I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trial
I know a lot of
lawyers
people don't believe such a problem
and your
exists, but
favorite
people make this waiver
cases.
avoid fallout.
Mr. Yeah, you're up.
Your Honor, Mike Gaddy, Assistant Public Defender. Concur with the prosecutor. We don't believe any conflict exists in any of these matters, but to the extent that any conflict does exist, we would certainly waive.
All right. And the court for its part also does not believe this conflict either. The Michigan court rules or the cases decided there under to the extent a conflict does exist, given the waivers, the court will accept the matter. Court does call the case of the People versus DeMarcus Thompson.
Evan R. Terry requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APA Rich McDuffie, Your Honor.
I know where you're from.
Trenton, Michigan, Your Honor.
Where?
Trenton,
Yeah, you're from Trenton.
Downriver.
Undergrad?
Michigan State, Your Honor.
And where are you in law school?
Wayne State, Your Honor.
Yeah, that's the thing that saved you. Now I remember. All right. Permission to practice is granted.
Evan R. Terry for the people, Your Honor.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Thompson, Your Honor.
I have before me a form that indicates that the defendant will be pleading guilty to the charge of false pretenses less than 293-day offense. Upon a successful plea to that charge, count one will be dismissed. There is also an agreement that he must pay $70 in restitution to the mobile on Rossville. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Is that a correct statement, counsel? All right. You want to swear him in? You want me to? Can I have him swear?
Do you solemnly swear affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes,
Go ahead and lower your hand, state your name, and then spell it out.
DeMarcus Jermaine Thompson, DeMarcus
Sir, this is court's understanding that you're going to plead guilty to the charge of false pretenses less than $200. That's a misdemeanor punishable by up to 2 years jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes,
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
yes,
Understanding all of that, you still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty,
Now, you understand that by pleading guilty, you will not have a trial of any kind.
yes,
You signed an advice of rights form, is that correct?
correct.
Any questions regarding those rights?
No,
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as other rights.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
I'm on probation.
Okay, were you on probation at the time of this offense?
Actually, my probation was just pending at that time. I was just about to get sentenced, so they really know about this.
It's our understanding that they knew about these charges when he was sentenced on the old charges. This is a 22 file, Judge.
Okay, so, but he's not on that same probation, is he?
I'm on the same probation.
All right, then I
About
do,
to
I understand they may know. I do have to advise you that your entry of a plea in this case could be a violation of that probation. Do you understand that?
Mm-hmm.
Yes.
So yes.
Yes,
And if it is considered a violation of probation, that court could sentence you to the maximum allowable under that other charge. You understand that?
uh-huh,
Yes.
yes,
And understanding that, you still wish to plead guilty?
yes,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no,
Anybody threaten you or coerce you in any way?
no,
You're doing this voluntarily,
yes,
of your own free will,
yes,
and because you believe that you are indeed guilty of this offense?
yes.
September 20th, 2021, at the location of 2120 Rossville Road, Ypsilanti Township, Washington County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
Gave them some money to get some lottery tickets.
You gave them money to get the lottery ticket,
Fake money.
fake money.
Yeah.
Okay, so you gave them counterfeit?
Uh-huh,
Yes?
yes,
You knew it was counterfeit?
yes,
All right. And I think that actually does it. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Defense is satisfied, Judge.
People are satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
July 17th at 10 a.m.
July 17, 2025, 10 a.m. before Judge Washington.
okay.
Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Simpson.
People, Your Honor.
Thank you.
Edward Lucas on behalf of Edward Johnson.
And what are we doing on this?
Your Honor, today the counts that were preliminary examination at this time, people are unable to proceed as to count 1, and would ask that count 2 be remanded to the district court.
Need to dismiss.
I would move to dismiss count 1.
People being unable to proceed on count 1. That charge is dismissed. I'll continue to defendant's not guilty plea as to count 2. Set this matter for pre-trial before Judge Barr on
June 18th.
And your, if
June 18th, 2025, 10 a.m. before Judge Barr.
I may address bond.
You may.
Your Honor, the serious felony is dismissed in this case. This is actually the second time this matter has been set for a preliminary exam, and complaining witness has failed to show twice. As another matter set with her tomorrow, that's set for final settlement. Based on the trajectory, I'm assuming she's not going to show tomorrow. I'm asking for a reduction in bond. He's got $100 bond in that case. It's actually at 1,010%. I'm asking for something similar to that. If it's a 1,010%.
That's your response.
Your Honor, at this time, I'm going to object to modification of bond. This case is set for guilty for the first exam, and then while he failed to appear, he did pick up bond violations with the same victim. So at this time, I'm going to object and I believe it's something that did get addressed in the pre-trial.
Your Honor, regarding that, I'm a part of that other matter. Mr. Johnson did turn himself in.
He had 2 bond violations.
The allegations are regarding a location over on MacArthur Boulevard. We would not be objecting to anything regarding a tether where he would not be able to go near MacArthur Boulevard.
What I'm indicating is that when he was released on this case, he had 2 bond violations. So he seemingly can't follow direction as to what he's supposed to do and not do. Motion for bond reduction denied. Bonds will continue.
Thank you, Your Honor.
That's all that's ready? Really? No, I'll wait. Court does call the case of the People versus William Phillips II.
Alexander, on behalf of the people.
Good to see you on this beautiful day, Your Honor. Robert Ellman with and on behalf of Mr. Phillips, who's approaching. Mr. Phillips, can you please state your name for the record? William Phillips.
Thank you.
Your Honor, today's the date and time set for preliminary examination. At this time, people are unable to proceed as account 1 of as account 2 be remanded.
You're moving to dismiss count 1.
Yes, Your Honor.
People being unable to proceed on count 1, that matter, that case, or that charge is dismissed. I'll continue to defend its not guilty plea as to count 2. Set this matter for pretrial before Judge Barr on June 18, 2025, 10 a.m.
Your Honor, may I address bond?
He's out.
Correct. There was
Okay.
a
Change.
there is a no contact order between the complaining witness and my client, which, as you know, previously she did provide me with a letter requesting contact. I know she shared the same sentiment with the victim's advocate. She's also due to have their child on the 15th of June, Your Honor. So I would be asking for a change in that bond so that he can have contact and also allow him to be present for the birth of his child.
And Your Honor, according to my notes, we haven't had any contact regarding her wanting consensual contact. The last contact we had with her, she confirmed it was her on the phone and then hung up and then didn't mention anything about contact. So we don't have any knowledge as to whether she want contact from our
They keep
office.
playing games friends every other day. Your Honor, they keep, it's like a, what? I know it's not. It's like a.
It's okay, just let it go. Because if he's not here to say anything, he's not gonna change his mind. You're just gonna dig yourself into hot water.
Anything else, Mr. Elman?
No, Your Honor. Thank you. I just, again, that you would like to be present for the birth of his child.
I understand that, but unless we've heard, and I understand the letter, but I have not heard from her, as I'm calling.
Okay.
So your motion for bond modification is denied. Bond will continue with its conditions.
And Your Honor, you said that the case is moving in front of Judge Barr. Did I hear that correctly?
Yes.
Okay, so any emergency bond motion would be in front of him at that time.
I don't know how he handles that, so go for it.
All right, thank you, Your Honor. Good to see you.
Thank you. What the killer won't do?
Are we ready on Mr. McKee?
Like,
Do we know LOR?
I'm Ms. Elwar, Your Honor. Mr. Feaster is going to speak to Ms. Elwar.
Okay. And I mean, do we have any that are ready to go?
We can get Mr. Brown in here. I think the Chalice Laughlin case is ready to go. Judge, I may be asking for an adjournment on Wednesday. I'll know as soon as,
On. Okay. On Wednesday. For your waivers, one is holding.
Yeah.
Okay.
I was not ready to discuss.
No, is she hearing it today?
She is.
Where is she?
I know she's here.
Anybody know where McDuffie is? Is she ready on her one case? Who's on the other side of that?
Going back and forth.
Which defendant is that?
Uh,
I'll be right back.
So maybe I should start yelling at people, then they'll be here. Lo, are you handling one? Why? Don't know? Is it Senda? She's not letting you.
She let me yesterday.
Yeah, but today's a new day. You want me to yell at her?
No.
Oh,
Good, Judge.
I'm great.
Enjoy your Memorial Day weekend.
I did. Had a blast.
Good. Did you call Smith, Judge?
I have not felt anything because nobody was here.
Do you want to?
Are we ready on Smith?
Your Honor, I believe we are, I may need, my understanding is that Mr. Feaster present as well.
I have not seen it.
He has 3 of the 4 cases, I believe.
Yes. I'll see if I can find this.
I think he's in fact dealing with his client with the Arabic interpreter.
Okay.
They're in the front row.
Yeah.
Okay, so I don't know where Mr. Feaster is. We need Mr. Feaster. Gilder, if you came back empty before that, no, you didn't come back empty. Yeah, thank you.
Well, if I was gonna come back empty-handed,
Okay, fair enough. Where's Feaster? Is that who has the other ones?
Feaster have both Feaster.
It's like herding squirrels. And I don't have a PD in here at all.
yeah. Judge, if you want Lindsay, you're gonna be asking for an adjournment.
Why?
It's Friday. It's my understanding the victim's not here, but the prosecutor's ready to proceed with the police officers. That being said, there's a lot of video I'd like to watch. My client's here. I just sat with them,
Why wasn't that done before that?
but asking for the adjournment.
The stuff that you're talking about is a review and discovery.
Right.
Why wasn't that done before it was set for PE?
Your Honor, I believe it was set by the public defender's office and then Mr. Kilwall was appointed last Friday.
I was appointed about 4 o'clock Friday. No detail for getting.
Fine. Thank you, Ms. Sender, for clearing that up. And Ms. Lowe had terrible things to say about you, but I defended you. I just want you to know. Court calls the case, People versus Alante Lindsay.
Good morning, I'm Rob J. Kill on behalf of Mr. Lindsay. What'd you say your name?
Ante Lindsay.
Judge, like I said, I was appointed Friday for what it's worth. There's a lot of discovery. My client wanted to proceed if the victim were here. She's not here, but it's my understanding they would continue with the police officer's testimony, which is fine. I understand that. So I want to review the rest of the discovery. I'm asking, can we get a 3-week adjournment? Is it possible? To the 24th?
2-week adjournment.
I'm in trial with Judge Kumpy.
My next date is July 22nd.
It's good by me. Is it okay?
Preliminary examination in this matter will be adjourned to July 22nd.
Thanks, Judge. We appreciate it.
2025. That's at 12 p.m. before me.
22nd at 12?
Yes, sir.
All right. Thanks, Judge. Appreciate your consideration.
Can somebody find a PD? There's like 50 billion of them. Mr. Brown? Mr. Brown? Can he handle?
I believe that LMR has left that.
We've been looking for Mr. Feaster, but I understand on that.
Gets around. He's one of those flint characters.
I am not.
I'm gonna tell him, Judge Simpson says, you get around.
This is, LOR is going to be a competency referral.
Yeah, what now? Otherwise gonna be,
A competency referral from my understanding, but we can't find Feaster.
do you already have the request or I can do it easily.
I don't have any, I have nothing. We were just told that.
Okay.
It's right here in the papers.
But I don't have any forms. No forms? I don't have any orders. On the other.
There he is.
I heard Judge Rutherford.
Yeah, he said that after you got through getting around, that you should come in.
Morning, Judge. I did agree with Mr. Brown.
My apologies.
Seem to get around. I don't
Well,
know what that means.
not that way.
No, I don't.
But I am here now, Judge. I apologize for my tardiness.
All right, I was ready on LOR. I don't have any orders. Are you ready on that?
I am, Judge. Yes.
All right. Court does call the case of the people versus Atif LOR.
Good morning, Your Honor. Mary Tanner, Assistant Prosecuting Attorney in that.
Ready, Judge. Torshell Feaster, First Assistant Public Defender on behalf of Mr. Elawar, and the interpreter is also here, Your Honor.
All right, may I have the interpreter sworn?
You raise your right hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Arabic and from Arabic into English in the matter now before the court, so help you God?
I do, Your Honor.
All right. Could you state your name, please, madam?
Hermine Dervartanyan, Arabic interpreter.
All right, thank you.
Thank you, Judge. I have spoken to the prosecutor,
أنا تكلمت مع النائب العام
and I am requesting an adjournment so that I can complete a competency and criminal responsibility form for Mr. Elawar.
وأطلب من المحكمة تأجيل موعد الجلسة لبين ما يتم إحالة إلى الحكيم مشان الطبيب مشان التقرير.
My understanding is that the prosecution is not objecting to an adjournment for those purposes.
حسب فهمي إنه النائب العام ما عنده مانع إنه نأجل الجلسة.
No objection, Your Honor. However,
لا مانع حضرة القاضي.
to continue the record, we had the victim here for exam last week.
لنتابع الموضوع إنه الضحية كانت موجودة الأسبوع الماضي هنا.
Excuse the witnesses from this week.
حضرة القاضي نعذر الضحية إنه ما يحضر المحكمة اليوم لهذه القضية.
With the purpose of adjournment being competency referral, I asked the witness to be excused for the next.
لبينما تتعاطى نتيجة التقرير.
Why wouldn't I just order the forensic evaluation now?
Please, I can do the paperwork later, Judge, if that's fine.
Okay, because
ليش؟ لأن لغاية الآن ما صار الأوراق عم يقول القاضي لتحت حالة.
I don't think you're asking for an adjournment to then do the competency. You want me to, okay.
Correct, Your Honor.
لأنه ما أعتقد إنه أنت عم تطلب تأجيل بس لبينما يصير تقرير القضية.
A forensic evaluation will be ordered. A competency hearing will be set for.
إذا تم أمر لإحالة عند طبيب نفساني.
September 9th,
سبتمبر 9
2025, 9 a.m.
موعد الجلسة القادمة بشهر 9 يوم 9 2025 الساعة 9 صباحا. Yeah, write it for me. He's asking me to write it.
Okay.
I am right now, Judge.
هلا سأكتب لك إياها بعد أعطيك.
All right, and there will be no bond will continue.
وما حيكون حاجة إلى حضور الشاهد.
Thank you.
Thank you,
Thank you, Your
Judge.
Honor. Thank you. لحضور الشاهد بخصوص القضية. لا، شاهد من الادعاء النائب العام.
Okay. The court does call the case people versus. They're not here. Court calls the case people versus James Sharp.
Andrew Simpson on behalf of the people.
Where'd Frykowski go? Ms. Mackey, how are you today?
I'm good, how are you?
Fantastic. Thank you for asking. What'd you say?
To be here in front of you, Your Honor.
A little bit more sincerity in that. It would have been nice, but thank you. Just secretary, we're waiting. Your attorney was guest here, which is why we had you brought out, but
James Fifelski on behalf of Mr. Sharp, who stands to my right.
Your Honor, today's date time set for preliminary examination. At this time, the people would move to dismiss this case without prejudice. It may be reauthorized down the line, but we're optimistic that won't need to happen.
No objection, Your Honor.
Case is dismissed. That's without prejudice.
Thank you very much, Your Honor.
Thank you. Thank you, Mr. I'll try to.
You can be my attorney.
Where'd he go? How many witnesses do you anticipate on the Smith matter?
She just abducted on the case.
Nope, I'm out.
I'll come back. You guys get it together.
All right.
Maybe seated. Court does call the case of the people versus Marcus Beal.
Good morning, Judge Christopher Quinn, appearing on behalf of Mr. Bill, who's present.
Your name, sir?
Marcus Bell.
All right.
In your understanding today, it's time set for preliminary examination. At this time, people are unable to proceed as counts 1 and 2, as at count 3 be reviewed.
Counsel, you're moving to dismiss counts 1 and 2.
That's correct, Judge.
People being unable to proceed on counts 1 and 2, those are dismissed. Continue the defendant's not guilty plea as to count 3. Set a pretrial in this matter for
June 18th at 10 a.m. with Judge Barr.
June 18, 2025, 10 a.m.
Okay, thank you.
Bond will continue. Thank you.
Thank you, Judge.
Thank you.
Just give me one. Call them. Let's just do it. Nobody lets me know. We're just gonna call them. No, don't even try it now. We couldn't even find you half. And now you're gonna stand up like you got something to do. No, I'm not talking to you. Just out there trying to get up, like just walk in the room, jump into the front of the line.
That's just it. Let you know. I misunderstood.
I said that about an hour ago.
Oh, I was a little.
I know, you weren't in the room. This has already started before me. This has already started before me.
I did, he did say it was going to be that.
What'd you say? Well, you know what? You go wait in the hall. We'll call you when we're ready for you.
Okay.
So hold it. They took somebody next door. How many people do they have back there? Thank you. Bye. Bye. Why are you guys still in here?
I'm going out this.
All right. We'll find you when we need you.
Let's get check him out.
All right. They just threw Easter out.
Yeah.
Okay.
I do have any coding more, which no one has given me updates on what's happening on this code anymore. If you would like. I'm sure you should have that now, Mr. Warren. And Mr. Warren.
My attorney next door.
Who isn't? No, okay, yeah, I got you. Court does call case people of the state of Michigan versus Kellis McLaughlin.
We're ready.
One Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. McLaughlin. State your name for the record.
Thank you. Date and time set for continuation of preliminary examination. Are you ready to proceed?
We're ready to proceed.
All right, let me call your first witness. Or your next
We'll
witness.
have to call a total of 2 witnesses. My officer in charge, Deputy Bouvet, asked to be present in court, and then Deputy Phillips.
All right, very good.
People will call Deputy Alex Phillips to the stand.
All right, please come forward. Please.
Someone swear from this one, so give you two.
J-O-E-X, Phillips, P-H-I-L-L-I-P-S.
You may inquire.
Thank you, Your Honor. And I know that we had kind of started, but I feel like I was only a handful of questions, and I'm basically just going to start from the top.
That's
okay. Because I couldn't tell you where I left off.
Okay.
Sir, how are you currently employed?
Currently employed with the Washington County Sheriff's Office.
And what is your responsibilities with the Washington County Sheriff's Office?
Road Patrol Washington,
And where are you assigned to road patrol?
Wayne Township.
Were you working in that capacity back on April the 15th of this year, 2025?
I was.
Directing your attention to around in the morning hours on that date, had you received any sort of dispatch regarding a potential stolen vehicle?
Yes.
Okay, and can you tell the court about the nature of that dispatch?
We were dispatched to the hotel located at 1275 South Huron Street for a report of a stolen vehicle. Deputy Bouvet and I made contact with the owner who advised that her gray Ford Explorer had been stolen sometime throughout the night.
Okay, and that hotel, do you recall like the brand?
I believe it was Marriott.
Okay. Based on this information that you received from the person who owned this vehicle and reported it stolen, what did you do next?
We entered the vehicle and NCIC is stolen. Deputy Bouvet was getting updates on the vehicle's location from the Ford Pass or the Ford application that I was tracking the vehicle.
Okay. And at some point, did you and Deputy Bouvet travel someplace in Ypsilanti Township to attempt to locate the stolen vehicle?
Yes.
Okay, where did you go?
The vehicle was showing in the area of Brook Tree Court and Woodsland in the Westfield neighborhood.
Okay, this is an area that you're familiar with?
Yes.
Okay. And you proceeded to this area of Brook Tree Court in the West Willow neighborhood in Ypsilanti Township?
Yes.
Okay. What, if anything, did you observe when you arrived in that location?
We entered into the cul-de-sac is on the east side of the road. When we entered in from the west side of the road, we observed a gray Ford Explorer faced on the north side of the road facing westbound, so we could not see the plate. Then I was in the passenger seat, Deputy Bouvet was driving, and then drove closer to the vehicle to confirm that was the stolen vehicle. Upon getting closer, we observed that the vehicle was occupied. At this point, we believed it was the stolen that was paying right in that area, so we initiated our overhead lights to initiate a felony stop.
Okay, thank you. And I'm just going to back you up a little bit. So you are the passenger in your vehicle?
Yes.
Okay. And I don't believe I asked you this. Are you and Deputy Bouvet in a marked or unmarked vehicle? Okay, this is a Ford Explorer?
Yes.
Okay. So you are, I guess, face to face with this suspected stolen vehicle. Is that fair to say?
Yes.
Okay, so you're looking at the front of that Explorer, hence you can't see the license plate.
Yes.
Objection. That's fair. I will rephrase that. Sustained. And you proceed in the area as you're attempting to verify the plate. You observe that the vehicle is occupied. Is that correct?
Yes.
Okay. How many people were in that vehicle?
Initially, we could see the driver and a passenger. Turning our overhead lights and exiting the vehicle. Two passengers exited the vehicle.
Okay. So as you're approaching, you can observe at least two people, a driver and a passenger in the vehicle. Okay. I presumably Deputy Bouvet is driving the marked police vehicle that you were in. Is that correct?
Yes.
Okay. So that vehicle is stopped. You activate your overhead lights. Approximately how far is your patrol vehicle from the suspected stolen vehicle?
I would say approximately 20 to 30 feet.
Okay. After you activate your overhead lights, stop your vehicle approximately 20 to 30 feet away from the suspected stolen vehicle, what do you do next?
We conducted essentially a modified felony stop. I holstered my service weapon and pointed it at the vehicle and began giving commands, which at this point, the two female passengers had exited the vehicle. So I started giving them commands to basically put their hands up.
Okay. And let me just back you up a little bit. When you took the initial report for the stolen Ford Explorer, was there a color given of this vehicle?
Correct.
Okay. And the vehicle that you had observed was consistent with that color? Was it also consistent with approximate year of the vehicle as well?
Yes.
What year was the vehicle that was reported stolen?
I do not recall, but I can check that.
Would that refresh your recollection? That's fine. Do you have your report with you? Okay. If you could just not read directly from it, refresh your memory, and then let me know when it's refreshed. It's refreshed. Thank you. And what year was the vehicle?
2024 Ford.
Okay. So you have your weapon drawn. You're giving verbal commands. Occupants of that vehicle. Are you physically now walking towards that vehicle?
At this point, I am walking towards and out of the patrol car.
Okay. The Ford Explorer, the suspected stolen Ford Explorer, is it parked on the side of the road?
It is.
Okay. And you said it's on the north side of the road?
Yes.
Okay. So as you exit your vehicle the patrol vehicle that you and Deputy Bouvet are occupying stop, are you up against the curb? Or are you more in the middle of the road?
We're more in the middle of the roadway.
Okay. So when you exit from the passenger side of the vehicle, is the Ford Explorer that you're interested in to your right or to your left? To your left. Okay. So is it fair to say that you kind of then have to walk in front of your patrol vehicle to walk in the direction of the stolen Ford Explorer, suspected stolen? Yeah. Okay. And is that what you were doing as you're giving commands to the occupants of the vehicle?
Yes.
Okay. Could you see at this time who the driver of that vehicle was?
Not that exact time.
Not at that exact. Okay. At some point, are you able to determine visually who the driver of that vehicle is?
Yes.
Okay. How far away were you from that vehicle when you're able to sufficiently see in the vehicle to make that identification?
10 to 15 feet.
Okay. So having the distance that you previously were? Okay. Is the driver of that vehicle in the courtroom here today?
Yes.
Can you identify an article of clothing that they're wearing?
He's wearing orange.
Orange what?
Jumpsuit.
Thank you. Your Honor, may the record reflect an in-court identification of the defendant?
Not objection, record shall so reflect.
Are you giving verbal commands to the driver of the vehicle to do anything at this point?
Yes.
What are you saying?
standard procedure is yell to roll out the window, turn the car off.
Did the driver, the defendant, appear to follow those commands in any way? Okay. As you are making these verbal commands, is your partner, Deputy Bouvet, also saying things to the vehicle, if you recall?
I don't know.
Okay, fair. You're making these commands. Is your weapon still drawn?
It is.
Do you get, how close are you able to get to the vehicle?
Maybe 20 or so feet away.
You said you had, in order to determine the identification, you were about 10 to 15 feet away.
Correct. That was, but I didn't, when I'm still giving commands, I hadn't identified the.
Okay, all right, sorry, and that's my fault then. When you're 10 to 15 feet away and you can see the driver of the vehicle, are you still giving verbal commands at that point?
Yes.
Okay. What happens next?
At first I noticed the parking lights of the vehicle were off, and then I saw the lights, running lights turn on, and then I observed the wheel turn and the vehicle start accelerating towards me.
Okay. While all this is happening, are you saying anything or doing anything?
I believe I was going to stop.
Okay. So the running lights turn on. Did that mean anything to you at that moment?
Means that the vehicle was no longer in parking, it was in drive or in theory reverse.
Okay. And now the wheels turn towards you and the vehicle starts driving towards you?
Yes.
What happened next?
At that point, when the vehicle is accelerating towards me, I start tending to move out of the way. I didn't have any cover or concealment to my left, so I was able to take about a step or two to the right. At that point, the vehicle's face on with me, approaching me at like a pretty high rate of speed. At that point, I was able to look through the windshield and identify the driver's chalice. Tried to step out of the way. I observed him turning the wheel towards me as we were accelerating, and the vehicle made contact with my left knee.
Hit your left knee? Okay. After the vehicle made contact with your left knee, what happened to you?
I spun around and hit the ground.
You had identified in your testimony the driver is Chalice, who we've identified as the defendant in court today. Is this an individual that you had ever previously had any sort of contact with?
Yes.
Okay. Approximately how many times, if you know?
At least 4 or 5. I had interaction with him maybe a week or two prior.
Okay. So the vehicle is driving towards you. You observe the defendant turn the wheel towards you. It made contact with your left knee. You spin and hit the ground. What's the next thing that you remember seeing?
Vehicle.
Okay. So it continued in basically in the direction that you had come in your patrol vehicle.
Yes.
Okay. And what is Deputy Bouvet, if anything, doing at this moment?
That moment, I'm not sure.
Okay. The vehicle takes off. What do you do next?
Run back to our patrol car while trying to radio. Dispatch.
Okay. You were hit by the vehicle, but you were still able to, you still had enough mobility to get yourself into your patrol vehicle. Is that fair to say?
Yes.
Okay. Did you ultimately suffer any sort of injuries from being struck by the vehicle?
I had some minor hand swelling.
No broken bones or anything? Okay. Do you get back into the passenger side of your patrol vehicle? Okay. And what does Deputy Bouvet do?
She gets the driver's side of the vehicle.
Okay. And what happens next?
Time to flip around, chase after the vehicle. That point, Deputy Rob was entering onto Woodland and observed the vehicle. Time to get stopped.
Did you observe that happening, or is this something you're learning over radio?
Learning over radio.
Okay. And Your Honor, I would not be offering it for the truth of the matter asserted.
I'll overrule the objection.
Do you and Deputy Bouvet then attempt to engage in a chase with this vehicle?
Yes, but we're pretty far behind.
Okay. At some point, do you encounter the vehicle again?
Yes.
And when and where did that happen?
The vehicle crashed out in the area of Ecorse Road in Van Buren Township. On arrival, Deputy Detective Rob was taking Chelsea into custody. That's what back.
Okay. So about how long in time was that? Did that from the time that you and Deputy Bouvet get in your car and take off to the time that you encounter Deputy Rob with the defendant in custody? How long is that time?
Approximately 10 or 15 minutes.
Okay. And while that 10 or 15 minutes is occurring, is it fair to say you are hearing things on the radio about this ongoing pursuit?
Yes.
Okay. What was the state of this Ford Explorer when you observed it in Van Buren Township?
It was crashed.
Okay.
Pretty substantially.
And you said that you observed the defendant on the scene there?
Yes.
Okay. And what was the condition of the defendant at that time?
Okay.
Was he in handcuffs? Was he sitting on the grass? Was he laying down?
He was handcuffed, being walked from near the gray Explorer to Deputy Rob's.
Okay. Hey, one moment, Your Honor. Yes. I have no further questions, Judge. Thank you.
All right, cross-examination.
Deputy Phillips, do you recall what time it was on April 15th when you encountered the gray Ford vehicle?
9:20.
And that's in the morning?
Yes.
Okay. So you testified that you had been receiving some sort of radio reports on the status of that vehicle?
I was being tracked by the Ford mobile application.
So were you tracking it or was someone else tracking it and giving you that information?
I believe the victim was giving information to Deputy Boway.
So the person who owned the vehicle was radioing or talking to Deputy Beauvais?
Yes,
How were they talking? By phone?
I believe so.
Okay, all right. And could you overhear the conversation?
No.
No, so you were just getting information from Deputy Beauvais that was communicated to her from the owner?
Yes.
Okay, and then you were being told, okay, this is where they're sending the vehicle?
Yes.
Okay, so at some point you make contact or you see the gray Ford Explorer yourself, is that right?
Yes.
Where is that you see it?
That was in front of 2341 Brook Creek Court.
Okay, and you said that's a cul-de-sac, is that correct? Yes. Now you see the vehicle, is it moving or is it parked? Okay, or stationary anyway. And Deputy Beauvais is driving. Deputy Beauvais pulls the vehicle that you're in to within what, 30 feet of the gray Ford Explorer?
Yes, sir.
Okay, could give or take, not holding you to that. Using the distances here, and you're in the passenger seat of your vehicle, I'm going to step back and you can tell me where the front of that gray Ford Explorer was when your vehicle stopped. Ready? Okay.
About there?
About here? Okay. And you're face to face with that vehicle, is that right?
More or less, yeah.
More or less. Maybe not directly head on, but at least face to face. Now, as you testified, it's a cul-de-sac, is that correct?
Yes.
And as you pull up, when you pull up, are your lights on already? No? Okay. So does your vehicle stop before you turn the lights on?
I don't know if the vehicle was still in motion or we put it in park over.
So let me ask you this. When your vehicle comes to a complete stop, that vehicle is also stationary, is that right?
Yes.
Are people getting out of that vehicle before or after your vehicle comes to a stop?
After the game stop, I believe.
After your vehicle comes to a stop, people begin getting out of the vehicle, the Ford Explorer, correct? Okay. Now, the full time that passes from the time your vehicle stops to the time that Ford Explorer hits you to move on, to go away from where you are, it's about 13 seconds. Is that fair?
Sounds about right.
About 13 seconds. The time from the time you get out of the vehicle and stand in the roadway to the time the vehicle hits you, that's probably about 6 seconds tops, isn't it?
I don't know the exact time.
You had a chance to see the vehicle video of the incident, right? Did you take the time to try to count out the seconds?
I do not.
Okay. Would 6 seconds be fair, or does that sound like an exaggeration?
That sounds fair.
Okay. So from the time you get out to the time that vehicle strikes you to move on, about 6 seconds pass. So when you got out of your vehicle and you're facing, I'm going to be where you are. You're going to be where the Ford Explorer is. You did not go around your vehicle and approach the passenger side of that vehicle, did you? What you did, got out of your vehicle and you moved into the roadway area. Is that right? There's a reason you did that.
To get that on the side.
Also, you were concerned that the vehicle might try to leave, right?
Possible.
Because as you said, people were getting out of the vehicle, right? All right. And one of the things when you got out is you raised your hand. Is that right?
I believe so.
Okay. And that was for a specific reason, right?
You don't know.
Stop the vehicle, right? You don't recall that? Okay. So you have a vehicle that you're concerned might flee. You're in the roadway. Now, let's talk about the roadway where you were. This is a cul-de-sac. The space between where your vehicle is and the space where the vehicle, the Ford Explorer, can get past you, how much space is that?
I'm not sure.
Okay. When you got into that space, was there any space where the vehicle could drive around you and past your vehicle without hitting your vehicle?
There may have been.
May have been, or there may not have been, right? Correct?
Yes.
Okay. All right. So the 6 seconds that you get out of your vehicle, you get there, you have your hand up. That vehicle then drives by and it strikes you on its way out, right? Okay. Does Mr. McLaughlin say anything to you on the way out? Okay. Does he even roll his window down? Does he make any threats to kill you? Does he say verbally, I'm going to kill you? You testified that the vehicle accelerates towards you, is that correct?
Yes.
Again, you are in the roadway between the area where they are and the area to get away from that cul-de-sac, is that right?
Yes.
So in accelerating towards you, they are also accelerating towards the roadway to get past you, is that right? Well, let's go back just a little bit. The information you had on the gray Ford Explorer was that it was stolen sometime during the night, is that right?
Yes.
Okay. Was the owner able to pinpoint a time when that vehicle was stolen?
I believe it was on the surveillance camera. There was a time.
Had you viewed the surveillance camera at the point before you had encountered the vehicle yourself?
Yes.
Okay. When did you review the surveillance camera?
The sergeant shift, when we were dispatched out there, probably 8:30 or so.
8:30 a.m.? Okay. And you said you had contact with the vehicle around 9 something? And I'm not trying to nail you to any time check. So in the surveillance vehicle, what time was the vehicle taken? Would it have been before your shift started?
Yes.
Okay. Do you have any idea if it was that same day or the night before?
I believe it was in the early morning. So
Okay, so it could have been, say, 2, 3 or something around there, right? It's a possibility that the vehicle would have been taken some hours before your shift. All right, thank you. I don't have any further questions for you, Deputy. Appreciate
You're
it.
right. Deputy Phillips, ultimately, did you have to have any sort of medical attention regarding the?
Yes, sir. I'll do the St. Joe's.
Hospital? Thank you. No.
All right, you may start. Thank you, sir.
Deputy, move into the stand.
Please come forward, be sworn.
Swear firm testimony about your future. State your name, spell it out. Go ahead.
Your first name?
Stopper.
Thank you. And how can you spell that?
Spelled it, please. Yes, thank you.
Last name.
Both.
K-A-T-H-E-R-I-N-E. You like boy, B-A-U, like Victor, A-I-S.
Thank you. Ma'am, how are you currently employed? How long have you worked with the sheriff's office?
About 6 months.
About 6 months. Okay. Were you working in that capacity back on April the 15th of this year, 2025? So you would have been only a few months on the job at that point. Okay. Were you assigned with a partner at that time?
Yes.
And who was that? Both of you were in a patrol vehicle together?
Yes.
And you were driving that vehicle? Okay. You were dispatched to the Marriott Hotel regarding a stolen vehicle?
Yes.
Tell me about what, if anything, you did when you arrived at the Marriott Hotel regarding that stolen vehicle.
Upon arrival, we spoke with the owner of the vehicle, who advised that her vehicle was taken sometime overnight. She explained it as the Gray Ford Explorer.
Okay. And was there some line of communication kept between you and this vehicle owner about the potential location of it based on this app that's associated with this Ford vehicle?
Yes, I advised her, she checked the forecast app that she had, she get bid locations, and I advised her if it moved, she got an update to contact dispatch.
Okay. And is that in fact what happened? Okay. Based on the information you received from the vehicle owner, you and Deputy Phillips went to the West Willow neighborhood looking for this vehicle. Is that fair to say?
Yes.
Okay. Describe for the court, and obviously we've already heard the testimony from Deputy Phillips, but describe for the court what you did as you drove your patrol vehicle when you first observed this gray Ford Explorer.
Before making it down the street, I advised that I was in the area, looking down side streets for the vehicle matching the description. I turned down with a Rotary Court, reserved the vehicle matching the description, 24 Gray Ford Explorer, from the street, and called out that we were out.
Okay. Did you activate any emergency equipment on your vehicle? Okay. What did you activate?
So, red lights.
Okay. Did you exit your vehicle?
Yes.
Okay. What did you do when you exited the vehicle?
I.
Okay. What commands were you giving?
So when we pulled up, I drew down the car, and 2 minutes I popped up, so I was telling them to let me see their hands, and they were walking towards us.
They were walking towards us? Thank you. The vehicle, are you walking kind of straight towards the vehicle at this point, based on where it is parked and where you park your patrol vehicle?
Yes.
Okay. And you still have your service weapon drawn
Yes, I was at the low ready.
at the low ready. Okay, so you're not pointing it straight out, but it's down kind of towards the ground. Thank you. You're continuing to walk towards the vehicle and give verbal commands?
As soon as the females had stepped out, I gave verbal commands and stopped walking as they were approaching.
Oh, okay. Is it fair to say at that point you were focused on the females? Okay. Did they walk towards you?
One got out from the passenger side and walked towards Deputy Phillips, and the one from the passenger front seat. I got down and walked.
Okay. After these two females exited the vehicle, could you see if there were any other occupants of this Ford Explorer? How many and where were they seated, if you remember?
One, they were in the driver's seat.
Okay. Were you able to get a visual of the individual who's in the driver's seat of this Ford Explorer? Okay. While this is happening, you're continuing to give commands to the individuals exiting the vehicle. Is that fair to say? Okay. What happens next?
The driver had thrown the lights came on when so the females had exited. The driver had turned the lights on and the vehicle then started to move.
Okay. What, if anything, are you saying while that's happening? Okay. You observed the vehicle. What did you observe the vehicle do after it started to move?
It started moving and started driving towards Deputy Phillips.
Okay. And what did you observe happen next?
Deputy Phillips was standing there, vehicle drove towards Deputy Phillips, tried to step out of the way, and step out.
Okay. I imagine this happened pretty quickly. Is that fair to say? Okay. During the time that you see the lights go on, the vehicle starts moving and it makes contact with Deputy Phillips. Do you have time to really do anything other than watch this happen? Okay. Do you attempt to use your radio in any way to ask for backup, help, anything like that?
Once we got out of the car.
Okay. So you observe the vehicle hit your partner, Deputy Phillips. Then what did you observe the vehicle do after that?
It continued to drive off.
Okay.
I
What did you do next?
asked my partner if he was okay, got out of the car and called out that he had just been hit by a car. And we attempted to drive around.
Okay, so then you are driving the vehicle and you're attempting to get involved in the chase of this Ford Explorer. Okay, and we heard from Deputy Phillips, but you eventually encounter the vehicle now involved in some sort of crash in Van Buren Township.
Yes.
And that was about 10, 15 minutes later. Okay. At that point, were you able to make any determinations regarding whether or not the vehicle ultimately found in Van Buren Township was the same vehicle that had been reported stolen from the Marriott that morning?
Yes.
Okay, and that was the same vehicle?
Yes.
Okay.
Over.
And you yourself, Deputy, did have contact with the owner, Miss Wilhelm, of that Ford Explorer? Okay. To your knowledge, had you given anyone else any permission to use that vehicle? I have no further questions, Judge. Thank you.
Cross-examination. Deputy Beauvais, when you were driving your police vehicle, is that right?
Yes.
Okay. When you pulled up, you were facing the vehicle that had been reported stolen, is that correct? Okay. And you weren't right up against the curb, were you? Okay. You were more towards the I don't want to say complete middle of the street, but away from the curb with enough space. And this cul-de-sac is this a 2-lane sort of street?
Yes, it didn't have any fees, but it.
Okay. And when your partner got out, he went to the right of your vehicle. Is that correct? And towards the front. Is that correct?
Not directly towards the front, but walk out.
That's sort of out. So if this is your vehicle, this path would be. For the record, I walked to the right and up towards the front. And then kind of go out. Motion. Do you recall if your partner had his hand up to stop the vehicle?
Once it got close enough to him, but not when he got out.
Okay. And do you have a good estimation of the time period from the time he got out of the vehicle, walked into the road, and the vehicle struck him? Was that about 6 seconds? Not sure. Would 6 seconds seem like a crazy amount? Would that seem untrue inherently? All right. So when you spoke with the owner of the vehicle, you said that you told her if it moved in the app to let you know.
Yes, if she continued to open an app and was getting up other locations, so that was action.
So did she show you the app initially?
Yes.
Was the vehicle stationary at that time? Okay. But you did say if it moved to let you know.
If she was continually checking the app and there was a different location.
So there was a location established? There was a location established when she showed you the app?
Yes.
Okay. And you don't have any idea whether it was stationary in that location or moving around in that location? Do you recall initially where that location was?
When she showed me the app?
Yes.
I believe it was in Wayne.
In Wayne. Okay. All right. Do you know if there were keys in the vehicle?
She did not have the keys while talking to her.
Okay. So I'm asking of your personal knowledge. Do you know if there were keys in the vehicle of your personal knowledge?
On her person?
No, in the vehicle.
In the vehicle?
Yes. Not sure. Don't know. So you don't know if Mr. McLaughlin had keys or not, do you? Okay. Well, thank you very much, Deputy. I don't have any further questions.
Can you redirect? No redirect, John.
All right, thank you. Thank you, Jeff.
Mr. Brown and I approached the bench very.
You may. Okay, record should reflect we had a bench conference in this case. What I'm going to do is there's a scheduling an emergent issue with the other deputy that needs to testify in this case. We'll see if he frees himself up from what activity he's involved in right now at some point. But what I'm going to do is I'm going to pass this matter and we'll call it up later.
And as soon as we relate it to bench, as soon as I have an update regarding the deputy's availability, I'll communicate with the court staff.
All right, very good. Right. Thank you. Yeah. Oh, they are. Oh.
Yeah, I got it.
That's these two. Can they bring them both in or no?
I'm sorry. What did you say?
Yeah, we might as well do one because I don't think they can be.
Not a problem.
Yeah. Court does call the case of People State of Michigan versus Gregory Callahan.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
And good morning, Your Honor. Reading on P44626, appearing on behalf of Mr. Gregory Callahan, is present. Standing to my right, sir, would you state your name for the judge, please?
Gregory Callahan. All right. This time set for preliminary examination.
Thank you, Your Honor. This is a continued examination on the Sheriff's Department file number 25-193 on a weapons charge and receiving and concealing a stolen motor vehicle. One of my necessary witnesses is away at a training that we were not aware of, Deputy Roy, and I spoke with Deputy Bechtel this morning, and we are not proceeding on these charges at this time.
All right.
Move for dismissal of the case, Your Honor.
All right. Well, I guess if you're not proceeding, are you nulling these cases?
I'm not objecting to it. We would just ask that any dismissal be without prejudice.
Yeah, okay. Then what I'll do is I'll dismiss it on the defendant's motion, and that's without prejudice.
Thank you.
Thank you, Your Honor.
Thank you. Ms. Young, can you approach on a separate matter while they get the next individual?
Yes, Your Honor.
Who's going up next?
Okay.
I don't know where Feaster is. Court does call the case of People versus Keith Finley.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Keith Finley.
Your name, sir?
Keith Finley.
Thank you. All right.
Your Honor, today is the time and date set for the continued preliminary exam on Washington County Sheriff's Report number 25-193, carrying a weapon with a lawful intent of receiving, concealing a stolen motor vehicle. Deputy Roy is at training. He's a necessary witness. And I did speak with Deputy Bechtel, who was here this morning, and we're not seeking a second adjournment, and we're not going to proceed on these charges at this time.
Move to dismiss, Judge.
All right. Court will grant the defendant's motion to dismiss this case. This case is dismissed without prejudice. Thank you.
Thank you, Judge. That's a weapons case, not a homicide.
Oh, there's more. No, because then I have to clear that. If she's there. Okay, where's McDuffie? Yes, William, he's not doing anything. Send him. Mike, you're preparing for, he's doing nothing. That's why you get interns. You just relax. See that Laura is all involved in doing what she's doing. She's gonna go, what?
But I also need pizza.
Oh, we need Feaster?
I'll go look for him.
Okay. Somehow or another, I'm gonna send all these people out and I'm not getting everybody back. Who's, he said, watch out. Okay, but I'm gonna check.
They should be.
I think they're both coming in, Judge. I think I got.
Today?
Can I approach on another matter?
Yes. Okay, on your cases, those being 1074-0152-5507, he is waiving, is that correct?
Yes, Judge, waiving up the city drug court.
Pardon?
Waiving up the city drug court, yes, Judge.
Mr. Smith, state your name.
Stephen Lawrence Smith.
And on those three cases, the court's understanding is you're waiving your right to a preliminary examination, is that correct?
Yes, Your Honor.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
You understand you will not have that hearing and on these three cases, and that you'll proceed to circuit court for further resolution.
Yes, sir.
On those three matters, people also waive the right. Preliminary examination having been waived, defendant is bound over on the one count in case ending in 0152, on one count with two following in the case ending in 1074, and is bound over to circuit court on the four counts as contained in the other matter, the case ending in 5507.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea. Pretrial in these matters will be set for
July 29th at 1:30 PM with Judge Combs.
July 29, 2025, 1:30, Judge Combs.
Thank you very much, Judge.
Bound on those matters. And as to his other matter, are we ready to proceed to prelim?
We are ready, Your Honor.
Oh, yes, people are ready as well, sorry.
May call you first witness.
Thank you, Your Honor. The people will call Officer Michael Sankey to the stand, please.
Sir, please come forward and be sworn. The 29th.
Yes. Some swear from.
Officer Michael Sankey, first name C-H, last name S-T-A-N.
You may inquire.
Thank you, Your Honor, and thank you so much, Officer, for coming today. I first want to start with just some background questions. How are you employed? How long have you been there?
About a year.
What kind of cases do you handle?
Wide range, drugs, violence, assaults, thefts.
Okay, so I want to get a little more specific now and turning your attention to August 17th of 2024. You were corresponding to an incident on that day. What area was that?
So the east side of Ann Arbor.
Okay, now without getting into what anyone said, can you just generally describe what the reason was for you going to that location?
Sure. I believe the dispatch call was welfare check on a man who was assaulted over a moped seat on.
Okay, so did you in fact respond to that location yourself? Okay, were you alone or with a partner? Okay, what did you find when you got there?
I found a man sitting on a moped, which is perpendicular to the road, stopped. He was slumped over the front. Exited by patrol vehicle and broken.
Okay, and as you approached, did you get any response from him?
Not initially. I walked to the front of the moped, he was moving heavily over the handlebars, and then he said something about, hi, how are you?
And what happened?
And I believe he gave a verbal response of, good, you, something like that.
Okay, and now you said he was slumped over a moped. What did this moped look like to you? What was there anything about it that struck you?
It was red. The kickstands were up, which struck me, both his feet planted on the ground.
Okay.
Over it. That has it in the back, I believe.
Okay, and as far as you, why did you mention that the kickstands you said were not up, were up?
I thought very unusual that he slumped over, he was down, so that he fell his feet planted on the ground.
Okay, I see. So did he take any action with that vehicle at any point in time?
He raised his body up, looked at me, Then began to slowly back away, and stop moving away from me. He continued to move away, and then he got off the moped and started running.
Okay, now, I understand you just said that he started running, but I want to back up just a bit from the point where you said he slumped over to starting to respond to you. Why did you need him to respond to you? What reason did you have for continuing to interact with him?
Well, I believe he was one of two things, either suffering for a medical emergency or some sort of drug or alcohol necessitating an investigation.
Okay, so what did you do after, as you stated, he began to run away?
I let him open on the ground, and then I get chased.
Okay, how are you dressed at this time?
Full patrol uniform.
Okay, so when you say you gave chase, is that on foot?
Yes, sir.
Okay, and what happened after that?
He ran for approximately 40, 50 yards or so, and then tripped. I was able to catch up to him where I tackled him to the ground, and then took him the handcuffs.
To be clear, I understand you're chasing him. Are you saying anything or asking him to do anything?
Yes, I believe I yelled at him to stop, and I then stopped the police, and he kept running.
Okay, and so at the point where he fell, what happened then?
I believe he fell on his stomach and I was on his back, and then was able to bring his hands behind his back where I placed him in cuffs.
Okay, and after you placed him in cuffs, what happened then?
I briefly searched his pockets, I believe. I located a knife, some other personal items. I then brought it back to my vehicle.
Okay, and I'm sorry, pardon me. Now, you originally said that you were concerned that he might be under the influence. Is there any other reason that you were concerned about him being under the influence in terms of that moped?
Oh, that he was operating it while under the influence?
Okay, what makes you think he was operating it?
Both his feet landed on the ground, like as I said, so it wasn't, you could say it wasn't parked, kickstand up where he immobile, so kickstand was down.
Okay. And was there anything, you said that you recovered a knife and you said personal items?
Yes.
Was there anything else that you took from him or found related to the moped itself? Any other items?
Those are the items that I found as a person. After placing them in my vehicle, I went back to the moped. I found a black bag, which I believe had been in the basket on the back of the moped. I looked inside that bag and I found numerous drugs, both illegal and prescription.
Okay. Now, at the point where you went to this bag that was on the moped, that is after that is after this individual was placed in the handcuffs, correct?
Yes.
So was he under arrest at that point?
Yes.
Okay. So what reason did you have for looking into what the bag had in it?
I believe we were taking him to jail.
Okay.
Incident to arrest.
Okay. You said incident to arrest. What incident to arrest?
I placed him under arrest for resisting, jumping, or fleeing from the other foot.
Okay.
And then I believe you were taking him to jail on that charge.
Okay. So you just said incident to arrest. Are you saying that you searched him incident to arrest?
Yes.
I just wanted to be clear about that. Okay. Understood. Now back to that moped. What did you find in the bag?
Numerous narcotics. Without referring to my report, I believe there was substances which appear to be methamphetamine, cocaine, heroin.
Okay.
Pills.
First of all, can you describe why you suspected these substances to be drugs? I understand you said pills. I'll get to that in a second. But what were you looking at?
Sure. I believe one of the first things I opened was a container which may have been some sort of representing some sort of skincare or hair product. Inside of that were several large shards, which I identified from my experience being methamphetamine. There were several little glass jars unlabeled, which contained quite powdery substances, which, based on my experience, is cocaine, and then the pills.
Okay. Now you say pills. What sort of container were the pills in?
I do not recall.
Okay.
But, exactly. I vague recollections of unmarked prescription bottles.
Oh, as in a prescription bottle that didn't have a label when you say unmarked?
Correct.
Okay.
Like I said,
Okay. I got you. Okay. So now I'm just saying you suspected that these were certain substances. How did you go about verifying that?
I use an online database called Pill ID. I just run the shape, color, and markings on the pills, and then it returns the substances.
Okay. And just generally, I know you've named quite a few different things you suspected, but what kind of amounts did you recover in terms of these substances? In your training and experience, how did those amounts appear to you?
The amounts appear to be far greater than what one would have for personal use.
Okay. And so in addition to the substances that you suspected to be narcotics at this point, are there any other items that you found of interest?
I believe he has some drug paraphernalia to include needles, aluminum foil, maybe a pipe or two.
Okay. And okay, now again, so going back, in terms of verifying what those substances actually were, what process did you follow?
I logged them into our police property room. From there, the detective's supposed to submit them for testing.
And did you get results back?
I believe we did.
Okay. Now, I'm sorry, I'm sorry, I'm jumping around a bit. I have to kind of go back and forth. So you submitted the substances that you found in the bag to the lab.
Yes, so.
Okay, but you started out also by saying that you suspected that this individual was potentially operating under the influence. What did you do to follow up on that concern?
I called HBA and paramedics come evaluate him after he continued to appear to be unresponsive or under the influence of social narcotics.
Okay, and what happened after that point?
HBA paramedics were out scene. They loaded him onto a stretcher. I believe they stated that.
Objection, hearsay.
Understood. Officer, remember that you can testify as to what you directly observed. And if the defendant in this case happens to say something, you can always testify to what he said. But aside from that, I have to have you limit your answers to what you personally observed, not what somebody else said, okay? So again, you can describe what happened. You said HBA loaded him into a stretcher. And what happened after that in terms of following up on the operating concerns?
I don't recall. The first step I took on that from.
Okay. So just to be clear, did you receive results back from what you submitted to the lab?
I believe so, without information.
Okay. Oh, understood. I just wanted to know, but you recall getting results back? Okay. And you mentioned that these amounts you stated were far greater than what you would expect to see for personal use, correct?
Yes.
Okay. So I want to follow up a bit on back to this moped situation. So you've described how it appeared, some unusual things about this individual's appearance with it. Was there any other information you got about the moped itself?
Yes, we ran it. Started it or stolen.
Okay. And did you have any information on who the individual was that the vehicle would belong to?
Yes, I believe it was Christopher.
Okay. So is that information, is that as far as you can see when you look into lien, is that the registered owner or who?
I believe it was the registered owner.
Okay, understood. Now, what information did you get in terms of who this individual was who was actually on the moped on this day?
He identified himself as Stephen Smith. They were applying for me a driver's license, so we have to match his photo to his image form.
Okay, so did you ask him his name directly?
I believe I did sometimes without success, and then other officers attempted to, and then they were able to get his name.
Okay. So did you take his name and do a search, or how did you connect that with anything else?
I did. I input the name Stephen Smith into Loom and started a driver's license with a photo match.
Okay, so the image that you came up with in your system matched the person that was before you.
Yes.
At that time. I see. And as far as you know, no one by the name of Stephen Smith had any affiliation with that vehicle. Okay. Do you recall, I'm sorry, I apologize if I asked you this already, what substances those lab results showed when they came back?
Only vaguely from looking at the report earlier this morning that I believe certain substances came back testing positive for methamphetamine and cocaine.
Okay. Your Honor, the people are approaching counsel first. Exhibit. Your Honor, unfortunately, the people tried several times to print this exhibit out in hard copy for the court. Unfortunately, the printer refused to do so. Can I display it on the screen?
What exhibit?
People's proposed exhibit number 1,
Which is?
the lab report from Michigan State Police.
I'll just state that although I did file a lab objection, I'll waive
Yes, you
that
did.
objection for purposes of preliminary exam.
Thank you. All right.
Officer, can you tell me what you're looking at here?
It appears to be a lab report from Michigan State Police.
I can scroll up a bit. Okay, thank you. And is this consistent with the report that you recall receiving in this case?
Yes.
Okay, and just to be very clear, this is from the substances you recovered from the backpack on the moped?
Yes.
Okay. These results are consistent with what you recall?
Yes.
Given that the people would move to admit people's proposed exhibit number 1, which is this laboratory report from Michigan State Police.
Any objection or what here?
No objection for purposes.
Exhibit 1 is admitted.
Thank you very much. So you described the individual that you saw and the steps that you took to identify him. One of my last questions is that individual in the courtroom today, sir?
Yes.
And can you please just describe him based on what he's wearing and where he's sitting?
Sitting at the defendant's table wearing a white t-shirt.
Thank you. Your Honor, may the record please reflect that the witness identified the defendant.
That objection record shall so reflect.
Thank you very much. And just to ensure, one more detail from very early in the questioning. So you mentioned that this incident took place on, I think, Fairlane and Provincial. What area is that in terms of city and county police?
That's in Ann Arbor, County of Washington.
Okay, thank you very much. I don't have any further questions at this time.
Cross-examination.
Thank you, Your Honor. Good morning, officer. If you don't hear one of my questions, let me know. I'll try to move through this relatively quickly. The first thing I want to ask you before I forget, you came up with information that the moped was stolen, correct? But you did not get any sort of admission or confession from Mr. Smith that he was aware that the moped was stolen. Isn't that correct? Did you gather any other evidence in your investigation to show that Mr. Smith knew the moped was stolen? Okay. Now, you first testified your reason for being in the area where Mr. Smith was, dispatch called out for a welfare check, right? Did you get any information about what anyone who may have called 911 or dispatch provided in terms of why a wellness check was being requested?
I believe they used the phrasing slumped over. I believe they had tried to give him a drink and he seemed slow, lethargic, and they just wanted him checked out.
Okay. So you had no reason to believe when you first appeared on scene with Mr. Smith on the moped that he was involved in any kind of criminal activity, correct?
I wouldn't necessarily say that.
Okay. Thought maybe he could be under the influence, but you never saw him drive the moped, right? You did not see him operate the moped even once you arrived at the side of the roadway, correct? The moped was not running when you made contact with him? It never turned on while he was on the moped? And other than moving back a few steps when you first made contact with him, verbal contact, when he's walking back on the moped, you never saw the moped move otherwise, correct?
Yes.
Nor did you get any information that somebody had seen him driving the moped around the neighborhood, right? When you are setting out to do a wellness check, what are you looking for?
The physical condition of the person. That's called.
Okay. Are you, when you made initial contact with Mr. Smith, did you notice any weapons on him? You noticed a pocket knife after you tackled him in his pocket, but that wasn't any legal knife, was it?
No.
Okay. When you're speaking to Mr. Smith, your testimony was something to the effect that either you or he said, "Hi, how are you? Fine, good," something like that. What do you remember about him actually saying to you?
I approached him. I asked him what I believed, and he legit said it was very normal. I believe he tried to say, "Good, you," as in how are you?
Okay, but he did say good. Did you have any reason to believe that he was a danger to other people in the area at that time? Did you believe he, at that point in time, was a danger to himself in the immediate sense of the term? That he could do something to harm himself while you're next to him?
No, not besides me, nothing was a drug and mental.
Okay. And sometime shortly after you make contact with him, he gets off the moped and begins to run. Is that correct? Okay. You had a body cam operational at that time, is that correct? And have you viewed that to just verify it is what you remember seeing that day? And that's been provided to the prosecutor's office, as far as you know? Okay. This is defense proposed exhibit A. I would seek admission of this and just want to ask the officer to view a few moments and then follow-up questions. Any objection?
Do you have a specific time?
Just starting at the beginning, the body cam. Approximately maybe 30, 40 seconds.
Okay.
Seek admission of exhibit A.
Objection.
Objection.
Exhibit A is admitted.
Thank you, Your Honor. I plugged in and we'll press go once we're up. Officer, is this you getting out of your vehicle?
Yes.
And this is the area that you've made initial contact with Mr. Smith? That looks like a neighborhood.
It is.
Pretty large yards. Doesn't look like there's any traffic around at the time. Okay.
No. Stop moving. Everyone got one run from it?
All right, I'm gonna stop it there, officer. Is it fair to say that in that short time frame you're talking to Mr. Smith, when he's on the moped, that you did not observe, let me ask it this way. Did you smell any alcohol on his breath? Did you see any drugs or drug paraphernalia on his person? Did you see any drugs or alcohol bottles, what have you, in the basket of the moped?
No.
Did you have any actual evidence other than your suspicion that he might have had a medical or under the influence of something, like you said before? Do you have any other evidence that would lead you to believe he actually had consumed alcohol or drugs?
I believe his behavior was unacceptable.
Okay. Have you ever dealt with people that have seizures?
Yeah.
Could it have been that his appearance was that of a person having a seizure of some sort?
Oh, no, no, professional. I think that's right.
Okay. So until HVA showed up, you would not be able to determine whether he actually could have been involved in a medical emergency. Same thing if he had low blood sugar. Are you familiar with diabetes? People that have low blood sugar, really low, can look like they're under the influence. But you had no information one way or the other whether or not this actually could have been some medical situation for Mr. Smith, right?
Right.
And that's why you in fact called HVA later, once you had him under arrest in the back of your patrol car, so they could check him out, correct? And ultimately, he was not arrested and taken back to the police station. He was taken to the U of M hospital. So you didn't actually book him in order to inventory his property, right?
Not ultimately. No, I'm not booking it. Property.
Not even after he went to the hospital.
Booking, no.
Yes. Okay. So in other words, you didn't have any of his property. If somebody is arrested and booked, then you inventory their property to make sure you have everything checked off, right?
No.
You don't do that when somebody's arrested?
And booked? No, not the and booked. No, just arrested? Yes.
Okay. You, at the time, you told us earlier in your testimony that you arrested Mr. Smith for resisting you as a police officer, correct?
Right.
But isn't it fair to say that you can't arrest someone for refusing to get medical assistance?
He prevented me from conducting an investigation into whether he was needing medical assistance or under the influence of drugs.
Okay, but if you see a gentleman who begins to walk away and then run, doesn't that tell you that he seems to be fine?
No, I would not say it seems fine.
Okay.
Straight after a short distance.
But he wasn't asking for your help, was he?
What's the point of this question?
To understand why he arrested Mr. Smith the way that he did. Just a handful more questions, Your Honor. So you arrest Mr. Smith, place him in the back of your patrol car, right? He did not resist you putting handcuffs on him, did he?
I don't believe I don't recall that he only went way off at the time.
Okay. And at no time prior to him being taken out by HVA did you conduct field sobriety tests? Or even interact with him to see if he smelled like alcohol or something?
Are you going down a road that just indicates the officer's conducting an investigation? Because first of all, the moped is illegally placed where it is because it's in the roadway perpendicular to the roadway. That's number one. But are you attempting to ask questions that go to whether or not the officer would have had the right to take that individual into custody or that they were resisting and obstructing?
Yes, Your Honor.
Go for it.
In situations, and again, I've asked you these questions, but you place Mr. Smith in the back of your patrol car. It sounds like you did not ask him any more questions or other than trying to get his name before he went off with HVA, correct? And when you searched his bag, which was near the moped, did you get his consent?
No.
Did you get a search warrant? Was it within his reaching distance once he's in the patrol car to get something out of it? And did you yourself have any reason to believe, strike that, from the outside of the bag, were you able to see anything that looked like controlled substance or paraphernalia or anything illegal?
No.
And unless somebody is a threat to himself or others, isn't it true you cannot take somebody in for a medical involuntary commitment unless they're a threat to themselves or others?
Sure.
And in this particular case, isn't it also true that you did not seek any sort of petition for him to be involuntarily committed, even after he was taken into custody and gone to the
What is the
hospital?
relevance of that?
Again, I think it goes to the legality of the arrest
You don't have-
and the search and seizure.
I get where you're trying to go. You didn't have to answer that question.
All right, let me ask a few more questions about did you field test any of these controlled substances?
No.
The lab report that was People's Exhibit 1 shows 1.88 grams of a combination of methamphetamine, cocaine, xylazine. Do you know where that particular, those substances came from in terms of a container, where they were found?
No, the detective in charge of that.
Okay. Did you find any logbooks or notebooks showing sales of anything in Mr. Smith's bag or on his person? Do you ever see him selling drugs to anybody? Do you have prior contact with him selling drugs? Did you find any scales inside of the bag?
I believe so. I could reference my report.
Sure, yeah, if you want to reference your report, just to be sure.
Yes, it was a small scale.
What kind of scale was it? Okay. Did you find any money inside the bag? Did you find money on his person? No further questions, Your Honor. Thank you.
Let me redirect.
Very briefly, Ron. Sir, very quickly, you mentioned in the beginning of your testimony that you were concerned that Mr. Smith could be operating under the influence. Is that accurate?
Yes.
Is that a crime as far as you know?
It is.
Okay. And just again, when you were fully uniformed, you asked him, he began running, you testified, and did not follow your commands when you asked him to stop, correct? Okay. You stated that you took him into custody, or handcuffed him rather. And what is the phrase you use about the search for the bag? What was the reason for it?
Incident to arrest.
Okay, can you just explain very quickly what that means?
Sure. Up until the point that HBA tells me that.
Why am I getting an explanation on search incident to arrest? I think I know what that is.
Your Honor, I know that you do. Unfortunately, I was trying to make it extremely brief. Counsel wanted to create a record. I just wanted to very quickly rebut it with about 2 lines.
Go ahead.
As I was saying, until the point that HBA arrives, tells me he should go to the hospital, not to jail. I conducted my investigation as if he was going to jail. I have no reason to believe that he was certainly going to go to the hospital. He was well enough to run away from me, approximately 50 yards. So I fully believe that he was going to be going to jail that day. So I began to inventory the property.
Understood. Thank you so much, sir. And I think my final question is, when you spoke earlier to the amount of the drugs that you found, you mentioned that it was not for personal use, correct?
I do not believe it was.
Okay. And in your training and experience, what is having an amount of drugs similar to what you observed in this case consistent with, as far as you know?
Distribution of narcotics.
Okay. I don't have any further questions. Thank you.
Real quick, officer. The positioning of that moped in the street parallel to the curb, that's improperly parked if it were parked. Is that correct?
Sort of hard to say as it is. I believe the turbo is not very well marked. Not residential area, but I would.
Well, but it's parallel. It's parallel in the road. It's not going with the roadway, correct?
I believe you need to be parked.
Pardon?
I believe you need to be parked parallel to the roadway.
Okay, thank you. Any questions based upon the court's question?
No, for the people.
No, questions? You may step down. Thank you. Any additional witnesses?
No, for the people.
Any witnesses for the defense?
No, Your Honor.
You have a motion.
Your Honor, the people are going to move for bind over on counts 1 through, let me rephrase it like this. Mr. Smith is currently charged with 5 felony counts. The people are moving for bind over on 4 of those 5. I do recognize that there is some discrepancy with count 4, which is controlled substance possession of analogs. The results shown on People's Admitted Exhibit number 1 shows that there are markings for that particular substance. However, the detection of it suggested something different that could not be confirmed. I do not contest that those results are basically inconclusive for our purposes, so I am not fighting for count 4 to be bound over. However, I do believe we have met our burden, particularly at a probable cause standard, to bind over on counts number 1, which is controlled substance delivery manufacture of cocaine less than 50 grams. Count 2, delivery manufacture of methamphetamine less than 50 grams. Stolen property, receiving and concealing a motor vehicle, as well as police officer resisting and obstructing. Officer Sankey testified, I believe credibly and reliably so, that he's an officer with AAPD, Ann Arbor Police Department, that this incident took place within the city of Ann Arbor, County of Washtenaw, that he eventually identified the individual who was on this moped as Mr. Stephen Smith by him, number one, responding to his own name and stating so, as well as him getting identification, matching him up in lean with that photo and identifying him here in court today. His reasons for stopping were obviously of a concern, given that he was passed out, slumped over the handlebars, as we saw in the video that counsel admitted, and that he clearly had concern about him being under the influence, as well as potentially operating as well, but certainly being under the influence of some sort of substance at that time. Given that, as soon as he began to investigate that, as a fully uniformed officer, clearly performing his duties, I think that Mr. Smith immediately running away from him by itself meets the standard and the elements for resisting and obstructing, given that he did not follow those commands, knew that that was a police officer, and immediately ran away. In terms of what happened after that point, he did a search incident to arrest, as he mentioned, as he did plan to take him into custody for the resisting and obstructing. That search included a bag on that moped, which held a large amount of substances suspected to be controlled substances, which were then proven to be so in terms of being cocaine and methamphetamine, as shown by People's Admitted Exhibit 1 for the Michigan State Police laboratory results. Finally, he ran a report on that moped that Mr. Smith was found on, saw that it showed up in lien as a vehicle that had indeed been reported stolen. And it was not obviously affiliated with Mr. Smith in any way. Given that, if people believe we have met our burden, we move for bind over on those 4 counts, counts 1, 2, 3, and 5, excluding counts 4.
Response.
Your Honor, as far as count 3, receiving, concealing stolen property, there's been no testimony or evidence presented that Mr. Smith knew or had reason to believe or know that the vehicle, the
But isn't that a factual question?
I think there has to be some probable cause. I don't think so. I think in a case like this, it may come up as stolen, but there has to be some evidence that Mr. Smith was aware of it at the very least. And there's nothing here presented in the testimony.
Okay, go ahead.
I think more importantly, and I think that cuts to the heart of 2 different issues, is that under the resisting and obstructing police officer, one key element is that the officer gave the defendant a lawful command, or was making a lawful arrest, or otherwise performing a lawful act. I don't see how the law or the Constitution allows a police officer to turn what is a wellness
You need
check.
to give me some case law, because I'm not gonna argue law by Fikowski. I sat there and watched your exhibit. Your exhibit clearly indicates the officers in the performance of his duty, tells him, hold on, hold on, hold on. It's grabbing the front of the bike. The officer is in the middle of the investigation and your client gets off the bike, takes off. So you show me a case that where that is not resisting and obstructing. I'd like to see it.
Your Honor, there's a case, the City of Troy versus Olinger, Michigan Supreme Court, 438 Mich 477. This is talking about using the community caretaker exception to enter a house. But this is essentially what a welfare check is. Community caretaker of a police officer. It's not going to investigate a crime.
It may have determined, Mr. Fikowski, you're jumping to conclusions. When the officer arrives there, he's not sure what he has. He's investigating a potential crime or some wellness. He doesn't know, as many officers don't. One of the things is during the course of that initial part of that investigation, he tells your client to stay put. He doesn't. He takes off.
But
he gave him a lawful command and he didn't follow it.
But I think the question comes up as to what authority does a police officer have to detain someone on what initially starts as a medical check, a wellness check, if the observation of the individual is that he gets up and is able to move around.
He doesn't know that though.
Unless he's a threat to somebody else.
You can argue that at trial. Go ahead with your argument. Well, because I'm going to tell you, you're just wrong.
For purposes of the record, I'm making that argument. I don't believe it's a lawful arrest. And I believe that the ultimate search of the bag that yielded the controlled substance was equally unlawful, since Mr. Smith was already in the back of the patrol car, could not reach the bag, and therefore it's not search incident to arrest under Gant, Arizona versus Gant. And lastly, the lab report tells us there's 1.88 grams of a combination of methamphetamine, cocaine, and xylazine. We have charges of possession with intent to deliver less than 50 on counts 1 and 2. And while the officer testified there were other drugs, we don't have any indications of amounts. So I would ask that this, and without something more, again, in terms of actual measurement substances that the officer found. He says there was a scale. He says it looks like more, that is more speculation than I think it is for probable cause for bind over on possession with intent to deliver. So I've made my request that the evidence should be suppressed and all the charges should actually be dismissed.
Anything else on that?
Extremely quickly, Your Honor. Not that this is going to be outcome determinative, but the case that counsel cited, City of Troy versus Olinger, concerned whether or not an officer may enter a home without a warrant when he believes that the person inside that home may be injured in terms of that community caretaking function. I don't think that case has anything remotely relevant to the facts presented here.
It's not applicable. Factually, it's not applicable. Court, having heard the testimony in the case, the court believes that the people have indeed sustained their burden of finding the defendant over. It may be a factual question as to the amount, but certainly you can argue that in circuit court. And so as to the drugs at issue in count 1 and 2, the court would find that the people have sustained their burden. It's also to count 3. He's sufficiently, if the issue is that he didn't have knowledge that the bike was stolen, then certainly counsel's free to argue that in circuit court, but that creates a factual issue. He's there present on a stolen motor vehicle, and then when questioned by the officer and held by the officer, takes off, but later on it's determined that that vehicle is stolen. I think that's sufficient enough evidence regarding the count 3, the receipt and concealment of stolen property, motor vehicle. As to count 5, the resisting and obstructing, I don't even understand, quite frankly, defense's argument, because the cold-hearted reality is the officer gets there, and what negates defendant's argument more than anything is their own exhibit, defendant A, or exhibit A, which clearly lays out what the officer is doing. The officer is investigating a circumstance, and as I indicated, like with many officers, they don't know exactly what they're running into or what they have in front of them, but he's noticing certain things. He has gave him a lawful command to remain where he was, not back that vehicle up, and then he proceeded to take off. Even when he took off and the officer then says, "Stop, police," that in and of itself can constitute the offense of a resisting and obstructing after he began to run, because that was indeed, in this court's opinion, also an additional lawful command. So for those reasons, and because anything else in dispute creates a factual dispute which needs to be resolved by the finder of fact, court would find that people have sustained their burden and would bind the defendant over to stand trial on counts 1, 2, 4, and 5.
Acknowledge receive the information and waive formal reading and stand mute as to counts 1, 2, 3, and 5.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be set for
July 29th at 1:30 p.m. with Judge Conley.
July 29, 2025, 1:30 before Judge Conley.
Thank you, Your Honor.
As to his bond, I have a violation report.
Yes, Your Honor. Mr.
Well, how come he hasn't reported to community corrections after his release from custody?
He had been in custody since about January of this year. And in speaking to Mr. Smith, he was only released from the Jackson County Jail about 2 weeks ago. He had bonded out on all these cases. When he was arraigned, I believe he was told, because he was also on probation in Monroe County, that
if he goes over there and tests right now, is he going to test clean?
He should be clean, Your Honor.
Go over and test. He needs to come back. You'll need to remain here, and then they'll set his bond. How many more we got?
That's 3 more for sure that we're holding. After comes around yet. Don't know.
Mr. Brown. But
Mr. Brown was the recall on Mr. King. I don't know what we're waiting on.
all right. I'll stay in brief recess. I'll come back, line him up, and that's all.
Maybe.
The People's State of Michigan versus Cody Moore.
And Alex Warren, Green on behalf of Mr. Moore. Just state your name, Mr. Moore.
Cody Moore.
Your Honor, today's date and time for preliminary examination. I had an opportunity to speak with Ms. McDuffie about Mr. Moore's case. We are respectfully requesting an adjournment to, I'll leave it in the court's discretion.
Why?
Your Honor, if I may, we have discussed the resolution in this case. I just need a couple of weeks to get the information that we need, and I believe I'll be able to send the knowledge to the court once I receive that in the next 3 weeks or so. For the court.
That's my understanding, Your Honor. We did attempt to contact Mr. Moore's parole agent. We need to follow up with her. We want to track Mr. Moore's progress over the next few weeks with respect to his drug testing.
Preliminary examination will be adjourned to June 17th, 2025 at 12 p.m.
You don't have to come back.
Continue.
Yes.
We have. They get any information yet on the availability?
No, I don't have any information on that.
Okay. Let's call the case, People versus Montel Gap. 2 cases. Mr. Brown, you didn't have any information yet on that? Okay. It's here? Okay. Oh, okay. So, well, let me try to do this one real quick and then I'll get that other one out of the way. But, well, the officer's here. Officer Rob's here.
No, he's not.
Oh, okay.
They're still on their calling. Still.
Okay. All right.
So if we want to recall that at this point,
I don't know.
I'll care about this around schedule.
I'm gonna do this one. Brown, he goes someplace and take a nap. He'll be back.
A lot of important meetings on there.
Is that right? All right, we're ready on Gatlin. Right.
Andrew Cho is appearing on behalf of the people, Your Honor.
Assistant Public Defender Ben Denos on behalf of Mr. Gatlin, who stands to my right. You state your name for the record, sir.
My name is Montel Gatlin.
Thank you. All right. 8 times that. Oh, yes, sir.
Hey, John, before we proceed, I would like to just take accountability for what I've done. I would like to plead guilty to.
Hold on.
No,
Mr. Gatlin. No, hold on a second. Okay, hold on. There's a process to it, okay? And so I hear what you're saying. You're not discounting it, but this would not be the place to do it, to do that right now. The question would be today, given what you kind of just said, as to whether or not you want to have this preliminary examination.
I would like to hold it and I would like the court to hear me out. That's it.
So you want to hold your preliminary examination?
Yes, I would like to hold.
Okay. Did you want to speak further with your counsel, given what you just said? And
I would not like to speak further with my counsel. I feel like my counsel is.
Is what?
Who he is.
Okay. All right. Okay, but I just want to make sure, and I'm doing this because I want to make sure things are fair for you, that you understand this isn't the point at which you would testify typically. You understand that?
Yes. Yes.
Okay, that's what I'm trying to. So here's the thing, Stan. You said something to me or said something out loud, stopped you, right?
Yes.
Then when I asked whether or not you wanted to have your preliminary examination, you then stated that you want to be heard.
Yes.
Okay. This proceeding, the preliminary examination, not saying it hasn't happened before, but this particular proceeding is not one where you would typically be testifying or saying things to the court.
I would love to if you would give me a chance.
Okay, well. Let me do this, okay? Because again, I'm not disputing anything that you may want to do. I just have to make sure that you're not doing something that may jeopardize your rights, okay? So what, just bear with me. I got to do my job, right? Okay, all right, so I'm hearing you. I think what I'm going to do is I'm going to pass the matter. I'm going to let you just briefly talk with your attorney and maybe the chief deputy of the public defender's office so that process-wise you understand it and understand what typically will happen at this proceeding and what won't happen, or what typically happens at this proceeding and also what typically does not happen. Okay? And I think you may be asking to do something that typically does not happen. And I just want you to be clear on that. Okay?
I'm just trying to plead to all.
Stop. Hold on. I hear you. If that's what you want to do, there's a way maybe to go about doing that. Okay.
I don't think they want to help me. I don't.
Well, hold on. Stan, I hear you. Okay. I'm trying to say it in a way. Here's what I'm gonna do. I'm gonna pass the matter. We'll find Mr. Brown. I'm gonna have you talk to Mr. Brown. All right, with the PD's office, just to make sure you're clear on everything, because I have to make sure that your rights are protected. Okay. So we're gonna do it that way. We're gonna do it that way. All right. That may mean you might come back up. We might be in the same boat, but I just have to make sure. Okay. Fair enough. Okay. So let's take him back.
Your Honor, real quick.
Okay.
Yeah, matter of fact.
Take him back. Council approach, please.
Sneak the CSC in.
Can you what?
We sneak into CSC.
It's a weird way of phrasing it, however, but Ms. Willingram's case? I would.
Would you like my time?
Yeah. And Ms. Willingbring and Mr. Pekowski. They know I'm waiting on the results.
Yes, and I do know he's over there, but I don't have salts.
So he's back.
Yes, but I don't.
So he's back, then I'm waiting on Rob, and I'm waiting on Gatlin. And then I basically got a clear area where I can do Taylor.
That's correct.
Okay. So I have to just give that time to debate. Court's gonna stand in brief recess. Which the officers involved in is a much more.
Yeah.
The one we're waiting. Well,
Correct.
oh, yeah. Where's my awesome? Oh, that's.
Yeah.
The one we're waiting. Well,
Correct. He's out, so he can go next.
And then he's out. That will clear me for Taylor.
Yep.
Okay, perfect. Let's call the case of People versus McLaughlin.
Andrew Tiller's hearing on behalf of the people.
We're ready. All right, although we were trying to avoid adjourning, my understanding is the circumstance which the officers involved in is a much more serious one than.
Right, and in fact, another deputy just left because they're requiring extra assistance. Just so the record's clear, that the deputy, Rob, who's involved in this case, is on the SWAT team. They are currently dispatched to some sort of barricaded gunman situation, and that situation has not cleared, so.
Did our best, we try anyway. So preliminary examination in this matter will be continued. Seventeenth at noon. Thank you. All right, thank you. Continue.
We should just stand at the table, right?
Pardon?
For Mr. Gatlin, should just stay.
Yeah, just stay over that way.
Okay.
Guess I shouldn't have said it like that. Court does call the cases of the People versus Montel Gatlin.
Assistant Public Defender Ben Denwood on behalf of Mr. Gatlin, who is entering the courtroom now. Mr. Gatlin, would you state your name for the record, please?
Montel Gatlin.
Your Honor, at this time, the defense will refer Mr. Gatlin to the Forensic Center for competency. On both cases, I will email the form to the clerk of the court later today.
All right, very good.
Mr. Simpson, what's going on here?
I'm sorry. Well, they've asked for a forensic evaluation. There's not. Just Gatlin, just hold on a minute. I can't. When it's requested by counsel, there's really not a lot I can do except to do the referral. Okay.
A forensics on what?
Likely for competency and criminal responsibility.
I'm just saying, what's that reason for trying to even do this just because I was trying to say something?
Well, no. I don't. Okay, so I'm not privy by design to all of the conversations that you have with counsel. You have conversations with counsel.
And still state what I wanted to state on record.
And
Now,
I'm gonna tell you something, Mr. Gatlin. That would, I just hold on a second. I don't know that would not only be a wise decision for you to come out and start stating stuff, but would also make me a bit concerned as to whether or not you understand the nature and objects of the proceedings. That is why I stopped it where I did the first time. And you're still in, and you're still in the same spot. And so your counsel has come out, they've asked for that. I'm gonna proceed to their request because they've made the request. So the conference hearing date for
September
September 9th, 2025, 9 a.m.
Mr.
Simpson, go ahead. Go ahead.
So you telling me they pushing my next court date all the way to September just because I wanted to come in here and take accountability?
No, that I don't know. I don't think you should look at it that way because the two aren't necessarily connected that way. They're not trying to push your case. The problem, Mr. Gatlin, is you're trying to do things that may not be in your best interest.
It's in my best interest.
No, it is not. That is why that is why I stopped the proceedings when I did. It was clear to me that what you were trying to do was not part of the process and may very well be against your interest to just
take accountability.
It's clear you don't understand how this works.
I'm being charged with charges, and I was clearly just trying to take accountability for my charges.
And accountability can happen, but it doesn't mean that you load yourself up with everything that's there, which is what you were trying to do. And hold on, no, hold on. After, when we had Mr. Brown up there and I talked to Mr. Brown and Mr. Childers, it's clear that there's an offer of some type.
I don't want to offer.
There's part of the problem. You're trying to, I'm done. Because you're not listening to it. You're just deciding you want to do something your way. I'm trying to explain to you why I'm doing it this way. I'm done. Bond continue.
That was September 5, year.
No. 9. Don't you dare leave this building without those orders for me to sign.
Yeah, I was gonna email them to a clerk.
Yeah, you better get them today. I want to sign off on them.
I'll go type it.
I need to have a peaceful summer. All right. And is everybody down here on Taylor on this? Oh, I got Smith still. Court does recall the case people versus Stephen Smith.
Again, James Fifelsky on behalf of Mr. Smith, please state your name.
Stephen Smith.
All right.
Your Honor, my client has a script for the Suboxone. He was actually receiving this in custody and they gave him a script when he left. So I can present that to the court.
Does he have a medical marijuana card?
He did, Your Honor. It's my understanding that it was taken into police property or something in one of these arrests. So I would certainly advise him not to consume marijuana.
He's not to be,
didn't have
I'm looking at the bond conditions. He's not supposed to be using marijuana at all.
Okay.
So
he just, as I told the court earlier, he just got out of custody after about 5.5 months. I think it was 2 weeks ago. He is doing group treatment at Catholic Charities, I believe up in Fenton, Howell. He certainly is aware of his dependence issues and treating those as best he can. I would just ask the court to continue him on bond.
You're gonna need a new order for him.
Okay.
All right.
Yeah, I've been on probation with the Department of Corrections, and they've allowed me to smoke marijuana with my
I'm
medical.
telling you what the order reads and what you can do is you can bring that up. I'm telling you, you cannot.
I understand now.
You can bring that to
I understand.
Judge Kunke's attention if you wish to do so.
I understand.
All right.
So no marijuana unless ordered by Judge Kunke or permitted by Judge Kunke. Got that?
Yep.
All right.
Thank you very much.
I'm preparing a new order consistent with the previous order so that he shouldn't have a problem testing.
Okay.
All right.
And he's gonna, I believe, go back to community corrections right now to get on board with testing.
Thank you.
Thank you, Judge.
All right, did you need time to get them down or?
All right, the First District Court, County, Washington, State, Michigan is now in session. All those having business before the court draw near. The Honorable Judge Simpson.
You may be seated. There you go.
I know, I'm very short. Sorry, Your Honor.
No, that wasn't.
Good morning, Your Honor. Ashley Lonnie.
Stars that.
Ashley Lonnie for the people. Your Honor, some people waive any conflict in this honorable court in the office of public defender. People do not believe that any conflict exists, may waive the avoidance called out.
Of course, if you had gotten behind the podium, I would have said, huh? Go ahead, Ms. Page.
This is the role of Your Honor, on behalf of the Public Defender's Office. Likewise, Your Honor, our office is not believe the conflict exists between this honorable court and our office, but no arising way such a conflict.
All right. Court for its part also does not believe that a conflict exists either in the Michigan court rules or the case decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Timothy Hess.
Senator Siller on behalf of Pittsfield Township.
Good morning, Your Honor. Christina Barrett, requesting permission to practice pursuant to Michigan Court Rule 8.120. Prosecuting Attorney Ashley Lonnie.
We didn't have enough stuff we had to say. Permission to practice.
Thank you, Your Honor. Christina Barrett, for the people.
For the record, I have no objection.
Generous.
I guess I should have asked.
Your Honor, is Mr. Hess, did Macomb County sign in?
The facility emailed this morning, Your Honor, they were unable to.
Well, then I'd ask for an adjournment, Your Honor. I was able to actually meet with him this time. I'm sorry?
Did you put your appearance on or just?
What?
No.
Oh, well,
You did not. I don't even know who you are.
there was a lot of chatter coming from that side, so
There's
it
a lot of
distracted me.
stuff being said.
Good. Slam. I would ask for an adjournment, I suppose. I did speak with him. We were ready to go today.
So you did speak with them, but.
I did.
That was the facility.
Yeah.
Did they say, where is he?
Macomb.
They just didn't let us know ahead of time. They didn't have space for it.
Got it. Okay. I'll adjourn it out. I'll adjourn it. Oh, we got 2 weeks and you're gonna give me a date.
June 18th.
All right. June 18th, 2025, 9 a.m. Has everybody met Miss Clemens? You haven't met her?
We did.
Did you?
Yes.
Did you like her?
Yeah.
Okay.
It's her birthday.
You're right. Happy birthday. I was supposed to remember that. I couldn't remember that from Monday.
Well.
Huh? Oh, is that what that said? I didn't know. I thought it was like a St. Patrick's Day thing. All right. June 18, 2025, 9 a.m.
Thank you, Your Honor.
We'll continue. Thank you. What's funny is all of that was said, like 80 people spoke, and Simon said nothing. But that may all end. Court does call the case People versus Ronald Altman.
Good morning, Your Honor. Don Smith on behalf of Mr. Altman, appearing by Zoom.
All right. Mr. Altman, can you state your name, please?
Ronald Altman.
Thank you. All right, what are we doing on this case?
Your Honor, this
Okay.
is set for a pretrial today. I'm sorry.
Go ahead. What are we doing?
This is set for a pretrial today. I emailed Ms. Londy back on April 25th with some additional evidence. I did not hear back from her, so I was expecting a conversation with her this morning.
This morning? She said she ain't got time for that. I mean, no, she didn't say that. I said that. Well, if you're by Zoom and she's here, I don't know how that conversation is going to happen.
Okay, I apologize. I appear in various places and oftentimes there is an ability to do that. And if there isn't, then I apologize. I guess at this point, we would ask that it be set for settlement and trial.
Jury final settlement conference will be set for, are you guys ready to go on Friday?
Yes, sir.
Yeah, no, Your Honor, I have a settlement conference and which will.
Why don't I do this so you guys can have a conversation? Did you want to say something?
Your Honor, Ms. Lottie may not be available. She was asking for August dates if possible.
Oh, jury
That's
final settlement conference, August 8th, 2025, 9 a.m. Jury selection, if necessary, be August 11th.
11 at 8:30.
August 11th, 2025 at 8:30. Both of those proceedings are in person. Bond with its conditions will continue. Thank you.
Thank you.
Court calls the case of the people versus Ali, is it Gary?
Ashley Lonnie for the people.
Joe Simon on behalf of defendant. What? Craig. Questionable. State your name.
My name is Ali Hayari, Your Honor.
Thank you.
Your Honor,
He has not been arraigned on that.
that's correct. Wait from reading stand mute, Your Honor.
Defendant having waived formal reading standing, court will enter a not guilty.
Your Honor, with regard to the pretrial, I've had a couple of discussions with Ms. Blondie asking to request the.
You actually talked to her?
I did.
Okay, sure.
Actually, asking to adjourn the pretrial just a couple of weeks.
Sorry. Pretrial in this matter will be adjourned June 18th, 2025, 9 a.m. As to bond.
People are requesting no contact with the named victim, Davion Priester.
Okay.
As well as all standard bond conditions. We are not making a monetary request related to our bond.
Okay.
And a no firearms condition, Your Honor.
Yes.
All that's acceptable, Your Honor. My client has no prior history, has no reason to ever be in contact with this person. They were strangers to one another.
All right. Bond will be set in the amount of a $10,000 personal recognizance bond. All other standard conditions, including no assaultive behavior or possession of any weapons or ammunition or anything fashioned to be a weapon. There is to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I will order no contact with Davion Priester in this matter. I think that's all I'm going to order at this time. You indicated they were strangers, so the location isn't an issue.
That's correct.
All right, very good. All right,
Thank you, Your Honor.
thank you.
Thank you, Your Honor. Wait for me out.
The court does call the case, people versus Jillian Sartori.
Ashley Lonnie for the people.
Your Honor, good morning. Joe Simon on behalf of Ms. Sartori. Jillian, when you get up here, state your name.
Jillian Sartori.
Morning. All right.
With respect to arraignment, Your Honor, waive formal reading and stand mute.
Waive formal reading, standing mute. The court will enter a not guilty plea.
Your Honor, I referenced with respect to the pretrial, I told Ms. Londy that my client is going to be undergoing some things that I want her to have time to complete before I approach her with a proposed resolution. What is I'm afraid this might hit my vacation. What is the next available pretrial after June 18th?
When's your vacation?
The 24th to the 1st.
And we have that day. No.
July 2nd and 9th.
July 2nd. Well,
is that
that's a Wednesday.
That's the day I come back.
Oh, okay. So you come back on that day. What's the next day? July 16th.
Thank you, Your Honor.
I'll adjourn the pretrial in this matter to July 16th, 2025 without objection at 9 a.m. As to bond.
Your Honor, the people's bond request in this case is no going to any target store in the state of Michigan. We are not making a monetary request for bond. We would also request standard bond conditions and standard supervision of community corrections.
Yeah, the only thing that I would oppose in that request is the community corrections. There's no real history here. That's not the issue that
prompted this. It's more of a mental health matter, which is what was alluding to. I didn't want to really state on the record as what I want my client to get completed.
Understood, but is there any indication of substances or anything along those lines?
And we approach.
Just to be clear, he's testing today, right? Unless you don't stop.
All right, record should reflect we've had a bench conference in this case. What I will do regarding bond is I'll set our bond at a $5,000 personal recognizance bond. And I'm going to order standard conditions, including no assault behavior or possession of any weapons or ammunition or anything fashioned to be a weapon. You understand that, ma'am?
You understand? Yeah.
I will also order there to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You are to not enter any Target store in the state of Michigan. I am going to order that you report to community corrections for drug testing. That'd be 1 time per week. Drug testing. All right. So I'd suggest before you leave the facility here today that you report over to community corrections, get that process started. All right.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. And just wait for me outside, okay?
No, I'm not talking to you. Just. $5 to $7 grand, Mr. Simon.
Your Honor, always willing to learn.
Oh, yeah. You have no idea what you're saying, me too.
And you know.
You know?
Oh, yeah.
All right.
I like learning new things too, Your Honor.
You know what, guys? I'm done. Court calls the case, People versus Aaron Salazar.
Christina Bergdorf for the people.
Good morning, Your Honor. David Shan on behalf of Aaron Salazar.
Good morning, sir. What's your name?
My name is Aaron Salazar.
Thank you.
Your Honor, we did have this set for a plea the last time we were here 2 weeks ago, and you felt it would be better for the defendant to have a translator, just to make sure that he understood everything that was going on. The goal is still the same. He would enter a plea of operating while intoxicated, and the more serious charge of operating with a high BAC would be dismissed.
All right. And he does not need a translator, or
we were going to line one up, but if you want to start and see how this goes.
All right. I don't mind trying to take the plea. Is your native language Spanish?
Yeah.
Okay. So if it doesn't go like we can try to order then one up.
Okay.
But we'll try it this way. All right. May I have him sworn?
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, go ahead and lower your hand. Say and spell your name out.
My name is Aaron Salazar.
Can you spell it?
Aaron Salazer.
All right. Let me just do this because my file here is a mess. And he's going to plead to the charge of operating while intoxicated.
Correct.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes.
I guess we'll wait. Yes, sir. Okay. You understand all of those maximum penalties, sir?
Yes, I am.
All right. Understanding that, how do you wish to plead?
Guilty.
You want to plead guilty or not guilty to?
I am guilty.
Pardon?
I am guilty.
Guilty?
Yeah.
All right. Now you understand that by pleading guilty, you will not have a trial of any kind.
No trial.
Not right.
All right. You signed an advice of rights form. Is that correct?
Yes.
Correct. Yes.
All right. Do you have any questions regarding any of those rights?
No, I don't have question.
All right. On the podium, I need you to look at paragraph 5. Now, those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Understand all that? We went through this.
Yes, I understand.
All right. You understand you're giving up those rights.
Yes.
All right. You understand that you're giving up your right to appeal of right. What that means is that if you don't like the fact that you have a conviction or your sentence, you have to ask permission of the higher court to hear your appeal or your complaint.
You're giving that up. Yes, we want to do that.
Yes.
All right. Are you on probation or parole? Let me ask it this way. Are you under the jurisdiction of any other court?
No.
This is his first interaction ever.
Ever. Okay. And so you're not on parole. You've never been to prison for longer than a year.
No, never.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
Nobody's promised you anything except the plea deal.
Yeah, yeah.
So nobody's promised you anything except this plea deal.
Oh, yeah. Yes.
Is that correct? Has anybody threatened you or coerced you or forced you in any way to enter this plea?
But he threatened you to get you to enter this plea, to threaten to harm you. Nobody's threatening you to get
No,
you.
no, but
Okay. You're doing this voluntarily and of your own free will?
yes, I did.
Okay. And you're also doing it because you believe that you're guilty of this offense?
Yeah.
Okay. October 21st, 2024, at Oak Valley Drive near Target in Pittsfield Township, Washtenaw County, state of Michigan, were you driving a car?
Yes, I was.
Okay. Before you drove the car, had you drank alcohol?
Before?
Yeah, were you drinking prior to driving?
Why?
Were you drinking prior to driving, drinking alcohol prior to driving?
Yes, I was.
Okay. Were you stopped by the police or was there an accident?
There was an
That
accident.
was an accident.
Okay, what happened?
I was having problems with my wife, so I made a wrong decision. I was drinking, and I was go home, and what happened? The accident.
What did you hit?
A signal for the pedestrian.
All right.
It's a crosswalk sign on Oak Valley Drive there.
Did the police arrive?
Did the police come?
Yeah.
Okay. Were you arrested?
Yes, I was.
Okay. Were you taken to the hospital for a blood draw?
Yeah.
Okay. Do you know the results of that blood draw?
It's 0.176, Your Honor.
Okay. Do you have any reason to think those blood test results are wrong?
Did you think they were wrong that you were?
No, I don't think so.
All right. All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor, people are satisfied.
And defense is satisfied, Your Honor.
All right. Court will accept the defendant's plea of guilty. Count 2, DOWI. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
June 25th at Friday.
June 25th, 2025, 9. Bond with its conditions will continue.
I think that also may be a vacation. Your Honor, can I get the next date after June 25th?
Okay.
July.
I would really like to stay married.
You know, July,
I outkicked my coverage, so I don't want to lose it.
July 9th, 2025, 9 a.m.
Thank you, Ron.
All right, thank you. JP. Court calls the case, People versus Mohammed Al-Del Haber.
Your Honor, good morning. I'm Mohammed Abdul Jabbar.
Okay, you don't have an attorney on this case?
Negative, sir.
All right. Where are the rest of your pants?
Oh, sorry, I'm going to work
Next
right
time
after
you
this.
show up,
Yes, sir.
make sure you have all of the pants.
Absolutely.
All right. Okay. Why is this on my docket? The last thing I have on here is you warranted. Did you turn yourself in, sir?
Yes, sir.
All right. And then you went before the magistrate.
No, I came to the court and I got a letter in the mail saying to appear today. I got pulled over. The cop told me I had a warrant, so I came the next day to address it.
He filed a warrant. Okay, got it. Okay, so you're here on a pre-trial.
Yes, sir.
All right, and it's a driving while license suspended.
Yes, sir. And I did have a brief monologue with Miss Landy, and I think we came to terms about the prosecutor.
Yes, Your Honor, we had a conversation with him before.
Okay.
We just like to ask if he has a valid license. License is valid.
It's currently valid but restricted, Your Honor.
Restricted, yeah.
Yes, sir.
Yeah, he does have a valid license, but it is restricted.
Up until August of this year, Your Honor. August 27th.
Hang on a second. Let me just check it. Make sure. What's the restriction for?
Just no moving violations. That's the only restriction. And I currently don't have any. So.
Hold on a second. Oh, I see. Yeah. When I'm looking. Yeah, okay. His only restrictions, if you don't see it, are that he can't drive a vehicle requiring a commercial driver's license and no moving violations. But that's the only restriction.
Okay, okay. Your Honor, given that his license is valid, people move to dismiss.
But he did that all by himself?
Sorry?
He did that all by himself?
Yes, sir, I did.
After coming, he did that all by himself and only had half his pants. All right.
I'll tell you what, like I do watch a lot of your videos, so I was educated before I came in here, definitely.
All right. This case is dismissed. You have a great day.
I appreciate it, Your Honor. Thank you.
Take care. Court calls the case, People versus Abdallah Bader.
Ashley Lonnie, for people.
It's an arraignment pretrial without counsel. All right. I'll issue an order to show cause on this case.
For your show cause, Your Honor?
Yes.
Thank you.
Court calls case, People versus Candace Brooks.
Good morning, this is Civil Defendant Warren Attorney on behalf of Ms. Brooks, who should be on Zoom. Oh, no.
Candace Brooks. Well, Miss Perroni.
Well, Your Honor, we had a resolution today. I was speaking with her and yesterday, and she was intending on being here. I don't have an explanation for the failure to appear, unfortunately.
The individual whose phone number ends in 999, could you identify yourself, please?
Jared Robertson.
Not her.
For the record, I don't.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 5,000. Give it 10% per.
Jared Robertson.
I got you. We don't have your case yet. That warrant on this case will issue immediately. Court does call the case People versus Ashton Ebler.
Ashley Lonnie for the people.
Ashton Ebler.
Thank you.
Sorry, Your Honor. Assistant Public Defender Natalie Tate with and on behalf of Mr. Ebler, who is present via Zoom and has already stated his name. Your Honor, I'm respectfully requesting one last adjournment. The people did provide me with an offer yesterday afternoon that I do need to discuss with the client. There is an also other potential resolution that I still need to discuss with the people as well.
That's correct, Your Honor. There's a few moving parts here. We're looking for a little bit more time, please.
June 18th, 2025, 9 a.m.
Thank you, Your Honor.
Uncontinued. Thank you, sir.
Thank you.
Court calls case People versus Ashley Garcia.
Ashley Lonnie for the people. Agreement for each other.
Ashley Garcia. No response. I'll issue an order to show cause. Court calls the cases of the People versus Larry Geekaman.
Ashley Lonnie for the people.
Defender Laura Perry, on behalf of Mr. Michael.
All three cases.
Good morning, Your Honor. Larry Geikema.
There he is. Okay, thank you. All right, what do we do?
Have come to a resolution. Mr. Hekima is going to plead to no operator's license on this person as an added count 2 on the case ending in 1747.
No ops.
Yes, Your Honor.
And in exchange, count 1 on that case will be dismissed, as well as the cases ending in 1748 and 146.
That is correct. The no ops being a $100 fine contrary to 57311. That's a complete recitation of the plea agreement, Your Honor.
All right. Sir, can you please raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
State your name again for the record, please.
Larry Geikema.
All right. You can put your hand down. I think that was your left hand, but that's okay.
Oh, you're
right. What did you say?
I said you are correct.
Yeah, I just gotta let it go, but all right. Sir, it is this court's understanding that you're gonna plead guilty to the charge of no valid operator's license on person. That is a misdemeanor, punishable by up to 90 days in jail and a $100 fine plus court costs. You understand that?
Yes, Your Honor.
And understanding that, do you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you.
Sorry, Your Honor, he did sign an advice of rights form.
Is that correct, sir?
Yes, Your Honor.
All right, left hand and you're late on getting the information.
Well, I had it.
Oh, it's okay.
It's
Okay.
just, I didn't want to
Keep hearing
interrupt you because you were so eloquently explaining his rights, so.
Wow. Okay, sir, you signed an advice of rights form?
I did, Your Honor.
All right, you have any questions regarding any of those rights?
No questions.
All right, you understand that you're giving up all the rights contained on that form, including the rights contained in paragraph 5, your trial rights.
I understand.
You also understand you're giving up your right to appeal of right?
I understand.
All right, are you on probation or parole?
No probation or parole.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Absolutely.
And because you believe that you're guilty of this offense?
Yes, sir.
August 13, 2018. Location of westbound I-94 in Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
I was.
Were you stopped by the police?
Yes, sir.
Did they ask you for a driver's license?
Yes, sir.
Were you unable to give them a valid license?
That is correct, Your Honor.
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Satisfied, Your Honor.
All right, court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to say before I impose sentence?
Nothing. I just have one question about fines and costs. Before this court date, I had paid 2 of those tickets, $100 each in full, and put $80 towards another ticket. Will this money go towards my costs and fines now?
You paid.
So I looked up the cases in JAS, and that does reflect that he's paid about $280. On May 21st, he didn't appear before Your Honor, and the court adjourned it to today. He paid some money, I think A, to display to the court that he was serious about resolving the cases, and B, to get ahead on some fines and costs.
Hold on a second.
I do show that back in 2021, but I did see a payment of $100 on 5/21 as well, unless I might be mistaken, and maybe that
5/21 of
this year.
you see a
So I see an $80 payment in the case of 1748.
that was on a different. I see what I think what he might be asking is he paid money on the cases that have been dismissed as part of this.
Correct.
That's what he's asking, but he hasn't paid on this case. And I don't,
There's also a couple civil infractions that are floating around in JIS, so I'm not sure if
this is 1748 that he paid on. I don't,
Yeah, he paid $80 here and $100 on the 1464 one. He should not have been able to receive those payments because they are pending cases.
okay.
So he,
Okay, I got it.
Yeah.
So he's paid a total of $180.
that's what I see.
I do.
180.
Pardon?
It should be 280. I paid 2 separate $100 payments and one $80 payment.
On 1747 on the financial screen, I see $100 paid on 5/21 using the credit card. It says warrant.
Okay. Right, because he had to clear his 2 warrants. So that one's out. On the other cases, he's paid it. On the other files, he's paid what? You said 180.
I see $80 on case ending 1748. That was on 5/21.
And what was,
That went towards state things.
really?
Yeah,
$80? Okay.
$80.
All right.
And then the 2019 case, he paid $100, but again, that went towards warrant fees.
So the 100 on the one went to warrant fees to clear the warrants.
So $80 is what I see.
But they weren't in.
They were in, I know the 1747 was in warrant status.
But they weren't in warrant status at this last court date
Right.
because he was set before for a pretrial before Your Honor.
His last court date was, well, I have May 12th, but it may have been the 21st. Alan was having an issue.
Yeah, May 21st, and he did not appear, but because he had a valid license, Your Honor adjourned it to this day.
And continued his bond, but when did he pay?
It's, sorry, I don't know.
No, go ahead.
It says the warrant was canceled on 4/11, bench warrant requested granted by the judge, warrant canceled, previous bond reinstated. So I don't know if Because those warrants existed, those,
So here's the thing. It's gonna be a $50 charge when the warrant is issued.
right.
So I'm looking at the card stock, and the court issued 2 warrants against him.
Yeah.
One on October 31st of 2018. And then another warrant on June 16th, 2021.
Yes.
And so those fees were there. And even though he might have cleared it, he would still owe the warrant.
And now that they're dismissed,
Well, I'm talking on the case that,
the one that he pled on.
the one that he pled on, I'm saying. He would still theoretically, even though those cases were dismissed, still owe the warrant fees.
Okay.
All right, so on the $200 payments that he made, right? And normally we would waive those. So I hear what, I think, right, that's what I would have done. But they were paid as warrant fees, not payments. Okay, that's on that case. On the 1748, which I still don't understand how this happened.
I think it was a clear error when they received it because.
You think?
There are, on that case as well, $100 in warrant fees assessed that are not paid.
Okay.
We don't usually have people paying their fees in advance, so this is kind of throwing us for a loop.
Yeah, I'm shocked. Other than the left hand, I kind of like him. He paid everything.
To be frank, Your Honor, we felt really bad that we missed the 21st, so we wanted to.
I know, I get it. Yeah, and I'm just trying to figure out a way to. Can I take, here's what I want to do, and I don't know if I can. I want to take the 2 warrant fees. I don't know what to do with the $80 because that's weird, and I don't want to mess with it. I want to take the warrant fees on this case and the warrant fees on the other case, apply them to his financing costs, and close this case out.
The $200, close it out and waive any balance over the 200.
He's not gonna have a balance over to it, because I'm gonna assess fines and costs 200, but I need that money to go toward these fines and costs.
That's fine. Give me I'll take the files when you're done.
Well, okay. All right. Now that we've gone through that. Sir, anything else you want to say before I impose sentence? Now that you caused all this problem?
No, no, Your Honor. Thank you. I'm sorry about that.
No, it's fine. It's the sentence of the court. I'll suspend 90 days in jail. I'll order fines and costs of $200. The warrant fees, which were paid on 1747, what's the other case number? I gave it up already.
1464.
And on case 1464, those warrant fees will be applied to the $200 because he's paid 200 there, and then we're good. Okay?
Okay.
You're all set,
Thank
sir.
you.
Thank you. Take care of yourself.
You as well.
All right.
Bye.
Okay, I'm gonna step off and then I'll come back and start my 10 o'clock. Court stands in recess.
All right.
His paper is here. Oh, he's.
Oh, here it is.
Actually, Lonnie, for the people in the Artuso matter.
Court does call the case People versus Artuso. All 3 cases.
Assistant Public Defender Natalie Pate with on behalf of Mr. Artuso and the cases ending in 1656 and 1657.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso as the remaining matter set for pretrial, Judge.
Okay. Your name, sir?
Rick Artuso.
Thank you. All right, what are we doing?
Your defendant is set on Tuesday for a preliminary exam in a different case that involves the same victim as the larceny case in this case. So the people and defense are requesting to adjourn this matter to allow the preliminary examination to go first.
All right, and that's on your case.
That's correct, Your Honor. I represent him on on the other matters as well, but that's correct.
Okay. So that one I will adjourn to June 18th,
Yes.
2025, 9 a.m. Bond will continue in that matter.
Thank you.
All right.
And I would also request an adjournment as to these two matters, Your Honor. This is a ticket case that I've been in discussions with the people about, as well as my client. I don't know if we'd be able to resolve it by the 18th. There's a world in which we could, but I would not be opposed to a later date.
That's correct, Your Honor, and Ms. Payton and I have been trying to work on to, this may be one case that ended up in, just maybe one, two cases, and maybe the same ticket just got duplicated somehow, so we're working on that as well.
Oh, where he was written for two things on the same ticket.
Where it was written one ticket, or it was entered twice, or two things on the same ticket. I can't recall off the top of my head right now, but I do believe it's one of this.
I believe that it was a duplicate case. I think it was just entered twice. But
No, you mean 1657 and 1656?
yes,
No, you don't have a copy of the ticket.
we do. And we have the same discovery that we've been provided by.
So the ticket was written for two charges.
Correct.
And they're just in two cases. So
They're both, well, the discovery I have is they're both charged twice on each case. But regardless, I have been discussing.
so you have it, so I don't, what do you have? Hold on.
I have that both cases are charged for DWLS and operating unregistered vehicle.
I don't know where you're picking that up from. When I'm looking at the JAS printout, the card stock in the case and everything else, I have 1656 as a DWLS, which is the first charge on that ticket.
Mm-hmm.
And then 1657 is the no insurance.
Oh, I see, thank you.
Okay, thank you. That's probably correct.
So
yeah.
they're not duplicated. They just come off of the same ticket.
Thank you, Your Honor. Very helpful.
So are you looking to try to have him potentially in a position of clearing his, I mean, how much time?
Potentially, my client thought he did have a valid license. I was able to run his driving record on my end. I show that it's currently suspended.
He's right.
Oh,
Yeah, he has a valid license.
that's great.
Yeah. So let me just make sure when that was run. As we received our response, SOS response on May 28th, just a few days ago.
Okay,
And his NCL he's valid.
perfect.
He's got a
He
valid.
was right. I believed him. I must have run it incorrectly or entered the wrong date of birth.
Okay. So he's got a valid license. I don't know if
Awesome.
that helps.
Your Honor, the people would offer if there's a plea to the unregistered vehicle, you would just
The other ticket. So if he pleads to 1657.
Yes.
Thank you, Your Honor. And thank you, Ms. Lundy.
All right. So what does he want to do? Do you want me to adjourn it?
I would ask for a brief adjournment to
All
discuss this with him again.
I'll adjourn both cases out then to the 18th, 9 a.m. and hopefully we'll be able to get it resolved then.
Thank you, Your Honor.
All right. Thank you.
Thank you.
Thank you, Your
Bond
Honor.
continues. Let's call the case of the people versus Justin Goltowski.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Giltowski, who should be present via Zoom. Sir, can you please unmute and state your name for the record?
Justin Goltowski.
Thank you, Your Honor. So Mr. Giltowski has left me several emails and I've left him several voicemails. That being said, we have missed each other on all of those communications. I'd respectfully request a brief adjournment so I can discuss what he would like to do with this case and next steps.
June 18th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Mr. Giltowski. You're all set for today. We'll make
Thank you.
contact successfully before next time.
Okay, thank you.
Why is Parity against the wall?
I think she just moved out of the way for the last defendant. Manners.
Because she has manners. Court calls the cases of the people versus Vincent Dunlap.
Epsilon for the people.
Conrad Siller on behalf of Pittsburgh Township.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Dunlap.
And good morning, Your Honor. If it please this honorable court, Brandon Byrd, also on behalf of Vincent Dunlap. Mr. Dunlap, can you please state your full name for the record?
Vincent Edward Dunlap. Thank you. All right, what are we doing?
Your Honor, we did all have a conversation with all relevant parties in these matters. I believe Mr. Byrd and I are requesting adjournments on the 3 files. Mr. Dunlap has a felony that's before Your Honor tomorrow. And the resolutions on these files may follow what happens on that felony sheet.
Gotcha. So would the 18th be enough time, we think, or?
I'd ask for one more just in case.
What's after the?
July 2nd.
All right. I'll adjourn all of these then to July 2nd, 2025, 9 a.m. He does have minimal bonds on. Yeah, he has $100 bonds on all of these, so. All right, thank you.
Thank you.
Thank you. I wasn't about to argue this time, yeah.
What?
I wasn't about to argue mine this time.
Were you? Oh, no, go ahead.
No. I was. Thank you for the court.
All right, take care of yourself, sir. Let's call the case of the people versus Christopher Holt.
Epsilon for the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Holt. Mr. Holt, please state your name for the record.
Christopher Holt. Thank you, sir. Yep.
Your Honor, we have come to a resolution. Mr. Holt would like to plead no contest. I will admit my fault. I did provide the court with a police report last night, which I know is over the deadline. I did speak with Mr. Holt regarding the possibility of a adjournment. However, we are prepared to report today, depending on
Yes, my staff let me know that you sent it late, but I took the time, Miss Perny, last night to go over the police report.
Thank you, Your Honor. I appreciate that.
There'll be no more favors.
Fair enough.
All right. Okay. What's going to be the plea?
So he's going to be pleading to an added count of larceny under $200 in exchange for a dismissal of count 1. That's correct, Your Honor.
That's a no contest plea.
Yes.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name, please.
Christopher Holt.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of larceny under $200. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right. 2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty to the charge. You understand that?
Yes, Your Honor.
All right. So understanding all of that and the basis for the no contest plea.
Judge Civil liability, Your Honor.
All right. So, sir, understanding all of that to the charge of larceny under 200, how do you plead?
Plead no contest.
All right. Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form. Is that correct?
Yep.
Any questions regarding any of those rights?
No, Your Honor.
Under paragraph 5, those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today to get you to plead?
Nope.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes.
All right. As indicated, the court has been provided, albeit late, Pittsfield Township Department of Public Safety report for their case number 252506. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the defense. Counsel, have I complied with the court rule?
People are satisfied. Satisfied, Judge.
All right, court will accept the defendant's plea of no contest to count two. Count one is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be June 25th, 2025, 9 a.m. Bond will continue. All right, I don't have probation intake on the screen, so you'll have to call over and make an appointment with our probation department. Okay, sir?
Yes, Your Honor.
All right, thank you.
Thank you. You have a good day.
You too.
Bye.
Court calls the case, People versus Jacqueline Murray.
Conrad Siller on behalf of Pittsfield Township.
And Ashland, people.
Assistant Public Defender Natalie Tate, with and on behalf of Ms. Murray on the case ending in 1190.
And Kyle Burrell on behalf of Miss Murray and the two other matters.
Hey, what are we doing?
Mine might be the quickest one, Your Honor. I have discussed this matter with my client as well as Mr. Siller. On my case ending in 1190, I'm respectfully requesting an adjournment of this case to potentially work out a global resolution with Mr. Siller. Ms. Murray is being seen on her felony case tomorrow in front of Your Honor. So I would just ask for a couple weeks if possible.
That matter, I'll adjourn June 18th, 2025, 9 a.m. All right. Bond continued on that. All right, on the other matter.
The matter ending in 1911360, retail fraud with the state. We will be adjourning that. We'll be requesting an adjournment on that matter.
Adjourn that matter June 18th, 2025, 9 a.m.
Thank you, Judge.
All right.
And as to the matter ending in 191-1668, Prosecutor Siller has made an offer to plead to admit responsible to double parking. Ms. Murray would like to take that offer.
Count two, double parking. If you accept that admission, move to dismiss the original charge.
All right. Let's count two. And Ms. Murray, do you admit responsibility to the fact that on September 23rd, 2019, Washington Avenue in Pittsfield Township, that you double parked the motor vehicle?
Yes, I do.
All right, court will accept that admission to count two. Count one is dismissed. I'll do fines and costs of $180. I'm not going to put a time on it. Some point at the
Okay, thank you, Judge.
Thank you.
Thank you.
Court calls case People versus Khalid Hishara. Or Hishara, no, I'm sorry. They put this, yeah, they just have it listed. Oh, Hishara Isa.
Ashland, people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Issa, who appears via Zoom. Sir, can you please unmute and state your name for the court?
Hishar Issa.
Thank you, sir.
Thank you, Your Honor. I'm respectfully requesting an adjournment if possible, 3 to 4 weeks. As of yesterday, our office did not yet have discovery in this case, so I'd ask for a possibly slightly longer adjournment so I can get it, review it with my client.
Retrial July 2nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Your Honor. Thank you, Mr. Issa.
Thank you, Your Honor.
Court
Thank
calls-
you, Ms. Natalie.
Court calls the case People versus Devon Gibson.
Ashland, people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Gibson, who's approaching the podium. Please
Your
state your
name?
name for the record, sir.
Devin Gibson.
Thank you.
Thank
Thank you, Your Honor. I'm respectfully requesting an adjournment. I have discussed this case both with my client and the people. The media that my office received, the media discovery that my office received for this case is for the incorrect case. So we just need to get the correct media and review it with Mr. Gibson. I will say for the court that he is being held on some felony matters with his next court date being July 14th. So we have no objection to a lengthier adjournment so that we can make sure we have the discovery by then.
That's correct, Your Honor.
July 2nd, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Oh, hold on, what's his bond? Okay, he does have a
He
small
should.
cash bond, so he's getting credit.
Thank you, Your Honor. Thank you, sir.
Court calls the case People versus Kenneth Miller.
People.
Kenneth Miller, this is an arraignment, failed to appear, order to show cause. Court does call the case People versus Stephen Grisbeck.
Conrad Silver on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Grisbeck. Mr. Grisbeck, please state your name for the record.
Stephen Grisbeck. Thank you.
Your Honor, we are here for a pretrial on the possession of drug paraphernalia case. I did speak with Mr. Grisbeck. He would, however, like me to renew his request to be released on his domestic violence case.
I don't have the file before me, so I'm not gonna hear that, and I don't know that the prosecutor assigned to that case is here, so I'm not.
That was the one with Miss Polara.
Pardon?
That when I was here 2 weeks ago.
I know, but I don't have, I'd have to hear from the people regarding that, and that's a domestic violence case, and I don't have the domestic violence prosecutor assigned to record. So
I can get in touch with Ms. Zenda and Ms. Polara again. He has completed more classes and wanted the court to know that.
and that was so that you know, and I mean, I don't really want to address it here, but that information as to the classes was provided to the court. And I did look at that earlier this week. I think it might have been Monday or today's Wednesday. So it was Monday that they provided that information to me because the information had come from the jail requesting that. And so I don't know that I made a decision on that in any event.
I did receive a decision from Ms. Polara. Again, we don't need to.
You
get-
probably did.
I did from
Probably
Ms.
made a decision. I just don't recall specifically what it was, but I did review.
Yes, and you said he wouldn't release him at that time, so that's why he wanted me to readdress it. So
I'm just at stake of losing my housing, Your Honor, and
I took all of that into consideration. I also took into consideration, again, I didn't want to address it, shouldn't be addressing it because I don't have that file in front of me. But there were a certain number of classes that needed to be completed that had not happened at that point. And so I gave the preliminary answer that I did. Ms. Perny, certainly you can talk to Ms. Polara and Ms. Zenda and see what can be arranged that might be satisfactory for everyone.
yes, Your Honor, thank you. As for this case, we are requesting an adjournment. We're doing a little bit of investigation. That DV case is holding him. I don't think this one is. So we're just requesting another date.
Pre-trial June 18, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Council approach on that matter.
Hi, I'm so sorry to interrupt. Did you guys call Michael McMullen already?
Thank you, Judge.
Court calls the case People versus Rebecca Miller.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Rebecca Miller, who should be present via Zoom from Dawn Farm. Ms. Miller, sorry.
All right. Apparently, Miss Miller has been transported to the hospital as a medical emergency. And Dawn Farm sent over an email indicating that she can't appear this morning.
Okay.
I am
So-
sorry to hear that, but I would request an adjournment. given
I'll
that.
adjourn it to the 18th, 2025.
Thank you very much, Your Honor.
Thank you.
Hi, I'm so
Court
sorry to
calls the case
interrupt. Did
People
you guys
versus
call Michael McMullen yet?
Court calls the case People versus Chad Jones.
Conrad Siller on behalf of Pittsfield Township.
And Ashley Lonnie for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Jones. Mr. Jones, please state your name for the record.
Chad Jones. Thank you.
Your Honor, we are requesting an adjournment of these two cases. Mr. Jones has three cases in front of Your Honor tomorrow, as well as some cases in 15th, as well as a case before Your Honor scheduled on the 18th. So he's got some moving parts, so we're hoping to possibly do it
So
global.
he has another case before me on the 18th.
Yes.
Yes. And let's try to get all of them together. Is that a state or Pittsfield case? Do you know?
It's a state.
State case. So I'll adjourn these to June 18th, 2025, 9 a.m.
Thank you.
Tag along with those.
Thanks, Your Honor.
Court calls case People versus Jared Roberson.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Roberson, who should be present via Zoom. Sir, can you
He was. Mr. Roberson? Mr. Roberson, can you state your name, please? Oh, you muted. You'll have to, there you go. Mr. Roberson, can you talk to me? State your name. I think if you just talk now, Mr. Roberson, you just unmuted. It's unmuting and muting, and so I don't know. What were we gonna do?
I was going to be requesting an adjournment, Your Honor. The people did extend an offer in this case that would require Mr. Roberson to get a license in order to take advantage of, and he believes he'll be able to do that in July. So I'd request an adjournment into sometime then.
All right, you'll let him know. I'll adjourn this. We can't communicate with him, so you'll have to call him, but I'll adjourn it to July 16th, 2025, 9 a.m. I know he's here because he spoke up previously.
Thank you, Your Honor. And I expect him to be here. And I do apologize for that July 16th.
Yes.
Thank you, Your Honor.
Court calls the case People versus Norcasham.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Kashan, who stands to my right. Please state your name for the record, sir.
We all know. All right. Good morning, sir. All right, what are we doing on his case?
Your Honor, there's a resolution in this matter. I've been able to discuss this with my client and get the documentation from his mother that Mr. Siller has extended the offer of double parking in this case.
That's correct, Your Honor. So we had come to double parking. If you accept that admission, move to dismiss the original charge.
Mr. Kashan, do you admit responsibility to the fact that on May 9th, 2024, Flat Road, Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Sir.
All right, court will accept that admission to count 2. Count 1 is dismissed. What else is holding him?
His anticipated release date is July 5th. I believe he's going to be sentenced on a VOP.
Okay. So what I'll do is fines and cost of $180. Said July 5th?
Yes.
All right, I'll make this payable by September 5th, 2025. You're all set. All right, take care of yourself. Come on. Fit for that block? All right. Step off. We'll get set up for 11 o'clock and I'll come back out. Court's in recess.
District Court, County of Washington, State of Michigan is back in session. The Honorable Judge Simpson presiding.
You may be seated. Court does call the case People versus David Stevenson White.
Ashley Lonnie for the people.
Mr. Stevenson here.
All right.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Stevenson White.
You need a camera, sir?
Yes, can you see me, Judge?
Yes, we see you. All right, go ahead.
Your Honor, we are asking for an adjournment. Mr. Stevenson White is in felony drug court. He's currently in, he's been very successful, I think, in phase 4 out of 5. He believes that he will be getting his license through drug court soon. He doesn't know exactly when that's going to be, though. So I'd ask for a few weeks to see when that
can take place so he can avail himself to an offer.
All right. I'll adjourn this to July 2nd, 2025, 9 a.m.
Thank you, Your Honor.
We'll see where we are. All right. All right, sir. Thank you.
Thank you.
Court does call the case People versus Alicia Stewart.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Stewart, who should be present via Zoom. Can you please state your name to the record, ma'am?
Alicia Stewart.
Thank you.
Thank you, Your Honor. So Ms. Stewart has had her Secretary of State administrative hearing early May, no longer this month, it is now June. She had it in May, and last I spoke with her this week, she was still waiting on a decision from them to see if she would be able to be eligible for restoration. So I would ask for a few week adjournment.
All right. So all of that correct, Ms.
Yes.
Stewart? All right. We adjourn this to July 2nd, 2025, 9 a.m.
Thank you.
All right. Thank you. Take care. Court calls the case People versus David Wagner.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of who is present via Zoom. Sir, can you please state your name for the record?
David Charles Wagner, Jr.
Thank you, Your Honor. I'm respectfully requesting an adjournment of the pretrial. I had the opportunity to discuss this carefully with my client. He did provide me the documentation that I did provide to the court regarding the ownership of the animals in the residence belonging to another person. As to the case itself, I'm requesting an adjournment to discuss this further with my client and to negotiate.
Any objection from the group?
There are.
All right. And this information from Vetco was provided also to the people.
It was.
Yes.
All right. Turn this matter to July 2nd, 2025, 9 a.m.
Thank you, Your Honor. Mr. Wagner, you're all set for today, okay?
All right, thank you so much.
Thank
You have a
you.
good day.
You too. Court calls the case People versus Jason Williams.
Ashley Lonnie for the people.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Williams. Mr. Williams, please state your name for the record.
Yeah,
I think he's iPhone,
I think so.
but he's muted.
Mr. Williams? If that, you're muted. I think it's you. You know how to unmute? Yeah, that's gonna be no. Well, let's make sure we're talking to Mr. Oh, almost. Nope, you didn't get it. Well, no, oh, no, wrong button. All right, Mr. Williams, if that's you, wave your hand. All right, hold on. Okay, hold on a second, because could be like next year before we get this done.
Well,
What are we intending on doing?
Your Honor, we are requesting a relatively lengthy adjournment. I can speak with Ms. Lonnie about this case. And we're hoping for a longer period of bond compliance in order to negotiate an offer. So
All right,
that's the reason for the lengthier adjournment.
That's correct, Your Honor. Given that the defendant does have a prior, I did tell Ms. Perry that I want to see a longer term of compliance before making any offer.
all right. So here's what I'll do. Mr. Williams, I'll adjourn your case out to July 16th, 2025, 9 a.m., or as your invite indicates. All right. Did you hear me, Mr. Williams? If you did, nod your head. I see you waving, but okay, you heard me. All right, real good. We'll see you on the 16th. Between now and then, you figure out how to unmute. All right. Okay, take care. Court calls the case People versus Oscar Romero Gonzalez.
Ashley Lonnie for the people.
The arraignment. Sir, come forward. What's your name, sir?
Oscar Romero Gonzalez.
All right. Sir, this is an arraignment to let you know what the charges are and maximum penalty. The complaint that it alleges, or the ticket alleges, that on or about March 25th, 2025, location of US 23 near Washington, Pittsfield Township, that you did operate a motor vehicle without a valid operator's license on your person.
Yeah.
Hold on.
Sorry,
Do you understand that charge?
Yeah.
Okay. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. You understand that, sir?
Yeah.
Okay. My first question that I have for you is, do you want to be represented by an attorney?
Attorney?
Yes. Do you want somebody to help you through the process? You do? Okay, this is a public defender case.
Assistant Public Defender Natalie Pate with on behalf of Mr. Romero Gonzalez. We would waive any further reading, stand mute to the charge, and ask for an adjourned pretrial date, please.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to July 2nd, 2025, 9 a.m. As the bond in this case, I will set his bond at a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. No use of alcohol, recreational marijuana, or any illegal drug.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Court calls case People versus Adam Sowers.
That's the one for the people.
All right.
Good morning, Your Honor.
Good morning. Your name?
Adam Lawson Swords.
All right. Sir, this is also an arraignment. And the complaint in this case alleges that on or about February 27, 2025, at the location of Washington near Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle without proper security. Do you understand the nature of that charge, sir?
Yes, Your Honor.
All right. That's a misdemeanor, punishable by not less than 1 year, not more than 1 year, and not less than, do that again, not more than 1 year incarceration, and not less than $200, nor more than $500 fines plus court costs. Do you understand those maximum?
Yes, Your Honor.
All right. First question I have for you, you want to be represented by an attorney?
Yes, my attorney will be making an appearance today. He's in another meeting this morning. He advised me, his
Who's
name
your
is
attorney?
Tim Dinan.
Okay. Did Mr. Dinan, he said he'd be coming?
Yes, he had another hearing this morning, so he couldn't make it. But he advised that I stand mute, but he.
Okay. All right. Gotcha. All right. So here's what I'll do. You understand the charges against you and everything.
Yes, Your Honor.
All right. So I'll indicate that the defendant is standing mute to those charges. I'll enter a not guilty plea on your behalf. You understand that, sir?
Yes, Your Honor.
All right. And Mr. Dinan needs to file an appearance with the court.
Yes.
Okay. In this case, so that we know that he's the attorney of record in the case. I'll adjourn your case out to June 18, 2025. I'll set it at 9 a.m., but he'll get a time block that his case is.
Okay.
And once he files his appearance with the court.
June 18th, 9 a.m.
Yeah. And then what I'll do is part of also the arraignment process is I set bond or conditions for your release. I'm going to give you a $5,000 personal recognizance bond. Basically what that means is I'm letting you go on your own accord. If you don't show up, you may owe the court $5,000.
I understand.
For your release. Understand that?
Yes.
Okay. And then I'll order standard conditions such as you are not to commit any criminal offenses, you're not to leave the state of Michigan, you're to appear at all court proceedings and other places that's directed by the court. There will be also, you are not to engage in any assaultive behavior, you're not to have any possession of weapons, firearms, ammunition, or anything fashioned to be a weapon. I'm also going to indicate that you are at this time not possessing any alcohol, recreational marijuana, or any illegal drugs. You understand all of that, sir?
Yes, Your Honor.
All right, very good. All
And Your
right,
Honor, for the record, I'm handing the defendant my card, which I've written on the back, the instructions on how to get discovery from my office, so you can provide that to his attorney.
I'll do that. Thank you.
okay, very good. Thank you, sir.
I do have a question about the appearance. Will that, just if I'm working that day, will I have to appear in person or via Zoom?
It would have to, right now, you'd have to appear in person. There's a form that you'd have to file for a request, to appear via Zoom. Those aren't always granted, but you can file that paperwork.
I understand.
All right, or your attorney can file it.
Mr. Dinah can contact me if he needs an adjournment of that date.
Yeah, okay?
Thank you.
All right, thank you, sir.
Thank you.
Court calls the case, People versus Christopher Akron.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public,
You see him?
Assistant Public Defender Natalie Pate with and on behalf of Mr. Akron, who stands to my right. Please state your name for the record, sir.
Christopher Akron.
Okay.
Thank you. So, thank you, Your Honor. I did discuss this matter with Mr. Akron. We are ultimately requesting an adjournment for him to attempt to get some documentation of the vehicle in question so he can potentially take advantage of a potential offer that was extended. The vehicle in question, he believes is still impounded, but he wants to get the paperwork in order to prove that for me to provide to the people. So I would respectfully request an adjournment of a few weeks.
I'll adjourn the matter June 18th, 2025, 9 a.m. All right, thank you.
Thank you, Your Honor.
All right, thank you. Salandi, have a good day.
Take care. I'll see you tomorrow.
Yes, ma'am. Court calls the case, People versus Robert Addy.
Conrad Silver on behalf of Pittsfield Township.
Apologize for that, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Mr. Addy, who should be present via Zoom.
Yes. Robert Addy?
Yes, can you hear me okay?
Yes, we can hear you. We need a camera.
Okay, yes, sir. All right,
Okay,
there we go.
Okay. Okay, we have.
Thank you, Your Honor. We do have a resolution in this matter in which Mr. Addy will be pleading guilty to added count 2 of allowing an ineligible person to drive. In exchange, count 1 would be dismissed. And Mr. Addy did give me permission to sign the advice of rights form on his behalf that I believe the court should be in receipt of.
Your Honor, I move to add count 2 of MCL 257.326. If you accept that guilty plea, move to dismiss the original charge.
All right. Sir Addy, can you raise your right
Yes,
hand,
sir.
please, sir? Raise your right hand. Do you solemnly
Yes, sir.
swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for the record, please.
My name is Robert Lamont Addy.
Okay. Sir, it is this court's understanding you're going to be pleading guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days in jail and a $100 fine plus court costs. You understand that?
Yes, yes, sir.
All right. And understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
I plead.
All right. You have to say that again. You broke up on me.
I plead guilty to that charge.
Okay. You understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You had an advice of rights signed on your behalf and have gone through that. Do you have any questions regarding any of those rights?
No, sir. No, sir.
You understand that you're giving up all of those rights, including the rights contained under paragraph 5, which are your trial rights.
Yes.
You understand that you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge? Did you hear my question, sir?
Yes, I did. No, sir.
All right. Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, I am.
And also because you believe that you're guilty of this offense?
Oh, yes, sir. I take full accountability, Your Honor.
All right. April 4th, 2025, at the location of Ellsworth Road, Pittsfield Township, Washtenaw County, State of Michigan, did you have custody or control of a motor vehicle?
Yes, I did.
All right. Did you allow someone who was otherwise ineligible to operate that motor vehicle that may have included yourself?
Yes, sir.
Okay. Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, is there anything you or your attorney would like to say before I impose sentence?
Your Honor, as I just mentioned, I take full accountability of my actions, and I apologize to waste time, the court's time, and I appreciate the attorney that I have been so helpful, and taking full accountability of my actions, Your Honor, and it won't happen again.
I just have a question for you.
Yes, sir.
Who was the little guy playing baseball?
Sorry, Your Honor, I don't know how that got up on my screen, but I am a deacon at Second Baptist Church in Ypsilanti, Michigan, and
Yes, sir.
I am the co-chair of a new program that we are starting up for the youth in our community to teach them basic softball skills and have other activities for the youth in our community to participate in to help keep them out of trouble. And that happened to be a flyer that I just got produced yesterday, so we can pass them out and get more people to attend.
Well, I'll tell you something. Now you're a man after my own heart. Partially because of Second Baptist, but I'll just say also that I coached and played softball for years. And so I think kids need to be more involved in that. So it's good to hear about that. And I'm glad I asked, because otherwise I would have just assumed it might have been your little one or something like that, just putting that up on the screen. But you don't have to apologize for that. That's something that should be broadcast about what's happening in our community. The other thing is, and I wish people could see it, and now I understand why you did it. I appreciate the respect that you showed to the court, that when you came on, you had a hat on, but the moment you started addressing court, you removed your hat. And
Absolutely.
Maybe that's just an old time thing, but I did appreciate that, and that did not go unnoticed. Hold on one moment.
Amen. Yes, sir.
All right. So here's what I'm going to do. I'll suspend 90 days in jail. I'll fines and costs of $250. I'm going to waive half of that, which is the best that I can do. So it'll be $125. When do you think you can get that paid?
I would just need like 30 days to get it paid in full, just to be on the safe side, Your Honor.
Tell you what, you're sitting up there working with the kids. You get that paid sometime before the end of the year, December 31st. Give you some time to get that in. You're going to be busy with the kids. And I just say is I appreciate everything that you're doing with them and trying to keep them out of trouble.
Amen.
All right.
Thank you, Your Honor.
All right. You take care of yourself, sir.
Thank you, Your Honor.
Okay, thanks a
Thank
lot.
you, Mr. Addy.
Thank you.
Court calls the case, People versus Rex Atkinson.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Atkinson. Mr. Atkinson, please state your name for the record.
Oh, there he is.
Rex Atkinson.
Thank you, sir.
Your Honor, we are requesting an adjournment of this hearing. He has some tickets that have suspended his license. The 34th District Court has an amnesty program that's taking place at the end of this month. And
Okay.
he's gonna participate with that and see if he can work out some of the fines with the 34th and then be able to get his license. So I'm asking for a date in July,
Got it.
given that program.
July 16th, 2025, 9 a.m. Okay.
Thank you, Your Honor.
Oh, you're welcome, sir. Hopefully that'll work out for you. Take care. We'll see you
July
then.
16th at 9 a.m.
Yes, sir.
All right.
All right.
Your Honor.
Take care. Court calls the case People versus Tasha Beavers.
Conrad Siller on behalf of the township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Beavers. Ms. Beavers, please state your name for the record.
Tasha Beavers.
Okay. What are we doing in this case?
Your Honor, regarding the pretrial, we're requesting an adjournment, for some ongoing investigation.
I will adjourn the matter to June 8th, 2025, 9 a.m. As to the bond violation.
You know, I did have a chance to speak with my client regarding the bond violation. I believe that she wants to admit to the violation today. Is that correct, Ms. Beavers? I did advise her of her right to a hearing. Regarding bond and sentencing on the bond violation, would like to make some statements on behalf of my client.
Yes, go ahead.
Regarding her health, she is dealing with some health issues. She's dealing with kidney cancer and is on significant medication for that. She has an appointment with her kidney doctor on the 6th. I believe they're working towards getting a transplant. She's very concerned that if she is in custody, that she may lose that appointment and may lose that process, or lose her line in that process. She did speak to her agent at Community Corrections regarding the test, and she does have an appointment for CCOP this afternoon at Community Corrections. So she is working on getting into a treatment program. Her son lives with her if she's in custody. She supports him by paying the bills, rent, groceries, things like that. If she isn't taken into custody, it may impact her son and his ability to stay in that home. We are asking that the court consider continuing her personal bond, ordering her to report to Community Corrections for the outpatient program, and perhaps adjourn sentencing out to see how her progress grows in that program.
Well, here's the concern that the court has. On May 21st, first of all, she's here on a possession of direct paraphernalia charge. On the 21st, she tests positive for benzodiazepine, THC, cocaine, fentanyl, and other opiates.
She did make me aware that she has prescription medication that she takes. You did provide a prescription to Community Corrections for the benzo, I can never pronounce, but thank you, Your Honor, as well as the opiates. She did also want the court to be aware that because her kidneys are not functioning properly, they don't flush her body as quickly as normally functioning kidneys, and that may be why she's continually testing positive for the other illicit substances.
I understand, but the problem is that they shouldn't have been there in the first place. And then, so that's on the 21st, 8 days later, and I'll take your word for it, on the benzodiazepine and the opiates, they're still present in their system, THC and cocaine. And so, anything you want to say, ma'am?
Well, THC takes a minute to come out, and I am trying. I have a appointment today. That was as soon as they can get me in.
Well, yep. You have an appointment? What do you mean with?
With outpatient treatment.
She did schedule that with, Ms. Dozier at Community Corrections. I believe it's reflected in the violation report.
Well, maybe if you put together a plan, I'll consider some other remedy and something else to do. I understand she may have the medical appointments and the other things. But at this point in time, this is absolutely unacceptable. Defendant's bond is revoked, defendant is remanded. Thank you.
Your Honor,
My bailiff.
one remaining question. If we do get her assessed and get her a bed, can she be released to inpatient treatment?
I will consider release to inpatient treatment.
Okay. All right. Thank you, Your Honor.
Thank you. Ma'am, you're gonna have to stay back. Court calls case People versus Erica Birch.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate for Ms. Birch, who gave me authority to accept the offer on her behalf.
So Your Honor, I move to add count two, double parking. You accept the admission. Move to dismiss the original charge.
You having authority to admit responsibility, do you admit responsibility to the fact of the defendant double parking on March 31st, 2025?
Yes, Your Honor.
All right. Court will accept that admission. Count two, count one is dismissed. Fines and cost of $180 when connected.
Ms. Birch was asking for 3 months, Your Honor. When I spoke to her, she stated to me that it would be last week that she had kidney surgery and is still currently recovering and not working.
Paid by August 30th,
Thank you, Your Honor.
2025. Court calls case People versus Eugene Campbell.
Conrad Siller on behalf of Pittsfield Township.
Sorry. Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Campbell. Mr. Campbell, please state your name for the record.
My name is Eugene Campbell.
Thank you.
Your Honor, we are requesting an adjournment into July on this case. Mr. Campbell is going to have a hearing in front of the Secretary of State. He's waiting for that date. He did submit the paperwork seemingly early June and is just waiting on a response.
Okay. Got it. He submitted the paperwork when?
Yeah, I submitted paperwork last week through First Step Referral right across the street. So I'm just waiting on them to get responded back for a date. That's all.
Got it. All right. Turn this to July 16th, 2025, 9 a.m. All right, you're welcome.
Thank you.
Take care. See, your other client should be like him. He brought a driver. I know, I saw you. Court calls the case People versus Jerisa Carr.
Conrad Siller on behalf of Pittsfield Township.
She's in jail.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Carr, who is present via Zoom. May you state your name for the court?
Carr.
My camera broke.
Oh, there you are. Okay. All right. What are we doing?
I'm respectfully requesting an adjournment, Your Honor. It is my understanding that Ms. Carr does not currently have a valid license, but would be working to get it. So I'd request an adjournment for her to do so.
Okay, she's got a number of things she needs to pay out. I'll adjourn this to July 2nd, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you, Ms. Carr. Court does call the case People versus Deontay Arnold.
Conrad Siller on behalf of Pittsfield Township.
Wait a minute.
Yes, sir. No.
Deontay Arnold will issue an order to show cause. Thank you. That ends that block.
Yes, sir.
We'll be back shortly and we'll begin the new block. Court stands in recess.
All rise.
Court does call the case of the People versus Stephen Culmer.
Conrad Siller on behalf of Pittsfield Township.
Public Defender Natalie Pate with and on behalf of Mr. Comer, who should be present via Zoom. Sir.
Mr. Comer, Can you unmute and turn
Yes,
on your
sir.
camera?
Yes,
Oh,
sir.
there you are. State your name, please.
Stephen Coleman.
All right.
Thank you, Your Honor. I'm respectfully requesting an adjournment. It's my understanding that Mr. Comer does not yet have a valid license, but is hoping to get one.
Okay. July 2nd, 2025, 9 a.m.
Thank you.
All right, thank you. Thank you, Mr. Comer.
All right, thank you. Have a good day.
Case of the People versus Joella Edwards.
Henry Solar on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Edwards.
I do not have Edwards, Joella Edwards, no response.
I can speak with Ms. Edwards. We're gonna request an adjournment. She had provided with the Zoom information. I have no explanation for her failure to appear for the record. I would request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue immediately. Well, no, I'm sorry. That warrant will issue. What's today?
Today's the fourth, Friday's the sixth.
June 6th. Court calls case People versus Donnie Ellison.
Henry Solar on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Ellison. Mr. Ellison did give me permission to accept the offer on his behalf.
So, Your Honor, I move to add count 2 of double parking. Accept the admission of double parking and move to dismiss the original charge.
And Ms. Perry, on behalf of your client, you admit responsibility to the fact that on March 25th, 2025, in Pittsfield Township, he double parked a motor vehicle.
I do.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can that be paid?
He's asking for 4 weeks, Your Honor.
Really? Pay it by July 7th. Court calls the cases People versus Christina Evans.
Henry Solar on behalf of Pittsfield.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Evans. When I attempted multiple times to contact Ms. Evans, I was unable to do so. Oh,
Christina Evans?
Do you see me?
No, we do not. I hear you, but we do not see you. Camera's not on.
Okay, let me see. And yes, when I seen your text message, when you were trying to message me, I was out of town for my birthday. It was my birthday. So I didn't see your message but I did show up to the court date. I just got back from out of town.
Okay.
well, I'm glad you're here, Ms. Evans. I would ask for an adjournment of these 2 cases, so let me have a chance to speak, Your Honor.
All right. I'll adjourn your matters to June 18th, 2025, 9 a.m.
Okay, thank you.
All right. Thank you, ma'am. Take care. Bond continued. Court calls case People versus Angel Ford.
Henry Solar on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Ford. Ms. Ford, please state your name for the record.
Angel Ford.
Thank you.
Yeah, I'm requesting adjournment. Ms. Ford did provide some documentation to me. I expressed earlier, and I didn't have the conversation this morning. I'd like to have another conversation with my client to discuss her potential options.
Adjourned to July 2nd, 2025, 9 a.m.
Thank you.
All right. Bond will continue. Thank you, ma'am.
Thank you.
Court calls the case of the People versus Jermaine Hamilton.
Henry Solar on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate for Mr. Hamilton. Your Honor, someone from our office did speak with a family member of Mr. Hamilton who advised that unfortunately Mr. Hamilton has passed away, and that I did receive some correspondence from your staff yesterday that
All right.
that effect. And that's all.
So I move to dismiss, Your Honor.
All right.
Objection.
Case is dismissed.
Thank you, Your Honor.
Court calls case People versus Neil Hines.
Conrad Siller on behalf of Simpson Township.
It's public defender Lauren Perry on behalf of Mr. Hines. Mr. Hines did give me permission to admit to the offer on his behalf.
So, Your Honor, I move to add count 2 of double parking. And if you accept the admission, move to dismiss the original charge.
Attorney, do you have responsibility to the fact that your client on June 3rd, 2018 in Pittsfield Township double parked a motor vehicle?
I do.
All right, court will accept that admission. Count 2, count 1's dismissed. Fines and cost of $180. When can that be paid?
I'm asking for 4 weeks, Your Honor.
July 7th, 2025. Court calls case People versus Maurice Kenny.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Key. Mr. Key, please state your name for the record.
Please pay.
All right.
We are asking to set this settlement conference. I know the next one is Friday. We have no objection to that date, also no objection to the August date, seeing as it's 2 days from now.
I request the August date.
Jury final settlement conference will be set for August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Thank you.
Thank you.
Court calls case People versus Matthew Martinez.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Martinez, who is present via Zoom. Mr. Martinez, please state your name for the record.
Matthew Martinez.
Okay. I did see him on camera. You'll need to turn your camera back on.
Your Honor, I believe this is going to be a dismissal.
That is correct.
No objection.
No objection.
Sorry. Case is dismissed. Thank you, Mr. Martinez.
Be concerned. I apologize to people in Ann Arbor for what happened, by the way.
You're out. You're good. All right. Thank you. Court calls case People versus Michael McMullen.
Conrad Siller on behalf of Pittsfield Township.
Public Defender Natalie Haywood on behalf of Mr. McMullen, who should be present via Zoom.
Mr. McMullen, can you turn your camera on, please, sir?
Yes, sir. I'm looking to see how to do it right now.
Oh, there he is. All right. State your name, sir.
Michael McMullen.
All right.
Your Honor, I'm respectfully requesting an adjournment. It is my understanding that Mr. McMullen does not yet have a valid license, but is hoping to get one. I request 3 to 4 weeks to see where he is at that time.
July 2nd, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls case People versus Abbas Mercado.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Mortada. Mr. Mortada on Zoom, Your Honor. I did provide him with the Zoom information. I have no explanation of his failure to appear today, Your Honor. For the record, I request.
Mercado, bench warrant will issue bond 5,000. Give a 10% privilege. There's been a previous warrant, so this warrant will issue immediately. Court calls case People versus Demarius Munoz.
Conrad Siller on behalf of Pittsfield Township.
Yes, on behalf of Ms. Munoz, who's present via Zoom. Your name for the record, ma'am?
Excuse me?
Please state your name for the record, ma'am.
Damaris Monreal Munoz.
Thank you, Your Honor. I have had the opportunity to discuss this with my client as well as provide her with documentation of what she needs to do in order to take advantage of the offer extended by Mr. Siller. To that end, I think this can be accomplished in one last very brief adjournment. So I would request that.
I'll adjourn this matter June 18th, 2025, 9 a.m.
Okay,
All right.
thank you.
All right. Thank you, Ms. Mendez.
Thank you, Your Honor.
Court calls the case People versus Ariana Jenkins.
Conrad Siller on behalf of Pittsfield Township.
Arraignment, sorry. The wrong side of the door.
I know.
All right. What's your name?
Ariana Jenkins.
All right. Ms. Jenkins, you are before the court on a misdemeanor complaint. That complaint alleges, this is your arraignment so that you understand. This complaint alleges that on or about March 31st, 2025, at the location of Campbell Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle with a high blood alcohol content. Do you understand the nature of that charge?
Yes.
Yes. That is a misdemeanor. It is punishable by up to 180 days incarceration, up to a $700 fine. The court could order community service and any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, ma'am?
Yes.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, please.
All right, this is a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Jenkins, we would waive any further reading, stand mute, and ask for an adjourned pretrial date, please.
Defendant every way, formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be adjourned to June 18th, 2025, 9 a.m. or as your invite indicates. As to bond, alleged BAC in this
Your
matter.
Honor, it's a search warrant. The result was .215. The defendant drove off the road, up the corner at Michigan Avenue and Campbell Road. Drove off the road, back onto Campbell Road, and then proceeded to run. So
Proceeded, I'm sorry.
then proceeded to her home, which was very close by. So no accident, but she did drive off the road.
Yes.
I would just, I know given the nature of the charge, Your Honor, that you typically order either a sober link or a scram. We would have no objection to that testing through the alcohol monitoring. But I would, I would ask that she remain out of custody, of course, on a PR bond, however.
Bond will be set in the amount of $20,000 personal recognizance bond. All other standard conditions, including no assault behavior and or possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. Do you understand that, ma'am?
Yes.
I will also order that there is to be no possession of any alcohol, recreational marijuana, or any illegal drugs. Do you understand that?
Yes.
I am going to order. Does she have any prior alcohol related offenses?
I'm not aware of any, Your Honor.
No, I'm not aware of any.
I've seen no on her driving record for CCH.
This is a search warrant because of implied consent refusal.
Correct.
Is there a, you have a ticket for PPT refusal?
Oh, I'm sorry.
So the implied consent was. How old are you? How old are you?
24.
Are you in school?
And I'm going back to school in the fall.
Huh?
I'm going back to school in the fall.
Okay. Were you in school this previous semester?
No.
Were you just working or doing nothing?
Just working.
Council approach. Were you in school?
Yeah,
Where were you in school?
in Texas. I recently just moved back here. Texas Southern University.
You were at Texas Southern?
Mhm.
You graduate or you just
No, I didn't graduate.
stopped?
Mhm.
Okay. When did you move back?
I moved back in October.
Who's here with you?
My mother.
Yeah, hello. I'll ask the question. Are you originally from here?
Yes.
You got into Texas Southern.
Yes.
How long were you in Texas Southern?
About 2 years.
And you stopped at Texas Southern, why?
To come back home. I don't know. I can't answer that.
You don't have an answer for that?
No, I regret it, but yeah.
Well, hold on. Does mom have an answer for that?
No.
She doesn't have an answer? How come mom's not in yes? Young lady, I just don't think you're that grown. I think mom's got an answer and I want to know. Mom, can you come on up? Your name, ma'am?
Joyce Jenkins.
All right. So here's my, so that you can understand what my pause is in terms of trying to set her bond.
Right.
I've got a young lady that has significant blood alcohol level.
Right.
Was in school, is now not in school, says she's going back to school, was someplace else and is now back here. I'm trying to figure out what's going on in terms of making sure that conditions are set. So you'll tell me why she's not there.
All right. So she was there and COVID happened.
Okay.
All of her classes transitioned over to online and she's not an online student. So she's been out. So she then moved over to Houston Community College.
Okay.
But that didn't work out because it was still COVID, online classes. So it's been a few years, but now she's working in the healthcare field. So now she's wanting to go back for, I think, LPN. So.
Why did you shake your head, young lady?
Oh, no, she said it wrong. It's LPN.
LPN.
So,
That's your mother. She never says anything wrong. Go ahead, man. What were you telling me?
Yeah, so she wants to be a LPN, so she's looking at programs and so.
All right. Okay, but otherwise she behaves herself.
Now, since this episode happened, she located a job at Brecken Village. And she's been working consistently since then, and then that kind of helped her discover what her career goal is, going to the LPN.
All right, thank you, ma'am.
Mm-hmm.
I think you can just tell me that. Young lady, why can't you just tell me that?
I don't know.
How long have you been working where you're working?
About 3 months now.
Is it full time?
Full time.
Council approach again.
One, together, like the quiet ones. Gotcha. You won't have to the car. It's not like that. There's 3 times. Yeah.
Silverlink.
Yes, Your Honor.
Court's going to order that defendant be report to community corrections replacement of Silverlink testing device. And I'm signing that order. They'll be testing 3 times a day. I need you to understand, young lady, that if you miss a test, that is considered a violation of that. So you've got to make sure that you keep up with that testing. Understood?
Okay, yes.
All right. Thank you. See you in a couple weeks. Thank you,
Your Honor.
Court calls the case People versus Javi and Lovelace.
Conrad Silver on behalf of Pittsfield Township.
This is an arraignment. Javi and Lovelace, show cause for his failure to appear at arraignment. No response. Bench warrant will issue for defendant's failure to appear. Bond is set in amount of $5,000. I'll give a 10% privilege that warrant will issue. Court does call the case People versus Halaru Nayaya.
Conrad Silver on behalf of Pittsfield Township.
Oh, I think he's here. Hello, sir. What's your name?
My name is Haliru Naya.
Pardon?
Haliru Naya.
All right. Sir, you are before the court on a citation that alleges that on May 9th, 2025, that you operated a motor vehicle with an improper plate or registration. Do you understand that charge?
Yeah.
Okay. That's a misdemeanor. It's punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Okay.
You understand that, sir?
Yeah, I understand.
Okay. This is alleged to have occurred on that date in Ellsworth Road in Pittsfield Township. Do you wish to be represented by an attorney?
Basically, I don't understand the process because it's my vehicle. I bought it on Craigslist. Then I bought it on Friday. So instead of me taking it.
No, I don't want to know anything about the offense. You understand what you're charged with, though. I'm not saying whether or not you did it.
Okay.
Let me ask you this. What's your first language?
French.
French?
Yeah.
Okay. We will get an interpreter for you. I'm going to have an attorney represent you.
Okay.
Okay?
All right.
So this is a public defender case.
All right.
Did you get that? This is going to be a French attorney.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Nyaya stands to my right. We would waive any further reading, stand mute, and ask for an adjourned pretrial date, Your Honor.
I'll adjourn this matter to June 18th, 2025, 9 a.m. Well, actually, no. I'm going to adjourn it to July 2nd, 2025, 9 a.m. I'm going to set his bond at a $5,000 personal recognizance bond, standard conditions, no assaultive behavior or weapons, no alcohol, recreational marijuana, or any illegal drug.
Thank you, Your Honor.
Thank you.
Write down your phone number for me.
And once you're done with that, counsel approach, please.
Yes, sir. Thank you, sir. You're all set.
Okay. Thank you.
Yes. Okay. All right. So we're about caught up. I'll take about a 5-10 minute break, then I'll come back. We'll begin our 1 o'clock block.
All right.
Court does call the case, People versus Olivia Ray.
Conrad Silver on behalf of Pittsfield Township.
Good afternoon, Your Honor. Aaron Hilgendorf appearing on behalf of Olivia Ray, who's present. State your full name.
Olivia Ray.
Thank you. All right, what are we doing?
Your Honor, we're here for an arraignment and a pretrial. For purposes of the arraignment, we have received a copy of the misdemeanor complaint. We went over it. We would waive its formal reading, ask that you enter a not guilty plea on her behalf.
And then having waived formal reading, pleading not guilty, court will enter that plea.
Your Honor, it's my understanding today the defendant is going to plead guilty under HIDA. She is 20 years old. So she qualifies for HIDA. And so
Hold for one moment. You got him. Go ahead.
So it's my understanding she's going to plead guilty under HIDA today. She's 20 years old. She wants to proceed out that.
That's accurate, Your Honor.
May I have her sworn?
Raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, help you God?
Yes.
Go ahead and lower your hand. Say you spell your name out.
Olivia Ray, Olivia-Ray.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud under the Pittsfield Township ordinance. Your understanding?
Yes.
All right, that is a misdemeanor, punishable by up to 90 days in jail and a $500 fine plus court costs. Do you understand that?
Yes.
And understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
I'm sorry, can you repeat that?
You signed an advice of rights form,
Yes.
is that correct?
Yes.
All right. Do you have any question regarding any of the rights on that form?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today? That you plead?
No.
Has anybody threatened you or coerced
No.
you? You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
Make it plain to you. On the date of March 29th, 2025, at the location of 2000 Waters Road, what did you do at the Target store that makes you think that you're guilty?
I walked in and I exited with a face wash without paying for it.
With what?
A face wash.
Face wash?
Mhm.
Okay. Store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
This property you took was offered for sale by Target?
Yes.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor, we're satisfied.
All right, court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter,
June 25th at 9 a.m.
June 25th, 2025, 9 a.m. You haven't appeared before me, obviously, before. Are you in school?
Not at the moment.
But yes,
Well,
normally,
yes.
she just finished her
Sorry,
second.
it's the summer.
Your Honor, she's a second-year student at Michigan.
At Michigan? University of?
Mhm.
Sorry, you went to a second-rate school. It's okay, I'm a Maryland grad, so I have to just say that. All right. Go ahead, you were saying, Counsel,
That's really it. We were going to ask for a personal bond, Your Honor. She's 20 years old. She is a full-time student. She's clearly off for the summer. She has taken this very seriously. Her mom's here right now. Her dad was here this morning. We were mixed up on the time, but he was here and had to take off. But he did take off work and he was here. She has taken a extensive theft awareness course. She took a 16-hour course. I presented Mr. Seiler with a copy of that. So based on that, I would ask for a personal bond, and then I got to notify you of one thing. Oh, actually, she has never mind. We'll be back before that. She has a wedding. Her uncle's getting married in Wisconsin, but that's going to be July 2nd. So we were going to ask for permission to leave the state for that.
What are you studying?
I'm an acting major.
Did you graduate high school here in Ann Arbor?
No, sir.
Where?
I went to Interlochen Arts Academy. It's near Traverse City.
I know where it is. Everybody thinks I just crawl from under a rock and just put on a robe and come in. I know where it is. So that tells me that there's a lot of talent there, right?
I hope so.
Valedictorian.
They know so, right? So I'm sure your parents have probably asked you, what happened here?
I don't want to approach my statement with making excuses. I have had anxiety since I was born, really, but I was diagnosed with it when I was in 6th grade. And I was having a particularly difficult time, and I believe I just wasn't thinking and made a mistake.
Been doing this a long time, and so when young people particularly appear before me, sometimes I'm trying to figure out, why are you here? And why do you think you got caught? I'll let you answer, and then I'll give you the answer. But why do you think you got caught? That's a hard question, isn't it?
Yeah.
Yeah. But I'll tell you why I think you got caught. I don't think you were raised to be a criminal or a thief in any respect whatsoever. You don't know how to commit a crime. That's why you got caught. Okay. And the important thing for you, I'll just take a little bit of time, because I can tell when you walked up here, you were nervous as all could be, right? There's this crazy guy named Simpson up here, and there's no telling what he'll do, right? I bet you were asking your attorney over and over, what's he like? What's he going to do? Am I gonna, right?
I mean, no.
No,
I
you didn't
Googled
ask
you, but
What'd you say?
I Googled you.
I'm not going to ask you what you found, right? You know, it's that day and age. If I want to know, I'm not asking my attorney. I'm just going to Google it. Whatever you do, and you still got to go through the sentencing process and everything else. But I think it's important. You just finished your 2nd year. And out of all of this whole thing, people at times make a lot of mistakes, right? And what you can't do is let this define who you are. There's not a person in this room that hasn't made a mistake that if they could go back, they'd like to do something different, right? But it won't define who you are. Okay? You got that? You didn't expect to have this conversation, did you?
No.
You're not crying, are you? What's wrong?
I just do when I get nervous.
Am I making you nervous?
Well,
Well, what?
I mean, not you particularly.
Just the whole thing, right? Okay. You'll make it through all of this, all right? You just kind of walk it through. There'll be some things for you to do, but it looks like you and your family got a head start on a lot of stuff. And you'll make it through. At some point then later in life, you'll look back and you'll try to figure out why the heck I did that, and maybe even get a little bit of a chuckle out of it in some way. Okay. So what kind of arts do you do?
A theater.
Your theater.
Mhm.
Really? So acting.
Yeah.
Probably good that you're with a bunch of lawyers. Seems all we do anyway, right? All right. Okay, young lady, you take care of yourself. All right.
Okay, thank you, Your Honor. And you just want me to give you a copy of that certificate from her class at sentencing? Or would you like a copy? I have it.
Well, I'll tell you what, on your way out, you can start the process. You can stop down at my probation department. They'll be on your left on the way down. And if you have a copy of the certificate, you could, if they'll take it right now, you can give it to them.
Okay.
Right now.
All right.
Okay.
Thank
All
you.
right.
See you on the 25th.
Yes, we will see you. Court does call the case, People versus French and Is it Okunde?
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, this is Public Defender Lauren Perry on behalf of Ms. Okunde. Ms. Okunde, please unmute, say your name for the record.
Hello? Can you hear me?
We can hear you.
Oh,
Can you state your name, please?
Yeah, Francine Okundai.
You got her. Okay.
Yeah.
All right. What are we doing?
Your Honors, similar to the last case, Ms. Okundaye is going to be pleading guilty under HIDA. I do have a copy of her signed advice of rights form.
All right. Under HIDA.
Correct.
Got it. She's 21. She's 20 at this point, right? But she will be 21 in September. All right.
Yeah.
Can you raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help God?
I do.
All right. State your name again for the record, please.
Francine Okundai.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud under the Pittsfield Township Ordinance. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, that you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights that are on that form?
No, thank you.
Please look at paragraph 5. You understand that you're giving up those rights as well as all the rights that are contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yeah.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yeah.
On the date of February 24th, 2025, location of 2000 Waters Road, that being the target, what do you do on that date that makes you think that you're guilty?
I went to Target.
Before you answer, but
Yes.
just hold it before you answer. Council approach, please. Are we? Hang on. I just want to check one thing. Okay. All right. All right. On that date and at that location, what did you do that makes you think that you're guilty?
I went to Target. I concealed jewelry and tried to leave without paying.
All right. The store was open to the public at the time?
It was, yes.
You didn't have anybody's permission to take that property, did you?
I did not.
And this property you took was property that was offered for sale by them?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation. Hold on. For a pre-sentence investigation and report. Sentencing in this matter will be set June 25th, 2025, 9 a.m. Are you a student?
Yes, I am.
Where?
University of Michigan.
Oh, that's second-rate school again, like the last one.
Right. I heard you the first time.
What'd you say?
I remember you telling her, the girl before me.
Yeah, it's okay.
Yeah.
Just my personal feelings. I realize other people feel different ways. What are you studying?
Economics.
What year are you going into? I guess you finished up, so.
I'm gonna be a junior.
Young lady, why'd you get yourself involved in this?
Well, it was, of course, a mistake that I've learned from and a stupid moment, one that really doesn't reflect my character. I went there to buy a birthday gift for my brother and a jewelry box for my mom, and I went there with that amount of money. So it was a careless moment.
Got it. All right. I don't have probation intake on that. Okay. All right. I'll let you work with your attorney as to how to get yourself set up with probation. We'll see you on the 25th. Okay.
Okay.
Guess this is an interesting lesson in economics. Anyway, all right. All right, young lady, take care. Thank you.
Thank you. Have a great rest of your day.
You too.
Thank you. Bye.
Court calls the case, People versus Jalen Powell.
Conrad on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Powell.
He's in there. Jalen Powell. Hello, you unmuted. You'll need to turn on the camera. Jalen Powell, he unmuted. Say.
I'll check.
Parenting, why is it none of your clients can work a camera today?
He's too busy trying to get his license back.
Jalen Powell. Really, man? All right. Well, you talk with him. I'll pass the matter. Hold on. All right. Court calls the case, People versus Ton Rayberg.
Conrad Silver on behalf of Pittsfield Township.
Mr. Rayberg? He's not checked in. Rayberg? No response. This is a hearing off of an order to show cause. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. Give a 10% privilege. That warrant will issue immediately. Court calls the case of the People versus Rashad Shafi.
Conrad Silver on behalf of Pittsfield Township. Your Honor, you'll recall, he was in court he was on his way to treatment back on May 21st on a separate drug paraphernalia case.
Okay.
And so he was in a car, if you remember.
Yes.
Video, and he was not driving. He was going to, I think, Bear River. So.
Yes. Okay. That's it. Okay.
Yeah, I'm here now.
State your name.
Rashad Shafi.
Okay. How's it going?
Good. Learning a lot of things I need to change and working on changing my way of thinking.
All right. Okay, so this is set for an arraignment. And you are before the court on a misdemeanor citation that does allege that on or about May 3rd, 2025, at the location of Carpenter Road near Hogback, Pittsfield Township, Washtenaw County, State of Michigan, that you did and were in possession of drug paraphernalia. You understand that charge, sir?
Yes, sir, Your Honor.
That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs and rehabilitative services if the court deems necessary. You understand that, sir?
Yes, Your Honor.
First question I have for you is, do you want to be represented by an attorney?
I don't really find it necessary at this point for this case.
Well, hold on. On his other case, is that a PD? His other case is a PD case?
Yes, we have multiple cases.
With him?
Yes.
So I'm going to ask you again.
Okay.
Because I'm sure they're teaching you at Bear River to make good decisions. So I'll ask you again. Do you wish to be represented by an attorney?
Yes, Your Honor.
There you go. All right. Okay. This is a PD case.
We would waive any further reading, standing to the charges, request another pretrial date.
All right. Defendant having waived formal reading standing mute. Court will enter a not guilty plea. Pretrial in this matter. When do we know when his other cases are starting? I know I gave some time on your other
I
case
think it was July 16th.
It's like,
because he was going to be at Bear River.
Yeah, everything was pushed out quite far.
yeah, I'll be in transitional housing, so I should be good.
So he's got a July 15th case, but he's also
His
got,
other case is 241-1133.
I have that as July 2nd.
July 2nd.
July 2nd.
Yeah, then he has, a couple felonies set for the 15th.
Got it. Okay. So the pretrial in this one I'll set for July 2nd,
Okay.
2025 at 9, or as your invite indicates. I'll set your bond at a $10,000 personal recognizance bond. I'll order standard conditions, no assaultive behavior, no possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. Of course, no use of alcohol, recreational marijuana, or any illegal drug. Okay, I won't order any testing. He's at Bear River, so. All right. We'll see you in about a month.
Yes, sir.
Hey, Mr.
Thank you,
Trevor.
Your Honor.
All right. You take care of yourself.
Thank you. Have a great day.
Court does call the case of the people versus Moses Toribla. Reba. Yeah, I messed that up.
Conrad Silver.
This is public advocate for Mr. Toribla, who gave me authorization to accept the offer on his behalf.
So, Your Honor, I move to add count 2 of double parking, and if you accept that admission, move to dismiss the original charge.
And you admit responsibility to, on behalf of your client, to the fact that he double parked a motor vehicle in Pittsfield Township on or about April 12, 2020.
Yes, Your Honor.
All right, court will accept that admission. Count 2, count 1 is dismissed. Fines and cost of $180. When can that get paid?
Candidly, I think he could pay it this week. I'm asking for 2 weeks just so I can make sure.
Make sure that he can do that. All right, pay it by the 18th? No, by the 20th,
Thank you, Your Honor.
June 20th, 2025. Court calls case People versus Kiri Vickerson.
Conrad Silver on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Vickerson. Mr. Vickerson, please state your name for the record.
Kyrie Vickerson.
Oh, iPhone 1. All right, I need a camera, sir.
Can you see me, Your Honor?
Yeah, now we can. Thank you. All right.
Your Honor, we are requesting an adjournment. He owes a ticket in Romulus, which amounts to about $1,000, which is why his license is suspended. He's working on getting that paid down, but just needs some time to do so.
All right, how much time does he think it's just one ticket?
I believe so.
It's actually 3 tickets, Your Honor. Because I called in, I was told to bring in $300 for the warrant, another $300 for, I believe, the plate, and then another $430 something for the insurance. So I think that $1,072 or $73.
Okay, so how long is it going to take you
So
to
at
try to
least-
come up with that?
At least about a month, Your Honor, if you can. I just started back
I'll give
working.
you. Okay, July 16th, 2025, 9 a.m. All right.
Okay.
Okay.
Thank you,
Thank
Your
you,
Honor.
sir.
Thank
Have
you.
a good one.
You too.
Court calls the case People versus Kazia Wilson.
Conrad Silver on behalf of Pittsfield Township.
Sorry.
Is it? Push it. There you go.
Sorry.
Your name?
Kazaya.
Was she correcting me all the way from back there?
Sorry.
I mean, before she even got all the way up here, she's telling me you said my name wrong.
People always get it wrong. I'm used to it.
Oh, but do you correct them?
Yeah,
Oh, okay.
it's like a habit.
So I don't feel so bad now. All right. It's Keziah. Okay, so it's long A. Gotcha. All right. Or long I. Okay. This is an arraignment. This is off of the show cause. Okay, ma'am, you are before the court on well, technically on a show cause, but you're here before the court on an arraignment on a citation that alleges that on or about February 23rd, 2025, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you drove while your license was expired. Do you understand the nature of that charge, ma'am?
Yes.
All right.
Sorry.
That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. And do you wish to be represented by an attorney?
Yes.
Pardon?
Yes.
Good, because I think we can resolve this today.
We are Assistant Public Defender Natalie Pate with on behalf of Ms. Wilson. We would waive any further reading, stand mute. And I did discuss this matter with my client as well as Mr. Siller, and I believe she will be accepting the offer of admitting responsibility to double parking, and count one will be dismissed.
That's correct, Your Honor. So I move that count two with double parking, and when you accept the admission, we dismiss the original charge.
Okay, Keziah. Do you admit responsibility to the fact that on February 23rd, 2025, location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you did double park a motor vehicle?
Yes.
All right, court will accept that admission to count two. Count one is dismissed. Fines and cost of $180. When can you pay that?
Okay. What's the longest time that's available? I'm not really sure how this works.
Me either. Okay. What's the problem?
The problem is, so after my birthday, January 21st, is when I was supposed to renew my license, but I never ended up doing it. So I had got 2 tickets for the expired license. And I have one like due now, where it's in Romulus, or just like they're gonna be a warrant out for my arrest or something. So it's like, it's gonna be like a lot of money to pay very soon. So is there any way we can like extend it?
Okay, young lady. I like how she threw in there. There's gonna be a warrant out for me. I'm just.
That's what they said in the paperwork.
Might be a contempt
So
warrant.
it's
Some
like-
cities do that.
I don't
It's
know.
nuts.
Well,
Yeah.
we could just put her in and wait, couldn't we? No, I wouldn't do that to you. She's like, what?
I don't even know what that is.
How much time do you need?
What's that?
I don't normally ask that, so.
Sorry. Can we
No.
try like 6 months?
Pardon?
Can we try like 3 to 6 months? Is that?
How many tickets you have?
I have 2, well, 3, including this one. So
Okay.
it's a double.
Are you working?
No, I'm not. I'm in college right now, full time. Actually, right now. Yeah.
That's what the problem is.
Yeah.
Where?
University of Michigan. Biochemistry.
No, it's like everybody, what is the problem going on there?
I don't know. She should be a Spartan.
Ew, no. Did you go there?
Yeah, I did.
Did you go there?
I do not like that school.
Wow.
Did you go there as well? Oh no.
I
Might
will
hold you
come
to
off
contempt.
this bench if you try to call me a Spartan. Young lady, I am a very proud Maryland Terror.
Okay.
So I don't like Michigan.
I'm so sorry about that. A lot of people don't.
I grew up in Ann Arbor, so I
Mm.
can't say I dislike them, but they're my second favorite school, maybe.
Second favorite.
Fourth. Fifth. How many schools are in the Big Ten? 18. Maybe they're about 17.
Mm.
All right. What? All right. So you're in school, not working.
No.
Jeez, oh, Pete. What are you studying?
Biochemistry on a pre-dental track.
On what?
Pre-dental track.
Well,
Yeah, no.
Gonna be a dentist.
Yeah.
And a dentist, an economist, and what was the other thing I need? Like a theater. Hey. How are your grades?
My grades are pretty good. My overall GPA is like a 3.1. It's pretty hard to get.
Yeah. Right. Do this.
And I'm like super.
Because it looks like you created a mess with tickets and everything, so. Keep up your grades, pay it by December 31st, pay it by the end of the year,
Okay.
okay? Don't make us come have to look for you.
Okay, I will.
Right? All right.
Thank you.
Thank you, Your Honor.
You're
Have a great
welcome.
day.
You do the same. If somebody else gets up here, it says they're from the University of.
I know.
Court calls the case, People versus Crystal Ortiz.
Conrad Siller on behalf of Pittsfield Township.
Right with that.
You got him or no? Ortiz? They're not here. What happened? They
were released to treat.
Oh, okay. So they'd already been before the court before a warrant issued, so. Bench warrant will issue for defendant's failure to appear upon.
14A District Court for County of Washington, State of Michigan is now in session. All those having been before the court draw near. The Honorable Judge Judge Simpsons presiding.
May be seated. I looked at Ally, but there you are. Just kind of, go
Good
ahead.
morning, Your Honor, actually, a lot of the people, Your Honor, this time to avoid any conflict with
Would
this
you guys like to
honorable court.
quiet down? Thank you. Go ahead.
Between this honorable court and the Office of Public Defender, we do not believe that any conflict exists, we have any points called out.
Thank you.
Good morning, Your Honor.
What? Go ahead.
Intern Malaika Fatima requesting to practice under.
Oh, whoa. Say that again.
Intern Malaika Fatima requesting to practice under
Oh.
MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
Okay. Have you been before me?
No, never.
I don't think you have. I need a spelling of your name. My recorder asked.
Malaika. First name, last name Fatima.
I told you. I did. I had it. And where are you from?
I'm originally from Canada, but I'm in the dual JD program at Detroit Mercy and Windsor Law.
Canada, what part?
Toronto.
Toronto. One of my favorite cities. Where'd you go to undergrad?
I went to Toronto Metropolitan University.
Well, hearing no objection, permission to practice is granted.
Thank you, Your Honor. We do not believe that there is any conflict between this honorable court and our office. And if any conflict were to arise, we waive that conflict so that this honorable court can hear our matters.
The court, for its part, also does not believe that there is conflict. That if the court rules or the case is decided thereunder, to the extent a conflict may exist, given the waivers, the court will consent to hear the matters. The court does call the case People of the State of Michigan versus Anitra Comer.
AP Richmond, for the people.
Good morning, Your Honor. Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Stephanie Cannon on behalf of Ms. Comer.
Permission to practice is granted.
Thank you so much, Your Honor.
Ms. Comer, can you state your name, please?
Anitra Comer.
All right, thank you. Yes, okay, and what are we doing on this?
Your Honor, we are requesting to adjourn for 2 weeks so that we can have a client consultation in person with Ms. Coomer at the Women's Correctional Facility.
All right. Is 2 weeks going to be enough to work through the process? Al,
I believe so.
think so? All right. 2 weeks ago, that's what.
Thank you.
Probable cause conference in this matter will be adjourned to June 26, 2025, 9 a.m. Bond will continue. Thank you.
Thank you.
Court does call the case of the people versus Aiden Evans.
Ally Zend on behalf of the people, Your Honor.
Morning, Your Honor. Chris Eastup appearing on behalf and with Aiden Evans, who is present. Mr. Evans, you step up and state your name for the record.
My name is Aiden Evans.
I have a plea form in front of me. Is that what we're doing today?
It is, Your Honor.
The plea form indicates that the defendant will be pleading guilty to the charge of illegal entry, the 90-day offense. Upon a successful plea to that charge, count one would be dismissed, and that the parties agree to sentencing under HIDA. Of course, the court can't bind the sentencing judge. All right. All right.
That's correct, Your Honor.
I haven't sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the true self you got.
Yes, sir.
State your name.
Aiden Jack Evans.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of illegal entry. That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes, sir.
All right. You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I plead guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal upright.
Yes, Your Honor.
Are you on probation or parole?
Parole, Your Honor.
No.
Oh, no.
That's bond.
Parole?
Bond.
Okay.
That's how new he is.
Yes. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will? Yes.
Yes.
And because you believe that you're guilty of this offense?
Yes.
May 25th, 2025, at the location of 1043 North Main Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I entered the premise without permission from the resident.
So you entered somebody's house,
Yes, Your Honor.
apartment, and you didn't have their permission to enter those premises,
Yes.
and you had no property interest or other thing in that property. Now, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
That's satisfied with.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at the district court probation. Sentencing will be
July 1st at 9 a.m. with Judge Valvo.
July 1st, 2025, 9 a.m. before Judge Valvo. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you.
Do we still having them check out at the window after a plea, or do they just get their stuff? They make up their own?
I don't. No. They should always check out Corey Dan.
Thank you very much.
Really? Just do what she says. Court calls the case, People versus Terrell Green.
APA Rachel McDuffie for the people.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Green. Mr. Green, please state your name for the record.
Terrell Green. Thank you.
Hello.
2 are arraignments. Got it. Okay. All right, Mr. Green? Yes. I have, you're here on one case. I have 2 other cases where you need to be arraigned on those cases. And so we'll go through that process if they put my paperwork in here. Starting first with the case 25 F5 5605. In that case, sir, the complaint alleges that on or about May 3rd, 2024, at the location of 225 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan, that you did commit the offense of uttering and publishing. Do you understand the nature of that charge, sir?
Yes.
All right. That is a felony punishable by up to 14 years incarceration. You understand that, sir?
Yes.
All right. On the other matter, the case ending in 600. In that case, if I can find the complaint here. That complaint alleges that between the dates of April 10th, 2024 and April 11th, 2024, at the location of 423 East Duncan Street in Manchester, Washtenaw County, State of Michigan, that count one alleges that you did steal or retain without consent a financial transaction device. Do you understand the nature of that charge?
Yes.
That is a felony punishable by up to 4 years incarceration and a $5,000 fine plus court costs. Do you understand that?
Yes.
Count two alleges the offense of breaking and entering a vehicle with the intent to steal property less than $200. You understand that charge, sir?
Yes.
All right. There is a second or subsequent offense notice, which makes this a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property stolen. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. First question I have for you, sir, is do you wish to be represented by an attorney?
Yes.
All right, these are public defenders.
Your Honor, regarding both arraignments, we waive formal reading, stand mute to the charges. And I'm sorry.
Go ahead.
On all 3 cases, I'd request a pretrial date.
Probable cause conference.
I'm sorry, probable cause conference. Yes,
All right, you waive time limits.
yes, Your Honor.
And you're asking for an adjournment on the other one.
Yes, he's going to be in Livingston, I believe, until September 30th.
Got it.
And we would just want to review everything together and see what happens. Obviously, these are new cases.
All right. On these cases, I will adjourn the one case and set the probable cause conference for June 26, 2025 at 9 a.m. All right. And I'll get to the bond issue. Let's start with the Ann Arbor case first. Anything you want to say regarding the bond?
No, Your Honor, I just asked for a nominal bond. As I said, Mr. Green is going to be in Livingston County until the end of September.
Anything from the people?
Your Honor, on the, pardon me, on both of these cases, we requested a surety bond of $7,500. And with the reasons explained below, there's a no go-to request on this file for the DFCU financial branch at 25 Briarwood Circle. And I don't believe there's any no contact. That's the only other condition outside of the normal bond conditions on this file.
I'll indicate he's not to go to 225 Briarwood Circle. On that case, I will set his bond at a $5,000, 10% bond. I don't know that there's a necessity to have a cash or surety on this case. I will order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol possession of no alcohol consumption or possession. Also, that applies for recreational marijuana and no illegal drug. Dated, I said 6/26.
Yes, sir.
On the other matter,
There is a request for no contact with Susan Furda, Furda. as she is a victim in this case. I also requested a no go to, actually within a 1 mile radius of 423 East Duncan Street in Manchester, as this was a case of break-ins with multiple homes in that neighborhood.
How was her last name?
Hey.
I have no objection to that, Your Honor.
Bond in this case will be set as a $5,000, 10% bond. It'll indicate that there's to be no contact with Roberta, and he's not to enter the township of Manchester. Anything else on that?
Run that no go to as well on that file.
He's not to enter the township of Manchester.
Oh, okay, I didn't hear you. Thank you.
Nothing else for me, Your Honor.
All right, thank you. Thank you, sir.
We'll be in touch, Mr. Green.
Court calls case People versus Mary Collins. Aye. Permission to practice is granted.
Good morning, Your Honor. Edward Drukas for Mary Collins this morning. I'm standing in for the attorney record of Kyle Burdell. I have a substitution form for the court that's signed. Not in the file, but will be.
Very good.
And this morning, I'm asking for an adjournment. I understand the discovery got sent over yesterday. Still need some time to go over that. I don't know if there's any outstanding discovery. I'd ask for an adjournment at the court's discretion.
No objection, probable cause conference will be adjourned to June 17th. 2025, 9 a.m. That's a Tuesday. Bond will continue.
Okay, thank you.
Thank you. Court calls case People versus Ardeen Henderson.
And for that is for the people.
Good morning, Your Honor. Kerma Dadish on behalf of Ms. Henderson, who is appearing by Zoom. Ms. Henderson, can you please state your name for the record?
Ardeen Henderson.
Thank you.
You're welcome.
Requesting an adjournment.
Yes, Your Honor, we are going to refer her to our AIM division and to continue plea negotiations with the prosecutor's office.
How long is she going to be in Wayne County? No.
A while. I believe they're doing a competency report there. So it's gonna take a minute.
So
we can adjourn it out
So there's a comp on her case there.
there. Yes, I'm debating whether I need to talk to
Council approach.
the seniors in our office.
Council approach.
Yeah.
Or you can keep talking. Council approach.
Oh, council approach.
I think that's an approach.
Okay, on this case, what I will do is I'll adjourn the probable cause conference, understanding that I may get a request for a competency or forensic evaluation to coincide with the one in Wayne County, but I'll adjourn this to, we'll just do July 10th initially, and then we'll see where we are.
Thank you, Your Honor.
July 10th, 2025, 9 a.m. On continue.
Thank you.
Court calls case of the People versus Aaron Fromm.
Sherilyn Foster Tucker on behalf of Aaron Fromm.
Aaron Fromm.
And Your Honor, we're just requesting a brief adjournment to review discovery.
Probable cause conference will be June 17th, 2025, 9 a.m. That's Tuesday. Bond will continue.
Thank you, Your Honor.
Good answer. Court calls case of the people versus Winona Harvey. Really? Ma'am, state your name.
Winona Michelle.
Thank you. Where is she? Somebody needs to get her in here or have somebody that can cover this case now. Thank you, Mr. Gaddy.
Morning, Judge Mike Gaddy on behalf of Ms. Harvey. You spoke with her?
Yes.
What's gonna do?
So we gonna talk about somebody that I hit.
Okay, no, did she tell you whether the case was gonna go to?
Yeah,
Did she say she was gonna adjourn it?
no.
Hold on. Yeah, I think this may be a referral.
Parental.
Yes, Your Honor, I'm trying to.
She told me that I'm here about a case about putting my hands on an officer at the correctional facility.
Okay.
That's what I'm here for today.
Yeah, Your Honor, we're going to refer this for competency. I'll prepare the competency referral and the, excuse me, criminal responsibility referral forthwith.
Forensic evaluation is ordered. I'll set a competency hearing for 90.
August 28th.
90? Okay. Say it again.
August 28th.
August 28th, 2025.
Thank you.
9 p.m.
Thank you, Your Honor.
I have a court date August 28th,
Bond will
2025.
Yes,
What month is this? June?
this is June, yes.
It comes after June.
Well, I'll come visit you in the back, okay?
Okay.
July comes after June. Okay.
Court calls case People versus Charles Tingley.
Your Honor, good morning. Joe Simon on behalf of Mr. Tingley, who should be by Zoom. Is he?
Tingley?
I am Charles Tingley.
Okay, I'll need a camera.
It was just here.
All right, there he is. Okay.
Your Honor, I'm informed that the long-awaited contract with Detective Babbage in the county has been signed. And we are asking the court to grant our request for another adjournment. We're trying to be one of the first cases in line since we've been waiting, but I can't assure you of that. So
What's the anticipated time frame?
well,
The only information I have is that I believe the contract has been signed, and so he's gonna start scheduling them.
Got it.
So maybe 3 weeks, if that's.
unfortunately, I'll be gone at that time. So, but
Beautiful. We'll set it then.
thank you, Your Honor. Very kind.
No, I want you around because you're around and Miss Landy's there. We learn things.
We do further our education. That is true.
I'm so full of nothing. I am. It's a joyous time when you learn things.
It is.
So
That is true.
what date do you want?
Your Honor, could we possibly go to July 10?
Is there any objection from the people? Probable cause conference, July 10, 2025. 9 a.m. Bond will continue. Yes, I think that's the quietest Londy's ever been. All right. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Molly Fox.
Ellen Dennis appearing on behalf of Molly Fox.
Oh. No. Your name?
Molly Fox.
All right, what are we doing?
Well, Your Honor, this is a PCC conference and we've had many adjournments, but what I would like to see happen today is that the court would reinstate Ms. Fox's bond and let her get out. And I would say that Jacob Kennedy and I have had many discussions about resolution here, but we haven't really come to a conclusion. And he sent me the paperwork on the recovery court, which I discussed with Molly Fox. I went to visit her on Sunday and talked to her about it. And we went through some of the responsibilities and what would be expected of her if she be accepted in such a court. I believe that she could do that, but only if she has strong family support. So I urged her to, what I would like is for her to get out so that she can talk to the family members, which are, in my opinion, their involvement and support is absolutely essential for her to be able to complete the recovery court program. The other matter is we have never really come to a conclusion as to what the plea would be if she were to go into the recovery court. So I would like to have an adjournment of the PCC, but I also would like to have her released again on bond so that she can do these things and come to some kind of conclusion.
Well,
I thought he
gotta
was.
stop using cocaine.
Well, of course she does. Absolutely. And she, she did complete the first 8 weeks successfully of the Dawn Farm program. She doesn't, that's the other thing. She doesn't know whether they would let her back into the program or
They
let
should
her.
actually be able to re-enroll.
Okay, so what do you want me to do with, you want this adjourned?
Well, yes, but I wanted to be adjourned with a release of her from custody and go back on the bond if possible. Because she's had
Okay,
kind of,
I don't negotiate that way, but that's okay. I don't know that I'll release her. I don't know what you want me to do.
well, as I did make out an adjournment paper.
Do people have a position on bond?
Yes, at this case, it's a situation where the defendant was intoxicated, that's why she passed. And then while she was on, I don't think that a release is appropriate without a rigid substance abuse plan, treatment plan in place, which there is not.
Well, I'm informed that the Dawn Farm back in. I don't know for sure. I can't represent to the court that that's possible, but she seems to think it is. And that's a pretty, she was attending AANA once or twice a week. She was doing group program and she did that for 8 weeks successfully. And then, she had the incident where she used cocaine again. 2 incidents, sorry.
Yeah. Probably more because there's a lot of abnormal creatinine. She was using. So the issue from the court standpoint is this. I am not going to release her or change her bond until there's something in place so that she's at least receiving some treatment or something along those lines or some program. It's not going to happen. Give you time to put that in place or to try to figure out what that's gonna be. And I'd suggest that you talk with the prosecutor's office and try to work something out that is structured for this individual. So your motion for bond modification is denied. I will adjourn this matter to June 26, 2025, 9 a.m. The bond is
Your Honor, just for my own information, if I were able to determine that the Dawn program would let her back in or let her restart or whatever, would that suffice from the court's point of view?
Here's what I'd suggest. If you were to confirm that type of, that there would be something in place for her treatment, I'd suggest that you get with the prosecutor's office, see if the two of you come to some type of agreement. Can't, you can file a motion, I'll hear it, or we'll hear it on the 26th. Okay?
Thank you, Your Honor.
Thank you. Case, People versus Christopher Gilmore.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Burnwell standing in for the attorney of record, Kareem Johnson.
Your name, sir?
Christopher Gilmore. Good morning, Your Honor.
Good morning. And you have no objection, Barnwell stepping in?
No, no, sir.
All right. All right, what do we do?
Your Honor, Mr. Johnson has indicated that he received all discovery and he wishes to set exam dates on both cases.
People have the witnesses available on the 17th.
My best, Your Honor.
You said June 17, Judge?
Yes, sir. Yes, ma'am.
When did
Preliminary examination in these matters in person, June 17th, 2025, 9 a.m. That is before Judge Moore.
Today. If I can leave.
Your Honor, there's an ongoing discussion because my client wishes, Mr. Johnson's client wishes to have permission to leave the state. However, I'm indicating to him that the court would want that in writing. And the court would want
What's
defense
his
counsel.
purpose for leaving the state?
Right.
I'm about to turn a new leaf, Your Honor.
Pardon?
Can't just,
I'll-
the case has to be resolved.
All right.
You just want to leave the state?
Yeah, I'm tired of getting in trouble. My summer, I don't want to spend my.
You don't like the great mittens
Okay.
to the north? Go ahead. You just want to leave the state while criminal charges are pending? Probably is not going to happen.
All right, thank you so much.
Yep, okay, great. That's, glad we're,
Can't do it.
thank
I
you.
have a good one. Yeah.
That was easy. Court calls the case, People versus Marvin Sullivan.
James Fyfelski appearing on behalf of Mr. Sullivan, who is approaching. Can you state your name for the judge, please?
Marvin Sullivan.
Your Honor, at this time, we will ask the court to set this for preliminary
All
examination.
discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
Is it any way possible to go 1 week to the 24th? And I will represent the court. I understand that Mr. Sullivan has a hearing in front of Judge Conlon on an extradition on the 25th. So I don't think this would be holding him any longer than on this case that he would be otherwise.
I'll leave it to the court's discretion.
Preliminary examination in person, June 24th, 2025, 9 a.m. before Judge Freshour. Bond continued.
Thank you, Your Honor.
Court does call the case of People versus Alexander, is it Bounds?
Your Honor, Student Attorney Kara Rosengren
under the supervision of APD Stephanie Cannon on behalf of Mr. Bounds. Mr. Bounds, could you state your name for the court?
Alexander Bounds.
Your Honor, we're requesting that the court set a date for Mr. Brown's preliminary exam.
All discovery is complete.
Yes.
People have their witnesses available the 17th. Preliminary examination in person, June 17th, 2025, 9 a.m. Actually, that's at 12 noon. That is before me.
Thank you, Your Honor.
Bond continued. Thank you, sir. That's in person.
Yes, sir.
Court does call the case of the people versus Elliot Kazan.
Ashley for the people.
Oh, you're still here.
I return, Your Honor.
Oh. Picking
Joe
up knowledge. I'm sorry.
Joe Simon on behalf of Mr. Kazan. Your Honor.
Your name, sir?
Elliot Kazan.
Thank you.
Your Honor, I may request approach the bench, but I'm a little afraid. The last time we were here, we were about ready to enter a plea. Then we had our bond issue. The people have maintained the offer. My client wants to accept it. But could we approach briefly?
Yes, you can.
Thank you.
Oh, it's both you two.
Yeah, that's all. And to be clear, Your Honor, my client did fill out previously an advice of rights form that I
Wait, that was riding lawnmowers.
Fine,
go ahead.
I'm sorry, Your Honor. My client did previously fill out an advice of rights form, but I re-reviewed that with him. And he knows that he previously filled out a sentencing judge waiver, but he also knows, I've reviewed that with him as well. Please write it in, please.
All right, the plea form in this case indicates that the defendant will be pleading to 3 charges. That he will be pleading to the possession of a firearm under the influence, the actual stated count 3, as well as an addition, and that's the 93-day misdemeanor. He will be pleading also to operating while visibly impaired first, a 93 days. And will be pleading to attempted possession of a loaded firearm in a motor vehicle. And I believe that's a 1 year.
That is a 1 year, Your Honor, and I do believe mandatory forfeiture is a component of the offenses that the defendant will be pleading as well.
That's 1 year. Fines on that are,
1,000?
yeah, I think so. I think that's right. All right. And then counts 1 and 2 would be dismissed. And
The people are agreeing at the time of sentencing not to.
no upfront jail if defendant remains compliant.
Correct.
Okay. All right. May I have it sworn?
Raise your right hand. Do you solemnly swear in the firm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
State your name.
Elliot Kazan.
All right, sir. Is this court's understanding that you are going to be pleading guilty to 3 misdemeanor charges? Is that your understanding?
Yes, Your Honor.
All right. First charge is a stated count 3 of possession of a firearm under the influence. That's a misdemeanor punishable by up to 93 days in jail, a $100 to $500 fine plus court costs if you were using and or discharging the firearm. Also mandatory forfeiture of the weapon or device. You understand this?
Yes, Your Honor.
All right. Also, this court's understanding you're going to plead guilty to the charge of operating while visibly impaired first offense. That's a misdemeanor punishable by up to 93 days in jail, $300 fine plus court costs. Court could order rehabilitative services or any community service support deems necessary. Court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. Also, count 5 of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to a $1,000 fine plus court costs. You understand that? And also mandatory forfeiture of the device. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
All right. To the charge of possession of a firearm under the influence, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
To the charge of attempted possession of a firearm in a motor vehicle, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of right form previously, is that correct?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today in the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
June 22nd, 2023, at the location of Jackson Road near Stabler Road, Scioto Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much, if you recall?
5 to 6 beers.
Were you stopped by the police or was there an accident?
I was stopped by the police,
Why'd they stop you?
rolling through a stop sign.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the station or hospital for a blood draw?
Yes, Your Honor.
And what were the results of that blood draw?
0.095 blood alcohol level.
Do you have any reason to dispute those blood test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
In that motor vehicle that you were driving, did you have a firearm?
Yes, Your Honor.
And where was it?
In the glove box.
All right. And did you have authority to carry that firearm in that fashion?
No, Your Honor.
And I think that's the time you were under the influence and you had possession of that firearm.
Yes, Your Honor.
Counsel?
Was the firearm loaded?
No, Your Honor.
Well, actually, what?
Yes, yeah, it actually.
Okay.
Yeah,
Was the
yes, ma'am.
firearm loaded?
Yes, I had, yes,
All right.
In the magazine, not the chamber.
yes. In the magazine, not the chamber. Yes.
But nevertheless, that constitutes.
Yeah. Same, yeah.
All right. Now, counsel, have I complied with the court?
I'm satisfied, Your Honor. Thank you.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be. Hold on a second. We're on the wrong thing. Yeah. Give me that sentencing date again.
June 16th.
Sentencing, June 16, 2025, 9 a.m. Fresh hour. All right, as to bond.
Your Honor, we are requesting the court reinstate my client's bond. His original bond was 5,000, personal recognizance 5,000. He was ordered to community corrections to participate in sober link testing. The last time we were here, we offered to switch from that to a scram tether. That's our request, is to reinstate bond with the scram alcohol tether.
Anything from the people?
Your Honor, the people's concern is that the defendant not be consuming, so a scram tether will accomplish that goal this time.
I'll reinstate the defendant's previous bond condition. So he set his bond $5,000 personal recognizance bond. The defendant is to be placed on a scram tether prior to his release. I will sign that order, and I know you're trying to work through that, so we'll sign it and make sure that it gets over there.
Thank you very much, Your Honor.
Thank you, Your Honor.
All right, thank you.
Thank you.
Court does call the case People versus James Sharp.
People.
James Fifelski, appearing on behalf of James Sharp.
Mr. Sharp, can you state your name, please?
James Glenn Sharp, Your Honor.
Thank you, sir. What are we doing?
Your Honor, we're asking the court to set this for preliminary examination. Mr. Sharp does have sentencing on a federal case on June 17th. We'd ask the court to set it for the 24th.
Is all discovery complete?
Yes, Your Honor.
Would the people have their witnesses available on the 24th? Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Wash.
Thank you very much, Your Honor.
We'll continue. Thank you. Court calls case People versus Sterling Paris.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Barnwell on behalf of Mr. Sterling Paris.
Your name, sir?
Starling Paris.
Thank you.
Your Honor, may we-
Okay.
Oh, but can you come talk to me?
All right. Thank you.
I have other cases in here.
Court calls the case People versus Jody Williams.
Ready, Your Honor.
Alexander, on behalf of the people, Your Honor.
You're just everywhere.
Pardon?
You're everywhere.
It's been tough. I'll get my steps in. Joe Simon on behalf of Ms. Williams. Jody, state your name.
Jody Williams.
Thank you.
Your Honor, we're asking the matter be set for preliminary exam. And because you always know I never cause trouble for the court, what is the earliest possible? Because my travel dates are both on successive Tuesdays. I'd like to have this sooner than the 24th if possible. I travel on the 24th and then on July 1st, so.
Oh, so you want us to accommodate your schedule
If
on
possible,
everything?
if possible.
That's an arrogance I haven't seen in a long time. Will the 17th work for you?
Yes,
All right. So
thank you.
discovery is complete.
Yes,
Would the people have their witnesses available the 17th?
We'll do our best, Your Honor.
All right. Preliminary examination in person, June 17th, 2025. 9 a.m. That is before Judge Moore.
wait for me outside, okay? Thank you. Oh, sorry.
Bond will continue. Thank you.
Thank you, Your Honor.
Bye.
I'll see you on the next docket on Zoom, but Your Honor, I will say this, it's always an uplifting experience.
Back at you. That's all I got. Court calls the case People versus Wesley Brand.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Barnwell on behalf of Mr. Wesley Yonder Brand.
All right. What are we doing? I think I have a conditional release
They're gonna address
violation.
violation.
Yes,
Because
Your
you
Honor.
made a call and they're describing all
Jail
this
calls. On our
allegedly.
records, we have 17 complete calls to the victim since he was arraigned, as well as 84 total attempt in credit. So he's tried to call her a total of 84 times, with 17 of those calls getting
Counsel.
Your Honor, this
Answer the
is,
bond violations. Why don't we start there?
Your Honor, this is, didn't have enough time to talk to him about the particular alleged bond violation, Judge. I did read it yesterday. It was sent to me and I did read the bond violation.
And does he want it set for hearing? Or?
One
does
second,
he
Judge.
admit to the violations?
Yes, Judge.
What are we gonna do?
Wishes to set it for a hearing, Judge. I'm assuming it's another day.
Yes.
Okay.
Set a bond violation here. Gonna have room on 12.
Yes.
So I'll adjourn the probable cause and set a bond violation hearing for June 12th, 2025
Split second,
at
Judge.
3 p.m.
I'm here.
Pending that hearing, defendant,
I'm here, Judge. I'm here in front of this court that same day.
all right,
So
so that's at 3 PM. And pending that hearing, defendant's phone privileges are hereby ordered revoked. It's bond, however, is continued. Thank you.
the judge will set an exam day on that day.
That's the way.
Thank you.
Court calls case People versus Derek Stewart.
APA Rachel McDuffie for the people.
Mr. Derek Stewart.
The public defender case. No one was assigned to it.
No one responded.
I'm here, Assistant Public Defender Jay Bellinger, on behalf of Mr. Stewart, it sounds like. Derek Stewart.
He's here.
Okay. Thank you. And Your Honor, obviously, we haven't, our office has not had any time to review his police report with him and the evidence, so I would.
Well. What is this say? Except for confidence.
It's just on the bond.
It's here on the bond, by on the bond, by. And you know nothing about those, I take it.
That's correct, Your Honor.
Is there a report? Oh,
That's all.
Counsel.
What?
Okay, on this matter, the defendant is in custody on this case, I think, as well as others. He's awaiting a review hearing, which is set for July 22nd, 2025. Well, he wouldn't have been in. I think at this point, he's being held on this alleged bond violation, because otherwise it wouldn't have occurred that way. So at this point, what I will do is I'll continue the defendant's bond as being revoked for the violation pending a hearing on this. There's a report that needs to be prepared, as well as that, as well as shown counsel the preliminary results, I guess, of the bond violation, which is possession of a weapon. So I'll set a bond violation hearing on this matter for June 26, 2025 at 3 PM.
Thank you, Your Honor.
All right, thank you. Court calls case People versus Anton Brooks.
Good morning, Your Honor. Wendy Barnwell, standing in for the attorney of record, Mr. Kareem Johnson, on behalf of Mr. Brooks.
Thank you, sir.
Anton Brooks.
You have any? Barnwell speaking. Yes. All right, what are we doing?
Your Honor, Mr. Johnson needs an in-person PCC on June 26th. He told me that's when he's available. He said, however, because he doesn't have all
Go ahead, I'm listening.
all the discovery.
Oh, hold on. So he doesn't have the discovery, the 26th, he's just asking for an adjournment of the probable cause
PCC,
conference.
Judge.
Okay, thank you. Probable cause conference will be then adjourned on June 26, 2025, 9 a.m.
Thank you, Judge.
Bond continued. Thank you. Court does call the case People versus Robert Brascom.
Great Cat House is the prosecuting attorney on behalf of the people.
Good morning. This is Public Defender Lauren Perry on behalf of Mr. Branscombe. Mr. Branscombe, please state your name for the record.
Robert Branscombe.
Your Honor, we're asking for an exam date, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
I believe so, Your Honor.
Preliminary examination in person, June 17th, 2025 at
12 p.m. for Judge Simpson.
12 p.m. That's before me.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continue.
All right, thank you.
Thank you. Court does call the case People versus Anthony Alfaro Siquejas.
If you Richmond District.
Your Honor, Assistant Public Defender Nicholas Bukovich on behalf of Mr. Alfredo Correjas. You can say your name for the record.
Anthony Alfaro, KS.
Got it. All right.
At this time, Your Honor, I'll be asking for a brief adjournment. He has another probable cause conference state scheduled with you next week on a new matter that is the basis for the alleged bond violation. So we are asking for the adjournment to be able to track those cases together.
He has a what?
A probable cause conference with you on June 12th.
On June 12th.
So next week. So we're asking for that brief adjournment so the cases can track together.
And that case is what result.
Is what I believe is the alleged bond violation.
That's what I was trying to follow with what you had indicated. So
Yes,
we'll
sir.
deal with that bond violation. I'll grant the adjournment.
Thank you, Your Honor.
I'll adjourn this probable cause conference, June 12th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Mr. Bukovich, that went much better for you than last week.
It did.
Maybe it can continue.
That's the goal, Your Honor.
Because when you came up, I got scared. I just didn't know. Court calls the case, People versus London Daughter.
Andrew Childers appearing on behalf of the people, Your Honor.
Madam Judge, on behalf of Mr. Daughtery.
London Daughter.
It's two cases. What are you looking to do?
Your Honor, we are going to be adjourning. I believe we don't have discovery on one of the cases. So we're waiting to receive that from the prosecutor's office.
And I'm presuming that's on its way.
I believe it's the 1318, or one of the legal assistants or paralegals in our office emailed, I believe Tuesday, and then they looped you in and said, have you guys requested it? It's from a couple of years back, but we don't have discovery on one of them.
All right. Well, what I'll do is I'll adjourn probable cause conference June 26, 2025, 9 a.m. Let you guys try to get that cleared up. I see that the one is a 22 case, so sure they'll be able to find it, but all right.
Thank you.
We'll continue. Thank you, sir.
Thank you. Okay.
Court calls case People versus Jerome Burns.
Morning, Your Honor. Very Assistant Prosecuting Attorney on behalf of the people.
and Assistant Public Defender Tanasi Carrier can really, Your Honor, on behalf of Mr. Jerome Burns.
Nice of you to show up. Just thought I'd throw that out there.
I figured it was coming your way.
Mr. Burns, state your name for the record, please.
Jerome Burns. Thank you, sir. All right, what are we doing?
So, Your Honor, we are here for two matters today. I think we're doing a sentencing on the bond violation for Mr. Burns, as well as the probable cause conference. In regards to the probable cause conference, Judge, we are asking that this matter be respectfully set for preliminary examination.
You have all of the discovery.
To my knowledge, Judge, yes, we do.
We'll have the witnesses available to 7.
We'll do our best here.
All right, why don't I do this? I'll set preliminary examination, June 17th, 2000. 9 a.m. Or, well, why don't I do it this way? I'm gonna set this one at 12 p.m. for me since it's usually on the other day. And I'll adjourn the sentencing on his bond violation to that same day.
Okay.
Bond will continue. Court does call the case People versus Tequila. Evans, Guy. What?
She should be on Zoom.
Tequila's on Zoom? Is she here?
Oh, okay.
I don't see her name. Oh, there she is. Tequila, stop coming down.
She wished she could have.
Sure. Tequila, can you state your name?
Tequila Evans Guy.
Good morning.
Good morning.
What are we doing?
So, Your Honor, when we were here last time, I incorrectly filled out the plea form where I said that I was adding count 2 and dismissing count 1. And I meant to put I was adding count 3 and dismissing count 1 and 2. So that is why you're here today.
It's also my bad because I didn't notice that on the plea form. So it's count 1 and 2 that are getting dismissed.
Got it. We're coming back just to correct the record. What I will do then is I will sign sort of dismissing counts 1 and 2, accepting the defendant's plea to count 3, and then set the sentencing date. I'll set the sentencing date 7/10/25 at 10 a.m. before Judge Washington. And what I will do is I'm accepting the plea to count 3, non-protunct to May 22nd.
Do we need to turn in the form or not? The correct
Yes, why
report?
don't you?
We don't need the advice of rights again, right?
You don't need
Okay. Thank you, Your Honor. Thank you, John.
Thank you. That should clarify everything. Court calls case People versus Curtis Damon.
Good morning, Your Honor. Lord Yaki, Assistant Public Defender, with and on behalf of Mr. Damon.
Good morning, Ms. Sharkey.
Good morning. Mr. Damon, could you state your name for the court?
Yes, Curtis Mitchell Damon.
Your Honor, I did fill out a green sheet. However, I am asking if this court would consider allowing Mr. Damon to be released to treatment. He
To
is
inpatient treatment?
to inpatient.
I'm gonna have no objection to any order allowing somebody to release.
Okay, thank you, Your Honor. I think that will help immensely, and I know Mr. Damon is really serious about that.
All right.
Oh, and we would request an adjournment of the probable cause conference for him to get into treatment. I think that will help discussions with the prosecution about how to
Do
resolve.
they have a timing to try to get him there or how's?
I don't have any specific update as to timing.
Well, why don't I do this, then I'll adjourn the probable cause conference to June 26, 2025, 9 a.m.
Thank you.
See what progress they make.
Thank you, Your Honor.
Thank you.
So a quick question regarding bond, because Mr. Damon's tether, I mean, they closed his file essentially because he absconded as far as the scram is concerned. What would be the status of that order? Would the court wait to see if
They closed it. They closed out his tether.
Yeah, we have a report from May 13th, I believe, where they had lost contact with Mr. That's reported for a scram download April 9th. And so where that particular tether might be located and whether we would need a new order, depending on what happened with his treatment. He said he still has it.
And thank you, Ms. McDuffie, for bringing that up, because I actually, in the proposed order I drafted, I did put in all prior bond conditions remain in full force and effect. I didn't mention anything about the tether, so.
Okay, I'm just looking at it. That was a GPS tether.
Scram.
No, alcohol.
It was a scram tether?
Yes.
Yep.
Okay.
Yeah.
So what I'm gonna do is I'll just add it, I'm adding a sentence to the order I signed. He can be released to inpatient treatment program once a bed becomes available with a scram tether prior to release. Okay, so I'll add that and I will also sign a new order for a scram tether. So that way, if a bed becomes available, he gets a scram tether. Okay,
Thank you, Your Honor.
and I'll set it for June 26, 2025, 9 a.m. Bond continue.
Thank you. Thank you.
Court calls case people versus round two Francis.
After letting people.
Suze,
Oh,
seriously? Okay.
Oh, it's Francis. Oh, Assistant Public Defender. I thought they were bringing up my other client, Judge. Assistant Public Defender, Chinati Kerry, I can really, on behalf of Mr. Burns, to Francis, Judge. Can we approach?
Around to Francis.
Thank you. Record should reflect the advance conference in this case. Probable cause conference will be adjourned June 26th, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, Ms. Francis. Court does call the cases of the people versus Siobhan Vincent.
And Assistant Public Defender, Chinati Kerry, I can really, Your Honor, on behalf of Ms. Siobhan Vincent. Hi, say your name for the record. My name is Siobhan Vincent.
No finding it.
Get right behind you.
All right.
Today is a time and date set.
Your name is?
Oh, my name is Siobhan Vincent.
Thank you. All right, yes, go ahead.
Today is a time and date set for a competency hearing in all matters. And the people are in receipt of a report from Center for Forensic Psychiatry dated May 15th, 2027, authored by Candace Shield, PhD. And we would stipulate to the entry of that report and ask that the court make a finding based on
Any other evidence for the defense?
I apologize, Your Honor. You asked if there was, Your Honor, we have had an opportunity to review the report as well. We are going to stipulate to the findings in the report, and as per the probable cause conference, Judge, we're asking for an adjournment as we continue our investigation.
All right. For the purposes of the competency, defendant, based upon the review of the report, the defendant is competent, will be found competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against her, of the charges against her, and can rationally assist in her defense. Therefore, the defendant is deemed. I will set a probable cause conference then. Would the 26th work for you?
That we will make it work, Judge.
June 26th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue.
I also want to expose these people because they're lying on me. I'm not no demon. I'm not no monster. These people were hurting my daughter. They were sexually assaulting my child.
You'll have an opportunity.
It's too much. I'm not no demon. They hurt my baby and they're hiding this. They're covering it up. The state of Michigan is hiding and covering this up. They hurt my child and I'm looking at them. Oh, they're gonna be-
Thank you. And Ms. McNeely, I'll need additional orders on this.
The findings, right?
The findings, yes. Court does call the case of People versus Lamine Kaba.
Assistant Public Defender Natalie Pate on behalf of Mr. Kaba, who may be present via Zoom.
See ya. You got a copy?
I do not. I have one unnamed individual client.
Lamine Kaba? No, I don't have that.
Your Honor, I do not have an explanation for his failure to appear. I was unsuccessful in reaching him between the last probable cause conference and today's date. I did also make attempts to contact his mother and left a voicemail with her as well as provided her with the Zoom information. I have no further explanation for his failure to appear and for the record would respectfully request an adjournment of this probable cause conference.
Bench warrant will issue for defendant's failure to bond is set in the amount of $10,000 cash security. That warrant will issue.
Oh.
Does call the case People versus Vincent Dunlap.
Public Defender Jay Bellinger, on behalf of Mr. Dunlap. Miss, can you please state your name for the record?
Vincent Dunlap.
Thank you. So what are we doing?
Your Honor, we were just asking to set this for preliminary examination today.
Discovery is complete.
Discovery is complete to the best of my knowledge.
Are other witnesses available the 17th? Preliminary examination in person, June 17th, 2025, 9 a.m. That's before Judge Moore. Bond
We'll
continues.
still be here, okay? 17. All right. All right. Thank you.
Court calls case of the People versus Elia Keys.
And then on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Buckovich on behalf of Ms. Keys, who should be appearing via Zoom.
State your name, please.
Kiyola Keys.
Thank you. All right, what do we do?
At this time, Your Honor, we'll be setting this matter for preliminary exam. To my knowledge, all discovery is complete. And when appropriate, may I briefly address bond?
People have their witnesses available the 17th.
We'll do our best, Your Honor.
Preliminary examination in person, June 17th, 2025. 12 noon. That's before me. Yes, that's a bond.
As to bond, Your Honor, Ms. Keys did have a no-go to an address located on East Michigan Ave. It is an address that she does have a lease at. The purpose for that no-go to was because the complaining witness was moving out of that residence at that time. From my conversation with APA Zenda, it's been indicated to me that complaining witness now has fully moved out, has their animals, has no reason to return that address. Ms. Keys is the only person on that lease, so I'll be asking that that no-go to order be lifted so she can return to that apartment.
Response.
Your Honor, we have no objection. We did get confirmation that she has been out of that address for some time, so she would not be residing there or returning.
So I will delete the no-go to provision. Okay. Very good.
Thank you, Your Honor.
Otherwise, bond will continue with its conditions.
Thank you.
Court does call the case People versus Demario Farrell.
Alexander, on behalf of the people, Your Honor.
Morning, Your Honor. Mike, yeah, I'm Hope Defender on behalf of Mr. Farrell. State your name, Mr. Farrell. Sure. Your Honor, at this time, we'd ask the court to set this matter for preliminary exam.
All right, discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
We'll do our best, Your Honor.
Judge, if I could be heard on bond.
Yes, preliminary examination in person will be set June 17th, 2025, 9 a.m. That is before Judge Moore. Yes, sir.
Judge, Mr. Farrell is here. Obviously, he's in custody. We're asking that the court maybe consider reducing his bond and giving him a GPS tether. He does have a local address. There's an address that I can give to the court over in Ypsilanti that where his father and grandmother reside, and he may reside there as well. He reports. Also, he did obtain a job in Wixom, and it is a full-time job. He reports that he has been in contact with his boss there, and the job is open for at least for the current period. We'd ask the court that the court give him an opportunity to reside outside the jail, either by reducing his bond to a postable number or a personal bond with a GPS tether, and any testing requirements and no go-to requirements that the court deems fit to ensure both the safety of the public and his appearance. And the address on Kirk Street in Ipsy is not an address where the complaining witness resides.
So the address you're referring to is Kirk Street address.
Yes, Judge.
Thank you.
Your Honor, I'm going to object to modification of bond. This case is a reauthorization of a system
Sure.
matter before Your Honor.
Sure.
I have concerns, given that in that case, he failed to appear back in 2023, did not come back in contact with law enforcement until May of this year, and he was picked up. And at the time that he failed to appear, he had a violation of bond for leaving the state, and also for contacting the victim after he had been released. I had concerns, given that there were concerns of previous contact, and then he failed to appear for over a year and had left the state. So I'd ask that bond remain the same in this case, Your Honor.
Your Honor, Mr. Farrell is well aware of the importance of this matter, and I would note that he's now charged with a felony. It's a brand new case. This case has been kicking around for I don't know how long. I don't know why it was never charged as a felony back then, but it is now. I'd ask the court for a personal bond or a reduction. That is my end. That's what I'm informed by the people.
Motion for bond reduction or modification is denied. Bond will continue.
Thank you, Your Honor.
For cause case People versus Alexander Cronin.
And Lord Yagi, Assistant Public Defender, with and on behalf of Mr. Cronin. Mr. Cronin, could you state your name for the court?
Good morning, Your Honor. My name is Alexander Cronin. How are you, sir?
Okay, thank you.
And Your Honor, I apologize. I was just emailing about this case. It is going to be a request for an adjournment due to some discovery, as well as continuing discussions with the people about potential resolution.
Any objection from the council? When are we? June 26, 2025, 9/8. Bond continue.
Thank you, Your Honor.
That's called the case of the People versus Alua Gillis.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Jay Ballinger on behalf of Ms. Gillis, who approaches. Ms. Gillis, can you please state your name for the record?
Alua Gillis.
Request a forensic evaluation.
We are, Your Honor.
Forensic evaluation will be ordered on subcompetency hearing for August 28th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Shelby Lawson.
Your Honor, Student Attorney Kara Rothengren, under the supervision of APD Stephanie Cannon, on behalf of Ms. Lawson. Ms. Lawson, could you state your name for the court?
Shelby Lawson.
Really supervised. I'm just kidding. just thought I'd ask. Go ahead.
Your Honor, we're going to be requesting to adjourn Ms. Lawson's case. We're still awaiting some discovery.
Without objection, Probable cause conference will be adjourned June 26, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Case People versus Stephen Johnston.
Hey, Pierre, Rachel McDonald.
For Yagi Assistant Public Defender with and on behalf of Mr. Johnson, Your Honor, may we approach on this matter?
Yes.
Thank you, Your Honor. So as I mentioned to the court, I am asking that Mr. Johnston be allowed to be released to inpatient treatment. That is a priority of his. He acknowledges the issues he has with substance use, and he is eager to get treatment. I know Mr. Johnson is not happy about my request for an adjournment of the PCC, but I think it's important because I do think there is some additional discovery that we should see before he makes a decision whether or not to waive his exams.
Adjourned probable cause conference June 26, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor. I did just want to repeat your response.
Yes.
We did discuss this at the bench. I understand that at our last hearing, the court was very clear with Mr. Johnson about the fact that there was no contact with the BB victim related to this other case, and who's also involved in this case as well. And his phone privileges were revoked at the jail, and he was absolutely no contact with her whatsoever, including third parties. Since that time, we do have a recorded transcripts from some calls apparently made with other people's pens, and he has contacted third parties. Well, he attempted to call her 6 times, and also used third parties to make requests that they get in contact with that same victim. So tell her that he loves her. I can make a further record of some of the comments, but Mr. Johnson is apparently under the impression that because he had and still has consensual contact with her in his other case, that trumps any orders given by this court. I would ask that the court make it very clear, since in one of those calls he stated that the county, quote, fucked up his orders. And I won't repeat the comment that he made about Your Honor, apparently in this case, but
I'm sure it was very affectionate, so go ahead.
Sure. Affectionate with all the F's. So he, Mr. Johnston is under the impression that, again, there are erroneous orders made. I would like the court to be very clear with him that no matter what order he has in any other case, a revocation of phone privileges, as well as no contact with this victim, including third parties, regardless of his location, including should he be released to inpatient treatment, as counsel's order states, all prior bond conditions remain in full force and effect. That does include contacting this victim, including with third parties. While we may not have a recording from him while he's in treatment, it will still be apparent to us because, quite frankly, Mr. Johnson has been anything but so since he's been having this case pending. So I'm just asking for a reminder of those conditions. And I don't have any issue with the release of treatment. However, I would ask, well, I'll just leave it at that. I'm asking the court.
Thank you. I just received the transcript of these calls, actually, just very brief, not too long ago this morning. I'm going to have a very detailed and thorough meeting with Mr. Johnson later today about his bond conditions. He does have 2 different cases. Obviously, she's not listed as a victim in this case. It's the circuit court case where she's the victim. And so I will make it very clear with Mr. Johnson in our meeting later today. I will, and I would request the actual calls from the state instead of just the transcript.
Mr. Johnson, you understood what I ordered? Not asking whether you like it or not. You understood what I ordered?
I kind of understood, Your Honor.
What's the kinda?
I've never been in like court like this before, so I'm new to this, like being in trouble and stuff like that. So I'm not all familiar with the terms or wording and ways of the fact of. I watch a lot of court TV, yes, but I don't understand personally, no. I do have like a question of like what does a no contact order mean, Your Honor? Like, if you can, like,
No contact order means that you are not to have contact with that named individual, either directly or indirectly through third parties in any way whatsoever. You are not to have contact via any electronic communication, whether it be telephone, email, social media, or anything like that. And you are also not to mention them on any social media platform. Is that clear enough for you?
Yes, Your
And
Honor.
understand something. I don't believe in coincidence. So if there's contact, I'm going to believe that you purposely did it, either yourself or through some third party. Because even after I ordered it the last time, and I don't think you don't know as much as you're trying to pretend before me that you don't know, because of some of the stuff that you were saying going out of the courtroom. Also, if true, your behavior indicates that you are sophisticated enough to get somebody else's pen to try to make communication in an indirect fashion. So you understood exactly what I said. You just didn't like it. So hopefully now you do understand. Do you? Do you have any other questions regarding what I mean by no contact? I don't want to hear any more that there is any type of use of somebody else's pen to do some direct or indirect contact with the victim, because you're not supposed to be making phone calls at all. You've lost that privilege. Anything else from either side? June 26, 2025, 9 a.m.
Your Honor, would the court consider a 1-week adjournment, or is that not enough time?
If you want, if that'll work for you. If you're trying to get I don't know about the discovery. That's the other thing I'm trying to.
Understood. Do you know?
I'll give you the 1 week.
Okay.
June 12th, 2025, 9 a.m. Bond is continued with its condition and my admonition that you need to follow what I order. Thank you. Have a good day. Court calls the case, People versus DeAndre Cersei.
Hey, Richard. Oh, I'm sorry. I'm so sorry.
Evan Archer requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of APA Rachel McDuffie, Your Honor.
He was here on Tuesday.
Yes, sir.
And when he was trying to make the actual prosecutor to run out to find somebody, and he was doing absolutely nothing. He didn't even step up to say, can I help? And can I go out? He just did nothing. He just sat there. You remember? You do? And then I said, you go. And then he went. And you know what? He didn't even come back with the person. I don't know what he was doing out there. He just kind of sauntered back in. I don't know. But nevertheless, permission to practice is granted.
Evan Archer for the people, Your Honor.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cersei.
You state your name.
DeAndre Cersei.
Thank you, sir. You're looking for an adjournment?
Yes, Your Honor, we're looking for an adjournment to continue negotiations with the people.
For the 17th or 26th? I.
26.
Ow.
June 26th would be fine, Your Honor.
I knew you'd take that. And the only reason I gave Bukovich a choice, because last Thursday, I don't really feel sorry for people, really. I feel sorry for him. I really did. I mean, he was so confused. He was giving it, pointing toward the door. Just turned his back on us. It's okay. I'm a forgiving person.
Thank you, Your Honor.
You don't mean that. Probable cause June 26, 2025, 9 a.m. Bond will decision. Thank you. Thank you. Court does call the case, People versus Chad Jones. That was my last one.
And Lori Yaki, Assistant Public Defender, with on behalf of Mr. Jones, who's approaching. Mr. Jones, can you say your name for the court?
Chad Jones.
Your Honor, there is a pattern with me this morning. I'm asking for Mr. Jones to be released to treatment. I do have a proposed order. I did discuss this with Ms. Douglas, and I don't believe she has an objection. Sorry. The issue, may I hand an order, proposed order to Ms. Douglas?
Can you? I don't know. Yeah, go ahead.
Mr. Jones does have several holds, including 2 holds that are bond denied. However, I have been in touch with his attorney in his Wayne County case, where he's going to try to get him released to treatment with a tether in the Wayne County case. And obviously, he's not going to be released from here until he deals with those 2 holds anyways, but we are trying to get the ball rolling. And I just am realizing, and I apologize, Your Honor, I did not put a tether in this order. And that is one thing that Ms. Douglas and I discussed. So I apologize. I can revise it.
And that was going to be on a GPS tether.
I don't have objection to release to treatment. If there's a tether, I do think that it would be Mr. Jones.
I'll just insert it after available. I'll insert with GPS prior to release.
Thank you, Your Honor.
All right.
And I should have given this. I'm sorry. And I am asking for an adjournment of the PCC for continued discussion about global resolution, as Mr. Jones has multiple.
Yes, he does. June 17th, 2025, 9 a.m. Bond will continue. I signed the order.
Thank you, Your Honor.
But Court does call the case, People versus Sterling Harris.
Wendy Burnwell on behalf of Mr. Sterling Paris.
Sterling Harris, sir. Thank you.
Your Honor, your plea.
Again? Okay. fine.
And I'm asking.
Okay. In this matter, we have an amended complaint which adds counts 4 and 5. Counsel, you received a copy of that, Ms. Martin?
Yes, Judge.
And you waive any formal reading of that,
Yes, Judge.
and your plan stands to each of those charges?
That is correct. For the increasing your charge to. Hmm?
All right,
We gotta do the-
so taking care of that part. Also, just because of the counting of the counts, at this time, the people are moving to dismiss count 3.
Correct, Your Honor.
There's no objection from defense. Dismiss count 3. Don't talk to me tomorrow. And then you're requesting a forensic evaluation.
Yes, Judge, I am.
All right. Forensic evaluation is ordered. I'll set a competency hearing for August 28th, 2025. 9
If I can respond.
a.m. Yes, go ahead.
Come to our attention, Your Honor, that the defendant has made 18 complete calls to the victim since being arraigned. In these calls, he first calls his mother, wants to do a three-way call to connect the victim in, and then eventually gets a hold of the victim. And he's telling her he loves her, he wants to get back together with her. At this time, I'm going to be asking for his phone calls to be revoked because on top of the 18 completed calls, he has 124 total attempts, including those complete calls. So this time, I'm going to be asking that his phone privilege be revoked.
Yeah, I'd ask that not happen. I think he understands now not to make any calls. I don't want him to be cut off from his family.
Well, you requested a hearing on this, but I mean, after you listen to the calls, but he's supposed to have no contact with it. That's his third number,
And I'm concerned that he's calling his mom, and that was going to be called to try to make a three-way call.
which is going to be a violation of the bond. And this time, defendant's phone privileges are hereby ordered revoked. In all other respects, his bond will continue. Thank you. I'm sorry. That was an arraignment. Pardon? Oh, that's right. Court does call the cases of People versus Quincy Jones.
Okay, Richard McDuffie for the people.
Morning, Your Honor. Mike Getty, Assistant Public Defender on behalf of Mr. Jones, who's here to my right, Judge. State your name, Mr. Jones.
Quincy Jones. You feel better today?
Yes, I do.
Do you?
Yes.
Sobriety is a funny thing, isn't it? Never mind, you don't have to answer that. I'll never show up here like that again. You hear me?
Yeah.
All right, what are we doing?
Yeah. Oh, I'm sorry.
Oh, I'm sorry. This was also an arraignment. The court was attempting to arraign him on the new case last time.
Right.
Yes, on the 25 F2 1293, Your Honor, or 0697, Your Honor, anticipating that that will be appointed, I would waive reading and standing.
All right. Defendant having waived formal reading standing, you, court will enter a not guilty plea as to that case. And the public defender is appointed in that matter. What date did you want me to set probable cause?
Your Honor, I did receive the police report earlier this morning. Ms. McDuffie was kind enough to send it to me. The version I got last night wouldn't open, so I haven't had a chance to go over that with Mr. Jones. I'd ask for the next available date, and if I could be heard on bond.
Yes.
Your Honor, Mr. Jones is here.
Well, hold on a second.
Oh, sorry.
I'll make it the 17th, so he's not.
Thank you, Judge.
June 17th, 2025 at 9. That's time on the other matter too. Go ahead.
Thank you, Judge. Mr. Jones is here in custody today, obviously. He does have a place to reside. He resides in Ann Arbor. He does have his own apartment. He does receive assistance from Avalon Housing. I was able to reach them on the phone, and they are, would continue to provide him assistance in navigating the ins and outs of life. He would comply with whatever drug testing the court would require, where sober link if the court, or a scram tether if the court required such. He does receive a monthly, I believe does receive a monthly shot to under an ATO. I'd ask the court to give him an opportunity to have a personal recognizance respond in this matter with monitoring and whatever testing requirements that the court deems suitable.
From the people.
Your Honor, while I don't have an issue, my original request was for a $7,500 PR bond on this case. It probably goes without saying, especially at this point, that I am requesting a testing order. I don't know to what extent alcohol is something that Mr. Jones deals with, but certainly drugs, narcotics, cocaine specifically, are of concern to the people. I think that there was a request on his older file, but because he had been hospitalized and gotten out of treatment, the court declined to impose a testing order at that time. Unfortunately, I think we see that we probably need to keep a close tab on Mr. Jones's compliance. Other than that, no objection to the PR and the camera.
Yes. How often are you using the ground?
Well, but I ain't mainly not that much.
Why?
Mainly not that much.
Because I was a bit surprised you did what you did last week. No, usually you show up and you show up sober enough to take care of business.
Yeah, I have a lot going on between my mom's girlfriend and the house selling. And it's all right. Yep. Yeah.
On case ending in 575. In that case, that I've adjourned to the 17th at 9. I'm going to reinstate his previous bond of the 5,000 personal recognizance. All right, and the previous conditions. It means that you're going to have testing on that. Understood?
Yes, sir. Yes, Your Honor.
On his new matter, I'll set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You need to repeat that?
Oh, yeah.
Sure.
Yes.
I'm going to order that he test at community corrections. How often are you testing under the old order? How many times are they calling you?
Not once.
I don't believe he was
I wasn't.
at all.
Oh, that's right. So I'm going to order intermediate supervision with at least 2 times per week drug testing. Got that?
Okay.
Thank you.
Your Honor, will he need to report immediately to community corrections if he gets out or within 24 hours? Or will they come see him before?
Yes, they get him out, community, and you're out before 4:30. I want you getting over before 4 o'clock. I want you getting over there to community corrections.
Yes, Your Honor.
Hear me?
Yes, Your Honor.
Thank you, Your Honor.
All right. Court does call the case People versus Paris Lester.
Camera that is on behalf of Mr. Lester is approaching.
Paris Alexander Lester. Thank you.
Your Honor, we were going to be asking for an adjournment for a potential global resolution on his other matters.
Probable cause conference, June 17th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Court does call the case of the People versus Jacqueline Murray.
Camera that is on behalf of Ms. Murray, who can hear anything.
Jacqueline Murray.
All right.
Your Honor, we were going to be asking for an adjournment pending for release to treatment, but I believe she's already started her Dawn Farms program in custody. So we'll just be adjourning for plea negotiations after she does some progress there.
After she shows some progress.
Yes. She just started, I believe, right? Yes.
Is this the only, are these the only cases holding her here? Or does she have other?
She has other cases. I also believe she has cases. Well, she resolved, she has one warrant out of 35th, I don't believe has resolved yet. But here.
Okay, how much time do you want? I mean, I can do the 17th or the 26th.
The 26th, Your Honor. I think she'll have more progress at that point.
That's what I was,
Thank you.
I guess, kind of getting at. June 26, 2025, 9 a.m. bond continues.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am. You want those? Court calls case of the people versus Michael Patterson. Two
Morning,
cases.
Your Honor. Abigail Nice-Swanger requesting permission to go here, MCR 8.120, under the supervision of Laura Wood.
Get that whole thing. She did? Right through the Wisconsin angles. Permission to practice is granted.
Abigail Nice-Swanger, court.
Mike Gaddy, Assistant Public Defender for Mr. Patterson, who's here to my right. State your name, Mr. Patterson.
Michael Lee Patterson. All right.
Your Honor, we're here for a competency hearing. I did have an opportunity to meet with Mr. Patterson yesterday. We did go over the competency recommendation from the Forensic Center. We don't have any additions or corrections to that competency.
And no other additional evidence.
No, Judge.
Is there any evidence from the people?
No, Judge.
You would stipulate to the report.
Yes, Judge.
Based upon a review of that report, court would find that the defendant is competent to stand trial, would specifically find that he can understand the nature and objects of the proceedings against him and can rationally assist the defense. Therefore, the defendant is deemed competent.
Thank you, Judge.
I'll need orders.
I will, excuse me, prepare an order, Judge.
Okay. And what would you like this set for?
I'd ask to set this for a probable cause, these matters for probable cause, Judge.
Are these the only cases holding him here?
Yeah.
I mean, did you want me to set it the 12th or the 17th? That's, I guess, my ultimate question.
I'll leave that to the court's discretion. I do have a request on this. Actually, I think he has an MDOC hold, Judge.
Does he? Okay. No,
But I think that may be cleared up. I have not been able to verify that.
all right. I'll set probable cause conference for June 17th, 2025. Night. I wanted to say something. All right, Esteban. Yeah.
I mean, Your Honor, Mr. Patterson is here. He has indicated to me that he would like to seek treatment, most notably at perhaps the Havenwick facility in Auburn Hills. If I'd ask the court to consider if we are able to arrange that, to consider if I'm able to talk to the prosecutor, reviewing a stipulation to release to that treatment if we're able to secure it.
That would be inpatient.
Yes.
Okay. I typically am not going to have an objection to any release to inpatient treatment.
Okay, thank you.
Appropriate, but if you work with the prosecutor. Okay. So what? Otherwise, his bond will continue. at this
Release.
point.
Okay. Okay. All right. I'll be in touch, okay?
All right.
Thanks, Judge.
You're welcome. Where's Miss Yagi?
I think she went back to her office.
Okay, no, that's fine. I don't know why she's doing things better than everybody else. That hurt your, did that hurt your feelings, Miss Parenti?
No.
No. Something better than everybody else. And I'm just, oh, whoa. That was, wow. Okay, oh, yeah, I know, I didn't want to repeat
I can't speak for everyone, but for myself, I understand why she's doing better.
it. Wow.
I know my limitations.
Court calls the case, people versus Tyler Redmond.
Testimony for the people, both members.
Good afternoon, good morning. Attorney on behalf of Mr. Redmond. Your Honor, I had a green sheet. It was there and now it's missing. So I'll get that to you.
Probably why I said that about Yagi.
I know.
All right.
I guess I could admit my own faults.
Your name, sir?
Tyler Redmond.
Thank you.
Your Honor, we are requesting an adjournment for ongoing plea negotiations and a referral to drug courts. So we're gonna
Got
get them assessed.
That's correct. That's a felony drug court, Your Honor.
Okay, so are you gonna be doing that referral? I mean, I'm just thinking in timing of the adjournment.
Ms. Lunny may know better than I. Do you know how long those assessments are taking?
And right now I don't, but I would say if we could do two, and if it's not done, we could do a 6 order.
Yeah, that works for me.
Then why don't I just try the 17th to start with, and let's see if we can get it moving. Probable cause conference, June 7th. Bless you. June 17th, 2025. 9 a.m. Bond will continue.
Thank you.
Thank you, sir.
It just appeared.
Wow.
I know. What
No,
am I
it didn't
telling-
appear. I saw her doing it. We need to start looking under everything. Don't worry about it. It's all done now.
I know.
Miss Douche covered you. Court calls the case, People versus Lakita Roberts.
Hey, Richard McDuffie for the people.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender with Ms. Roberts, who's here to my right.
Yeah, Makita Roberts.
All right.
Your Honor, in speaking with Ms. Roberts and then in speaking with Ms. McDuffie, while I would like to also discuss a global resolution, it appears that there's a bench warrant that's outstanding out of the circuit court that didn't appear in X jail that Ms. McDuffie had, it looks like it's a 20 FTA matter.
That was already over at circuit.
Yeah, it's just an outstanding warrant. I'd ask the court to adjourn this briefly so I can track that down and get everything all squared away.
Okay, June 17th, 2025.
Thank you, Judge.
9 a.m. Bond will.
I'll be in touch, okay?
Thank you, Mr. Roberts.
Thank you, Your Honor.
Case of People versus Aaron Washington.
APA Richard McDuffie for the people.
Pardon? Yeah. Oh, okay. What's your name, sir?
Mr. Washington.
We're ready in this matter, Your Honor. Long Brown Deputy Chief Public Defender appearing within on behalf of Mr. Washington. Today's the date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination. We do believe all of the discovery is present.
Your Honor, I was just telling Mr. Brown, I didn't get a chance to tell him that I checked in advance with the OIC regarding availability. And he stated that he could be available either next week, June 10th, or July 8th. He will be out the intervening 3 Tuesdays.
Ooh. Yeah, I can set it. Everybody's gonna be ready.
Okay, so we'll work on this. So July 8th was one of the options, Your Honor?
Yes,
And what was the other?
it was June 10th. It was, yeah, this Tuesday coming up.
June 10th, please. Your
June
Honor.
10th?
Yes, please.
Okay, everybody be ready on that day. June 10th, 2025. 9 a.m. That will be before Judge.
I don't want to.
That's before, that's before Judge Barr.
That's the next day.
I just want to check it out. Are we sure about June 10th?
Yes.
Okay.
Germany, July 8th. We ain't trying to do that.
No, we're not Germany.
You want June 10th, right?
Yeah,
See?
that's preliminary.
Okay, cool. That worked. That's pretty
You
cool.
two all set?
Kinda, we're getting there.
Kinda, no, I'm gonna get the time, but
Baby,
I ain't got all day.
Try to figure it out.
Try to figure it out, Simpson.
June 10th, 9 a.m. before Judge Barr. Bond will continue. Thank you.
Thank you.
There she is. Ms. Eden, can you state your name, please?
Yes, sir. Brittany Eden.
Thank you. Counsel, I have before me a plea sheet that indicates that she's going to be pleading guilty to an added count 2 of use of methamphetamine. It's a 1-year offense upon her successful plea to that charge. count one would be dismissed.
That's correct.
Court's full understanding of it.
That's correct, Your Honor.
All right, very good. This evening, can you raise your right hand, please?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, state your name again for the record, please.
Brittany Eden?
Ma'am, it is this court's understanding that you're going to plead guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court cost. Is that correct?
Yes, sir.
All right. And this is my case. All right. So understanding that and the maximum penalties, how do you plead to that charge?
Guilty, Your Honor.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You gave permission and have signed an advice of rights form. Is that correct?
I consented to it being signed, I believe. I'm currently incarcerated.
Right.
Yes, I did.
And was that form explained to you?
Yes. Yes. I
All
read
right.
it
Did
over.
you have any question regarding the rights that are contained on that form?
No, sir. I believe I understand it.
All right. Well, let's just make sure you understand that you will not have a trial. And because you're not having a trial, you're giving up your right to call witnesses to speak for you at that trial or to have this court compel their attendance. You're also giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that?
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, I'm currently incarcerated and I will be on parole soon.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes, sir.
and because you believe that you're guilty of this offense?
Yes, I do.
January 25th, 2024, at the location of the Huron Valley Correctional Facility in Pittsfield Township, Washington County, State of Michigan, did you have in your possession methamphetamine?
Yes, I did.
Had you used it?
At the time I was going to use it, I hadn't used it yet.
You hadn't used it yet,
My
but you
intent
had it
was-
in your possession,
Yes, and my intent was to
and you
use
knew
it.
what you had was methamphetamine?
Yes, sir.
All right, looking at the elements of the higher charge, has the court complied with the court rule and would be proper to accept this defendant's plea?
No objection from the defense, Your Honor.
All right, court will accept the defendant's plea of guilty to count two. Count one is dismissed.
Thank you.
Is there any reason I shouldn't proceed with immediate sentence?
I was asking to request immediate sentencing, Your Honor, and for a credit for time served. This alleged offense occurred a while ago, and I believe that she would be entitled to credit for time served on this matter. And I don't mean to be any objections from the state.
No objections, Your Honor.
All right. Ma'am, is there anything you want to tell me before I impose sentence?
Yes, I have been doing better. This happened in 2023, and since then I've been working on my addiction, going through a DBT program, which is didactical behavior techniques, and I'm trying to learn other ways to cope with my flaws. Yeah, I've been in here for 2 years since this has happened, and I've done work. I'm learning to meditate more. I'm learning to talk things out. I'm getting ready to parole here soon. So they believe that I'll be ready, and I'm going to be on a D47 mental health parole. So they can help me with many things. And that's also medication assisted treatment. So I believe that, I'm working on that problem, and it's not the same as, sorry, I get a little flustered when I'm in front of
No, you're okay.
the judge. It's been a long time. Yeah, I'm trying to do the right thing. I'm all set to get out of here pretty soon. And I think I'm going to have another take at life and being able to be successful, happy, and that's all I have to say, I suppose.
Okay, I wish you all the best at that, I say, and I think you're right. You get another shot, so use it.
Thank
And
you, sir.
again, I wish you all of the best. It's the sentence of the court. The state minimums of $125 fines and costs, 365 days in jail, credit 365 days, sir. Again, good luck to you, Missy.
Thank you so much, sir. And I've seen your episodes on A&E. I was like, I just really hope you're in a good mood today. You have me cracking up sometimes.
Well, I'm glad you enjoyed them. Thank you.
Thank you, sir.
Court calls the case, People versus Donovan Sneed.
And then on behalf of the people, Your Honor.
Good afternoon, Your Honor. Stephen Mann, I'm appearing on behalf of the defendant. It should be on, I don't know if he knows how to label his name.
I lost part of my screen.
Can you see me?
Got it. He's what?
Can you
Mr.
see me?
Sneed?
Yeah, can you see me?
No.
Oh. Uh,
Is there a little camera button, Mr. Sneed? Do you see this?
camera, but, oh. Go to settings privacy. What do I do?
Okay, what are we doing today?
Your Honor, this is the first PCC, Your Honor. I'm not in possession of the discovery in this matter. I was simply asking for an adjournment. so I
Okay, and
could-
you can, for the record, state by voice that that is your client, Mr. Sneed.
Yes, I just spoke with him.
All right,
before you-
well, I'm unable to access camera. Allow.
It's okay,
Zoom one-
Mr. It's okay, Mr. Sneed. It's okay.
I don't know.
Okay, just, Mr. Sneeze, we'll figure out a way around it. So you're seeking an adjournment, counsel?
That's correct. I do want to seek a deviation in this matter and as well as look at the discovery.
And Your Honor, I believe the discovery was sent over today, the immediate discovery.
It got sent over today. All right. So I'll adjourn this out June 26th.
Thank you, Your Honor.
2025, 9 a.m. or as your invite indicates, bond will continue.
Thank you so much.
And in that interim, that's 3 weeks, he can learn how to turn on a video. All right.
All right. I don't know what's going on. Someone would teach me.
Thank you, Your Honor.
Okay, thank you.
All right, thank you, buddy.
Court calls the case, people versus Hannah Smith Seeley.
Christina Bear, adjourned for the people.
Your Honor, Joe Simon on behalf of Ms. Smith Seeley. Ms. Smith Seeley, will you state your name?
Hannah Smith Seeley.
Okay. All right, what are we doing?
Your Honor, I just entered this case replacing the public defender. I'm going to be requesting a rather lengthy adjournment of the PCC. My client's been screened and assessed, referred to Dawn Farm, which she's going to commence her intake. I think interview is tomorrow or maybe later today, one of the two. And also she's going to investigate a possible sobriety court path in the 15th District Court. She's on a scram now and in compliance. She actually downloaded today. I'm asking to adjourn the PCC to July 10.
Already wrote it down. I knew you were going to ask. Any objection from the people? Probable cause conference, July 10th, 2025, 9 a.m. or as your invite indicates, bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Yes, ma'am. Court calls case, people versus Dejan Wells.
Ally Zend on behalf.
Good morning. No, good afternoon, Your Honor. Jacob on behalf of Dejan Wells. Dejan, state your name.
Dejan Wells.
Judge, I was just retained last night on this matter. I don't have any discovery yet, obviously.
Sure. Court calls case, people versus Joseph Wynn.
Or Yagi, Assistant Public Defender. Good afternoon. With and on behalf of Mr. Wynn. Mr. Wynn, can you state your name for the court?
Joseph Wynn.
Assistant Attorney General Clarissa,
Oh, I'm sorry, Madam Attorney General.
Assistant Attorney General Clarissa Williams on behalf of the people.
And Your Honor, I do have a green sheet. I am asking for another adjournment and I'm happy to indicate, I know this matter has been adjourned several times, so I'm happy to indicate this would, if the court is.
Go ahead. Why?
But Mr. Wynn, we're attempting a resolution here and we are asking for some additional time. I did speak with Mr. Wynn about his specific plan in terms of catching up with child support, and he indicated that some unexpected things happened, but that next Friday he was going to follow through. And so we are asking for another adjournment.
Follow through with what?
With paying down a portion. He did pay one down, I think, in April, but not last month. So we are, he's.
Well, in April, that was his bond, right?
In April, he paid his bond. Mr. Wynn, did you make any payments after your bond?
No, not yet. No, he's not.
Your Honor,
Go ahead. Yes.
yes, just for the record, for our record, for the Attorney General's record, I would object to the continued adjournment of this file. I believe a plea offer has been submitted to the defense and their client. And I think at this point, either we're going to determine if we want to take advantage of it or not. I mean, last time it was a paycheck is coming. I get that emergencies happen, but I just learned of this a couple hours before this hearing. So I would object to the continued adjournment of this case for really, I don't think the cause.
Well, and I thought back in April, April, let me just make sure I have the date. But there, yeah, it was adjourned so that basically he could make payments. And so now I'm here in June and there hasn't been anything, and now what's gonna happen is there's a promise to.
I understand. And I did talk with Mr. Nguyen. He is, I don't know if he currently still is, but he has been in Northern Michigan taking on some additional projects for work. So he's expecting, I think, a good paycheck next Friday, but he indicated that something came up in terms of family emergency. I didn't get into details with him, and he said that took the funding that he was intending to use.
Oh, we're gonna have to do something else with this.
Understood.
Set it for exam or you can waive.
Understood. And I talked with Mr. Nguyen about that. Mr. Nguyen, did you have any other questions, or are you prepared to waive your exam today?
No, I don't have any questions.
Okay. I don't have a completed waiver from him, but
That's fine.
Okay.
So you're gonna waive your right to a preliminary examination?
Whatever my attorney did, whatever they think's best.
Can't do that. Is there a phone number you can call them at?
I can call him. I have a phone number.
I'll pass it. Happened last time with the Attorney General. She was here last day. Court does call the case of the people versus Donnell Young.
Sorry, Your Honor. Good afternoon, Laura Yagi. I'm standing in for my colleague, Mr. Bellinger, on behalf of Mr. Young. Mr. Young, can you state your name for the court?
Donnell Young.
And Assistant Attorney General Clarissa Williams on behalf of the people.
All right, what are we doing?
Your Honor, my colleague indicated that he spoke with Mr. Young about his options, and he understands that what the plea offer would be, and understanding that he still wishes to set this matter for exam.
And all discovery is complete?
To my knowledge. And isn't that right, Mr. Young, what I just said to the court?
Yes.
And would the people have their witnesses available the 17th?
Yes, Your Honor, we should be able to.
All right. Preliminary examination in person will be set June 17th, 2025. That's at 12 p.m. That's before me.
Thank you.
All right, bond continued. Thank you.
Thank you, Your Honor.
Court calls case People versus Brian Brown.
Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning. Good afternoon, Your Honor. Kia Hickman standing in for the attorney of record, Todd Perkins. Mr. Perkins should also be on Zoom.
Perkins is on Zoom, but sent you all the way down here?
Yes.
How did you do that? Where is Perkins here? Oh.
Perkins is here, but I actually don't have the vicinity for Mr. Brown's house.
I'm not seeing always.
Okay, I am Brown.
Oh, I see. All right.
He's gonna talk.
I see him now.
Did you call the case, Your Honor? I just saw the.
Yes, I called the case like an hour ago.
Oh, I didn't know that.
No, I'm kidding.
Okay. You know, I don't ever want to be late. I've been watching you on YouTube and I'm having a blast. The guy smoking a cigarette while, complaining that you sent him to prison. It's enough. But more importantly, the business. I did have, because your staff was kind enough to ask me, did I want Zoom or if I wanted in person, but I have a lawyer who, Ms. Hickman's there also from our firm. She has another case. So I just wanted to double back and let you know that we do have a lawyer who's there also for Mr. Brown.
Yeah, she's here.
Yeah.
Because she's been talking to Janaza all afternoon. I've been watching them over there. Just saying.
Okay, I'm not getting into that one. Let me do this. Let me do this, Your Honor. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Brown, whose presence I think I would be asking to waive.
Well, he's in custody elsewhere.
He's in federal custody.
Okay.
He's in federal
All
custody.
right. So, and they did not sign on. I don't even know if they were.
A writ was done by the AG's office, and my understanding is they did confirm, but they have not signed up.
Oh, okay.
But we've
I
been
hope
having
everybody
problems with
heard
Sanivac.
The writ was done. They confirmed the writ, but they have not signed on.
Correct. And I'm still in this holding pattern. I know that he has a pending. So if I can just elaborate a little bit for the court and sister counsel, I think I've already told her this before. He has a pending child support matter that's being litigated and it's not being litigated by me, but he was actually actively litigating that before he was in custody. And the issue is, if that court makes the determination, because he filed it, and it wouldn't offend the issue of retroactivity, because the time that he filed it, he was not over any threshold amount due. So that's what's really in the balance here. And that's the reason why I've been putting it off, or asking the court to put it off, to see if any, I guess I'm gonna have to bite the bullet and go see him, to see what he's doing and see what's going on in that other case, because I'm not involved in that. I've just been involved in the criminal portion of the non-support, because I think he has, for once in 100,000 of these cases, I think this guy actually has a defensible case.
So what do you want me to do today?
Go ahead, Ms. Williams.
No, you go ahead.
I like you going first. I would be asking the court to just put it off again, because I don't, one, he's not here, and I don't want to make a decision, go to exam, and once you go to the exam, you get ground in on certain positions. But I really would like to know what direction that civil case or the family court matter is taking. So I don't know that right now, and I guess I'd have to do my own due diligence in that regard.
And what's the people's position?
Although again, we don't like continued adjournments. I would not object to a brief adjournment so that the defense counsel can confer with his client to gain more information, so we know how to go forward.
Is he in federal custody in the state?
He's in Sanilac County.
Okay, so it's not that.
No, he's not that far, and I believe
Okay.
Sanilac might still provide. At one point in time, they used to provide video attorney visits. I'm not his federal attorney, but I did speak with his federal attorney, who had a motion for bond pending, and that was that got put off. So,
All right.
here's
Here's what I'll do. Give you a few weeks to get that done. We just have an odd schedule because of Juneteenth. So it'll be June 26, 2025. 9 a.m. or as your invite indicates, bond continue.
Is it 9 a.m. or 12:30? Because remember, I had that wrong the last time.
You always get it wrong.
I do. Yeah.
I set down, Mr. Perkins, I don't know how long you've been. I set everything at 9. My staff will then send out to you the exact time that it will be.
Okay. Got it. Okay.
No, he doesn't.
I got it.
You got it?
Yeah.
Okay. All right.
I do it right every time.
Thank you.
All right. Thank you so much, everybody. Thank you, Mr. Williams.
All right. Which one was ready? Wells was ready. All right. Are you ready on the, are you ready on the wind matter? Okay, let me call this one first real quick. I'll call that one then. Court calls the case People versus Joseph Wynn.
Assistant Attorney General Chris Williams on behalf of the people.
And Lori Yagi, Assistant Public Defender with and on behalf of Mr. Wynn. Thank you, Your Honor, for giving me its opportunity to speak with him further about his rights for preliminary examination. I did discuss that with him, and I believe he is prepared to wait his preliminary examination on record.
Is that correct, Mr. Wynn? Is he froze? Mr. Wynn? Oh, there he is. Mr. Wynn?
Yes, sir.
Is it correct that you intend on waiving your preliminary examination?
That's correct, Your Honor.
And you understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive the ring.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Yagi.
We would waive formal reading of the information and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for July 29th, 2025, 1:30, Judge Conkey.
Thank you.
Bond will continue.
Thank you, Your Honor.
Thank you. That is it for you. Okay. Court does call the case, People versus Dejon Wells.
And then on behalf of the people, Your Honor.
Good afternoon, Rob Jacob on behalf of my client, Dejon. Would you state your name, Dejon?
Dejon Wells.
Judge, thank you for the bench conference. Because of that conference, I spoke with the family. It's my understanding the court's loath to keep his PR bond. I talked to the dad. He would ask the court to consider a $10,000, 10% bond. The post, again, just Judge, he's on a tether. He's back in school. He's not had any alcohol. He's done with all these incidents, and he'll stay away from the victim. And I would just ask the court to consider, if it's going to post a bond, let it be 10,000, 10%.
I'll let people make their motion.
And Your Honor, at this time, we would be re-requesting our original request of $50,000 cash surety. In this case, the defendant went to the victim's residence after being told that he was not welcome there, not to come over. He was walking around the house and the victim heard him outside and heard him say, "Fuck this, I'm going to jail, I'm going for a reason," before he kicked in the door. The victim, who was his ex, one of the victims, grabbed a bat. He walked past her to go to the other victim who was getting out. She then hit him with a bat. He continued on and began attacking the other resident in the house. There were children present in the house, although they were still present in the house. He was then assaulting this other male. They were punching him while being hit with a bat. He still didn't stop. The victim then had to grab a knife and stab at the bed to try to get him to leave the house. That didn't even stop him. After being stabbed, one of the victims heard him say, "He made me bleed. Now I'm going to kill him," and talking about the victim he had been attacking. Eventually, he did leave the house, but I believe the bond that was set at arraignment as a PR bond was an abuse of discretion. And at this time, we would be requesting a $50,000 cash surety bond for this case.
Judge, just for briefly, it's pretty apparent that alcohol influenced a lot of these dumb decisions he made that day. He went over to get, he had been living there. He went over to get some of his stuff when the incident occurred. Again, I don't condone what happened, but again, Judge, he's on tether. He's living with his father, who's present in court. He's not had any violations, and I would just ask the court to keep a minimal bond.
I guess the great difficulty is that while the defendant's out, at least at this point, we don't have any violations of the conditions that are set. But in terms of the factual allegations of this case, does the defendant have a prior criminal history?
Yes. There's a previous conviction that he was on higher probation for a malicious destruction of personal property, 200 to 1,000 out of, I believe, 14B.
So at the time of this alleged offense, he's on probation.
I believe so, higher probation.
Judge, my client says no, but
I just literally, probably about a month ago, just got off probation. I had to pay the rest of my fees and then I was done.
Can we check? That's a difference.
Oh, Your Honor, his case was closed on May 15th, so he had just recently finished.
So he had just come off of probation.
Because this happened on May 25th, Your Honor, of this year.
10 days after he's off probation. Anything else?
no, Judge. Again, it was just a relationship that went bad. He went to get some of his stuff. Alcohol didn't help, but that being said, I'm asking you to keep it 10 grand at 10%.
Well, I am going to grant the people's motion, Mr. Allen. I don't, given the circumstances, I guess the defendant has at least shown while he's been out at this point that he's able to conduct himself appropriately. So I'm taking that into consideration. But I think that the initial setting of the bond in this case was an abuse of discretion given the circumstances. I will set the defendant and the fact that the defendant just got off probationary status 10 days prior to this, which again, I don't quite get why he would get himself potentially involved in something like this. I will set the defendant's bond at $20,000. I'm not going to make it a cash or surety. I'm going to give him 10% privilege on that if it can be posted. So it's $20,000, 10%. At this point, all other conditions remain in effect.
Thank you, Judge. Can we adjourn this matter to the 26th? I was just retained last night, and I imagine there's a lot of discovery.
Probable cause conference will be adjourned June 26, 2025, 9 a.m. or as your invite indicates. Thank you. Court calls case People versus Emily Ann Bates.
I don't know if she's present, Your Honor. Hope she is.
And that springs eternal.
Wishful thinking. You know, I know Ms. Bates has had many probable cause conferences. She has been present for, I believe, all of them. I don't have an explanation for her failure to appear. Again, she's usually here. I was not able to get in contact with her this week.
Bench warrant will issue for defendant's rate. The bond will be sent in amount of 10,000 cash surety. That warrant will issue immediately. Court calls case People versus David Leland.
And Assistant Public Defender, Nazi K. Your Honor, on behalf of Mr. David Leland.
I figured out the conversations are your fault.
It is,
The moment somebody sat down next to you, start talking again.
It's me.
Not that I'm paying attention.
Mr. Leland, state your name for the record, please.
David Duncan Leland.
Thank you, sir.
And Judge, we are requesting an adjournment of the probable cause conference. We are still, we just signed the protective order, so we're waiting on additional.
order to the court earlier today.
Got it. Okay. 26, will that work?
That will work fine.
June 26, 2025, 9 a.m. or your invite indicates bond will continue.
June 26th.
Thank you, sir.
Thank you, sir.
Court calls case, People versus Timothy Lloyd. Second ruling, is that the green sheet?
Michael Gaddy, Assistant Public Defender for Mr. Lloyd.
Your name, sir? Timothy Lloyd. Thank you. What are we doing?
Your Honor, we'd ask the court to set this for a preliminary exam.
All discoveries complete.
Best of my knowledge, Judge.
People have their witnesses available the 17th.
A request, not that we are not going to be in the office to go 1 more week out. If possible.
Any objection to that?
Leave it to the court's discretion.
Preliminary examination in person will be set June 24th, 2025, 9 a.m. That will be before Judge. I'm sorry, Judge Freshow.
Thank you, Your Honor.
Bond will. I'll be in touch, okay? Court calls case People versus Derek Martin.
Good afternoon, Your Honor. Student Attorney Kara Rosenbrand, under the supervision of APD Stephanie Hannon, on behalf of Mr. Martin. Mr. Martin, can you state your name for the court, please?
Derek Charles Martin.
All right, what are we doing?
Your Honor, we're going to be asking to adjourn as we're still awaiting some further discovery and to further plea negotiations.
What discovery is outstanding? That was a question.
My apologies, Your Honor, that was a question, I'm so sorry.
What further discovery are you waiting?
Your Honor, Stephanie Hannon, within on behalf of Mr. Martin, right? When I was going through, the discovery that we did have, it did look to me like there was some video evidence missing. And I can't remember if this is one of the ones I've emailed on already. I know there were a couple, and I will email and get that happening.
Probable cause conference will be adjourned June 17th, 2025. 9 a.m. Whereas your invite indicates. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Robert Martin.
Evan Arteri requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of APA Rich McDuffie. Your Honor.
That
I did, Your Honor. I was told to do it again.
From who?
Not very-
Who told you before me you had to do it again?
I told him we should ask. Any options?
That's not even true. Why would you tell him to ask?
Because he had a question. You should ask him.
Every,
Assistant Public Defender.
I want to almost deny it just cause. Fine, permission to practice is granted again.
Evan Arteri for PP.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Martin. Mr. Martin, can you please state your name for the record?
Robert Martin.
At this time, Your Honor, we're requesting a brief, approximately a 3-week adjournment to allow Mr. Martin to go obtain a substance abuse assessment in hopes of achieving an offer.
Got it. Probable cause conference and will be adjourned June 26, 2025, 9 a.m. Whereas your invite indicates. Bond will continue.
Thank you, Your Honor.
Thank you, sir. Thank you.
Thank you, Your Honor.
Court does call the case of the People versus Jermaine Mazza.
Those are people.
Assistant Public Defender Natalie Pay on behalf of Mr. Mazza, who may be present via Zoom.
Yeah, we do. Hello.
Your Honor, I'm grabbing him now. This is
Okay.
worker at the hospital. We're just getting the door open, Your Honor.
Mr. Mazza?
Hello?
Hello. State your name, please, sir.
Jeremy Mesa.
Okay.
Thank you, Your Honor. I'm respectfully requesting an adjournment. I have had discussions with the people regarding this case, and I believe they have reached out to the officer in charge regarding a potential resolution. Mr. Meza is also currently hospitalized at Trinity Health and then expects to be released to treatment at Bear River when he is done at Trinity Health. The court and the people should be in receipt of that documentation from Trinity Health. So I'm asking for an adjournment if the court would consider around 3 weeks.
Yeah. Okay. Any objection from the people? Probable cause conference, June 26, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. All right. Thank you, Mr. Mesa. Good luck to you.
Thank you.
Court does call the case of the people versus Lanish Mitchell.
Student Attorney Kira Rosengren, under the supervision of APD Stephanie Cannon, on behalf of Ms. Mitchell, could you state your name for the court? Lanish Mitchell.
Do you feel a need to like ask permission again?
Well, I only thought I had to do it at the top of the
At
day,
one,
or-
right?
Yeah,
Yeah, so you were told that.
yes,
Your supervising attorney told you that. Because they knew, right?
yes.
Yeah. I wonder why that doesn't occur with you. All right, anyway, go ahead. Just thought I'd ask.
Your Honor. Thank you, Your Honor. We are going to be asking to hear this matter for discovery and further plea negotiations.
What other discovery you think is still pending?
Your Honor, and I'm making those right now into that. Your Honor, at this point, we are missing video discovery on this. Any and all photos collected at the scene.
But you're sending an email to try to get that rectified, whatever you think is missing.
Yes, yes.
She's making her intern do the hard work. June 17th, 2025, 9 a.m. That's a Tuesday. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Samuel Peoples.
Hey, Rachel McDuffie requesting permission to correct. Oh, I'm sorry.
Denied. Oh, you don't want to give that opening to me, Ms. Duffy.
Student Attorney Kara Rosengren, under the supervision of APD Stephanie Cannon, on behalf of Mr. Peoples, Your Honor,
You have no client.
Your Honor, yes, I have, we are requesting to adjourn, and I also have a letter from Trinity Health Hospital in Ann Arbor where Mr. Peoples is currently hospitalized.
No objection to the adjournment. I did want to advise the court and counsel. Somehow I have 7 unreviewed warrants for Mr. Peoples, and 4 of those just came in yesterday.
That sounds like a prosecutor's office. No, go ahead. What?
And, some of those might be duplicates. It appears that Mr. Peoples, when he was arrested on this count, made admissions to some of the other offenses that he knew that he was going to be accused of, because I did see some duplicate report content. So I will go through all of those and figure out what needs to be charged and what does not, but I just wanted to make everyone aware.
Oscar. You don't have a. He's gonna remain until medically cleared. All right. Or maybe give you time to do all those warrants. I'll adjourn this out to the 26th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus Taiwan Phelan.
And with others on behalf of Mr. Phelan.
Phelan.
Your Honor, we are asking hopefully for one last adjournment, so able to continue plea negotiations with the prosecutor's office.
Probable cause conference will be adjourned June 17th, 2025, 9 a.m. Bond continue.
Thank you.
All right, that's a Tuesday. Court does call the case of the People versus Kirby Snyder.
People. Good afternoon, Your Honor. Intern Malika Fatima appearing on behalf of Kirby Snyder.
So they actually let you do another case?
Yes, Your Honor.
He only gave you 2 things to do. Don't look at him, answer me. Is that what he did?
Yes, Your Honor.
So he's not treating you right, is he?
No, he's treating me amazing.
We're looking for some evidence to go against Brown. All right. All right, go ahead. What are we doing?
Your Honor, we are requesting a 1-week adjournment as Ms. Snyder had to go to urgent care today.
Do you have any medical documentation?
Yes, we do.
Oh, he has it, like he saved me. Have you seen that? Oh. we can go ahead. Okay. But what I'll do is I'll put it out to the 17th. Probable cause will be adjourned June 17th, 2025. 9 a.m. bond will continue.
Thank you, Your Honor.
He only did one other case and then he had half the information. Court calls the case People versus Matthew Vermaelen.
Alexander, on behalf of the people, Your Honor.
Good afternoon. Assistant Public Defender Lauren Perny on behalf of Mr. Vermeulen. Say your name for the record, please.
Matthew Vermaelen.
I have two things for you. I do have a green sheet. We are requesting an adjournment of the PCC. There is outstanding discovery. It's a 911 call we're waiting on. I have spoken with Ms. Zenda and it is on its way. We just have not received it yet.
Filed yesterday, so it should be to their office in the next day or two.
And the second, I'm taking a page out of Ms. Yagi's book, is a stipulation.
Yagi's book?
Didn't she get you an order?
Okay, so,
I thought that's what the call was.
oh, yeah, okay, yes, she did. I gave her a compliment. That she was doing better than the rest. You acted like I shouldn't have said that to another woman or something. I mean, I don't know what, you just got an attitude.
No, I was happy that you
No,
said it.
you
I was
got
happy.
happy
for her.
later. Your initial response was not that.
No, my shock was out of pleasure for her.
Alan, was that how she?
Don't you think? Well, Your Honor,
We got the video. I'll go back and play that anyway.
we have agreed to cease testing requirements on this case.
Yes, I see that and I've signed that over.
Okay.
Bring it back.
If I could also address bond.
Oh,
Yes.
yeah. Lots of
I
things.
believe last time we were here, the no contact order was removed. However, we've heard back from the victim and she is asking for it to be put back into place because after it was removed, she said the defendant tried to guilt trip her and make her feel bad about this whole case and told her to lock the windows at night in her house because that's how he got in. I have concerns, and she told him to stop contacting her and he did, which we are appreciative of, but at this time I would be asking that the no contact order be put back into place on this case.
Your Honor, I don't think that's how we would characterize any of those conversations. However, we have no objection to the no contact order being reinstated.
We will reinstate the no contact. Was there a no go to with that or?
I believe that was kept in place, Your Honor. For her, Your Honor.
So the no go to was always kept in place. It was just a no contact.
Correct.
Got it. Okay. I signed that order. And how much time did you?
I think it's, as Ms. Zenda said, it's on its way. It should be here in the next couple of days. Then just need to review it with my client. So I think the shortest.
June 17th, 2025. 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Roman Whitfield.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Roman Whitfield, who should be present via Zoom. Sir, can you please turn on your camera, unmute, and state your name for the court?
Where's one? That might be him. Mr. Whitfield? Oh, that might be. Is that him?
Yeah. Mr. Whitfield, can you state your name for the court?
Roman Whitfield.
All right. Okay.
Thank you, Your Honor. No, the court should be in receipt of a signed waiver form that Mr. Whitfield gave me permission to sign on his behalf. He will be waiving his right to preliminary examination today.
I don't have it yet, but that's okay. Mr. Whitfield, is that correct? That you're waiving your right to a preliminary exam?
Yes, sir. Yes, sir.
All right. You understand that that's a proceeding where the people have to show by probable cause that the offense, that those offenses were alleged, that the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over on both counts.
Thank you, Your Honor. We would waive any further formal readings. My client stands mute and asks for a pretrial date in circuit court.
If you waive formal reading standing mute as to both counts, court will enter not guilty plea. Pretrial will be set for
July 30th at 1:30 would just come.
July 30th, 2025, 1:30, Judge Conlon. Bond will continue. Thank you. Thank you, Mr. Whitfield.
Thank you, Your Honor.
Yes, sir. Have a blessed day.
Thank you, Mr. Whitfield.
Yes, ma'am. Have a blessed day.
You too.
Court does call the case of the people of the state of Michigan versus Taylor Adams.
National Line of People.
It's an arraignment.
It's not, Your Honor.
Your name, sir?
Taylor Adams.
All right. We are set for PCC. And where are we on this case?
My attorney is not here. He's sick, but he has the acceptance, so I was told to file for
Who's your attorney?
Nunzio.
Who?
Damian Nunzio, Nunzio. He has his acceptance. I told the one lady that came up to me earlier today that he was not here, and she said, okay, so, yep.
Oh, you're that one lady?
Yes, sorry.
That's okay.
So I'm looking now, it doesn't look like Jay has updated yet with an appearance from his.
It is, or it is not?
Said that he could call to show the acceptance. I don't know.
You want me to call him?
We could.
I'm a little busy.
I don't know. Whatever I need to do to let everyone know that he's supposed to be here. He was sick for the last 2 days.
Do you have any objection to me adjourning after the 17th?
I don't, Your Honor. I'm trying to see my notes if I have any concerns that I just bring out today, but I think that should be fine. Yeah,
Okay.
go to that.
Okay, tell your attorney a couple things. First of all, that we need an appearance, what's called an appearance from him, okay? And then the second thing is that I'm adjourning your probable cause conference to June 17th, that's a Tuesday, 2025, 9 a.m. It'd be 9 a.m., but if he gets his appearance in, he'll get the time block that he's in.
Okay.
And can communicate that to you. We'll continue.
Thank
All
you,
right,
sir.
thank you, sir.
Thank you, guys.
Where'd Perrini go? What? She's going to talk to you. Okay, all right, well, I won't worry about it. So, young man, how many times do I request that you ask permission per docket?
One time.
Got it?
Got it.
Wait, he's a quick learner. All right. She knew that. Didn't you? You knew that. I'm still trying to figure out why you didn't know. We all know it's the one standing right there. All right, court standing recess.
All right. 14-day district court county, Washington State of Michigan is now back in session. The honorable Judge Day Simpson. You may be seated.
Yeah, court does call the case of People versus Chloe Whitson.
Andrew Childers appearing on behalf of people.
Good morning, Your Honor. Kia Hickman. I'm sorry, good afternoon, Your Honor. Kia Hickman on behalf of Ms. Chloe Whitsett. Ms. Whitsett, please state your name for the record. Chloe Whitsett.
How are you, Ms. Whitson?
I'm good, Your Honor. Thank you. How are you?
I'm doing well. All right. What are we doing? You're gonna yell, aren't you?
No, I didn't.
Okay, I'm just
earlier.
kidding. I just have to prepare myself.
I believe today if it's allowed, we'd be doing the plea and immediate sentencing. Ask you to be admitted completely into sobriety court next week. We were here to see if the judge is going to allow you to sentence.
Did we make contact? I don't think it works that way.
So
Go ahead.
the court will know more than I, but I'm just trying to recap. So my understanding is we received the forms from 36th District Court regarding Ms. Whitsett and the which would enable would enable the transfer of the case to 36th District Court after he has been taken for sentencing.
Correct, but I think they have to do the transfer. So our problem at PEs said this is a 15th District Court case. And so I would believe that Judge Bravo is the chief of 15th has to sign off on that for the transfer.
Would it make sense if because ultimately what the plea was going to be would be to counts 4 and 5, which are on the complaint before Your Honor, which are 2 misdemeanors. Would it make sense for us to dismiss counts 1, 2, 3 and remand counts 4 and 5 to the 15th District Court? That way it's there and it can happen.
And Your Honor, she did sign that documentation. Judge Valvo signed that and we sent that to 36th District Court. Ms. Whitsett has appeared at 36th District Court with the mental health portion, and they've been doing the onboarding intake process. It's just next week is when she's supposed to be officially admitted into that mental health court.
So bizarre.
It is.
What is this a Valvo case or so?
It's his number and what was the charge, I'm sorry.
is felonious assault. No,
Yeah, it is.
I'm sorry, assault and battery. And whatever, 5. Okay, what do you need that one? Okay. What do you have as fellow sentencing?
It would be July 1st.
So, but she signed off on the paperwork to 36.
Yes, Your Honor. I can email this court a copy of that.
So who? But what did she signed off as the chief judge of,
One moment, Your Honor.
because there's going to be the referring court, there's going to be the chief judge of the court.
If Ms. Whitsett were to plead today, and we follow the sentencing date as given by Ms. Fiedling of July 1st, to set it for that date, would 15th know what to do with it? Yeah, I remember the form, and I saw the forms as well. Judge Balbo did, and I said.
As what?
She signed off as chief judge,
Okay,
and you did assign.
I signed it,
Yes, you did assign judge, and she signed off as chief judge.
so I don't know why I couldn't go right over.
Do the police account 4 and 5 now.
Okay.
Get the date given us by Ms. Fiedling, and Ms. Whitsett's attorney contacts 15 and said the police better enter if the judge has signed off. That, to me, as fast as we can hope.
I think you're probably right. I think if I remand it down, it's probably gonna be more of a delay. So if I take the plea now,
Okay.
all right. So she's gonna plead the stated counts 4 and 5.
4 and 5, yes, sir.
2 counts of assault and battery. Yeah, ever sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Chloe Whitsett.
So what's that? It's this court's understanding that you are going to be pleading guilty to 2 charges of assault and or assault and battery. Is that
Yes, Your
correct?
Honor.
Those are misdemeanors, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You understand, and I guess technically I have to say this, I would not be your sentencing judge in this case, and you would either be sentenced in a 36th district court or the 15th district court. You understand that?
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty
Yes, I do.
to the charge of assault and or assault and battery as contained in count 4. How do you plead?
Guilty, Your Honor.
To that same charge as contained in count 5? How do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You haven't signed an advice of rights form, but because of that, you do understand that you're giving up certain rights. You're giving up your right to call witnesses to speak for your trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that, ma'am?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what?
No.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, Your Honor.
of your own free will. And because you believe that you're guilty of these offenses.
Yes.
On the date of March 13, 2024, location of Packard and Platte Road, what'd you do involving Robert Bloch and Adrian Vasquez that makes you think that you're guilty of these charges?
After I ran into the back of their car, I had a terrible case of road rage. So I didn't physically touch them, but I kind of lost it in the
You were
street.
yelling at them?
Yes.
Okay. And the manner in which you were yelling and what you were doing, would it have led a reasonable person to believe that you would assault them or could?
Yes, Your Honor, probably.
It would have put them in reasonable apprehension that you would have done something violent to them.
Yes.
Okay. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant plea?
The court has applied the court rule, and the people are satisfied with the defendant.
Satisfy, Your Honor.
Court will accept the defendant's plea guilty to counts 4 and 5, counts 1, 2, and 3 are dismissed. I will just do the referral to probation. I'll do everything technically as we do it, and we'll get it straightened out. Sentencing in this matter,
July 1st at 9 a.m. with Judge Bell.
would that be my in custody also?
It is.
Okay. July 1st, 2025. 9 AM, and hopefully we can get that all straight through Judge Balboa's office and they can ship it on its way.
I will put on the record that I communicated this with Ms. Hickman. There is a restitution amount of $674 I expect to be requested. I don't want that to get lost in the show.
$674. All right.
We're so sad. We're not gonna see you anymore.
Been a long journey for us, hasn't it?
Yes, Your Honor, it has been a long journey.
And the first time you met and you were just getting angry with me, I didn't know why. Right? It's okay. I bet you would never think as it came down the road that I would say, I'm gonna miss you.
No, in the beginning, but I can say the same thing, Your Honor. I appreciate your graciousness. You've been so kind to us and we thank you. And your court, thank you very much.
And the people.
And the people.
We just had to get you through some things. And your attorneys have done a wonderful job trying to get you into this program.
Yes, they have.
I just have great faith that it's all gonna work out.
All
right.
Thank you so much.
All right. You guys take care. Ms. Hickman, it has been a pleasure, even though you were yelling at me half the time. All right, take care. Court does call the case of People versus Jamari Bagwell.
If you were to make the people for the people,
Afternoon, Edward Lucas on behalf of the defendant. I'm standing in for the attorney of record, Kyle Burdell.
Okay. And is your client here?
I understand that there's been no contact at this time.
There has not been.
There has not been.
Bagwell. Okay. Bench warrant relation for defendant's failure to appear. There is a community corrections, also a violation. But council's aware. Bond is setting amount of $25,000. Cash surety. Warrant will issue immediately. Thank you. Court does call the case of People versus James Belleville.
Claire Love, requesting permission to practice pursuant to the Ocean Court under the supervision of Assistant Prosecuting Attorney Alexander.
Good afternoon, Ms. Lowe.
Good afternoon, Your Honor. Edward Lucas on behalf of James Belleville. There's actually a better explanation in this case. The court was making aware, again, there was a medical issue that we are dealing with.
Is there documentation?
At this time, no, but I have been in communication with his mother. I can get additional updated information, but he was undergoing surgery and had just been transferred. So I'd be asking for 4 weeks. There may be some movement by that time.
Any objection from the people regarding that?
No objection.
I'll adjourn the probable cause to July 10th, 2025, 9 AM. Bond will continue.
Thank you.
Court does call the case, Reeve versus Clifford Gordon.
Edward Lucas for Clifford Gordon.
Your name, sir?
Clifford Gordon.
Thank you.
I got a client this time here.
Yes.
At this time, but there's been some negotiation and we could certainly approach if the court would like to know more. I know we are close, but there's some things that we needed to look into in order to try and resolve this case.
You're close, but you need to.
We need a little bit more time.
All right. How much more time you guys gonna need?
2 to 3 weeks, whatever the court would provide there.
Hearing no objection from the people, I'll adjourn probable cause conference 26, 2025, 9 AM or your invite indicates. All right. Bond will continue. Thank you, sir. Court calls case People versus Julius Holston.
if you were to make the people for the people.
Edward Drukas for Julius Holston, who was approaching Your Honor. Yes, Your Honor.
Your name, sir?
Julius Holston. Your Honor, at this time, I'm asking for an adjournment. The prosecutor is looking into some information and that may or may not yield an offer. But at this time, we want to keep that window open. And so we'd be asking for an adjournment.
The probable cause will be heard June 17th, 2025, 9 AM. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Brandon Clement.
Good afternoon, Your Honor. William Amadeo, P7619, for Mr. Clement, who will be staying to my right. Brandon, please state your name for the court to know it is you.
Brandon Clement. All right, very good. Thank you.
Your Honor, we're just waiving up the circuit court if there's no objection from the people.
Sir, is that correct? You're waiving your right to preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and you committed.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on the one count.
Matter will waive a formal reading, stand mute, and ask for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 24th at 1:30 with Judge Slay.
July 24th, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond will continue. Thank you.
Take care, sir. Thank you.
Courthouse days, people versus Quanda Hall.
Good afternoon, Your Honor. David Canine for defendant. My client should be present on Zoom, Your Honor.
I'm here.
Okay, you need to turn on camera, ma'am. Oh, there you are. Okay, we got you. All right, state your name, please.
Shaquanda Hall.
There we go. All right, what are we doing?
Your Honor, I have all the discovery that I need, so I was going to request a preliminary examination date, please.
People have their witnesses available the 17th? All right. Preliminary examination in person will be set June 17th, 2025. Set
9 a.m. with Judge Moore.
9 a.m. before Judge Moore.
Your Honor, one quick question. My client currently resides in California. Does she need to be present in person?
Yes, she does.
Okay, understood.
All right, thank you.
Thank you.
Court does call the case, People versus Alexander Sanchez Garcia.
Morning, Your Honor. Good afternoon. Nicholas Monterez on behalf of Alexander Sanchez Garcia, who is present via Zoom. Mr. Sanchez Garcia, can you please state your name for the record?
Alexander Sanchez Garcia.
Very good. All right, what are we doing today?
Your Honor, time and date for a probable cause conference. I did communicate with APA Jacob Kennedy regarding this matter. We're looking to waive 21 days. Statutory right has been explained to Mr. Sanchez Garcia, and we're hoping that the court will reset this for another PCC. And I'm asking for 45 days, Your Honor. I'm asking for a little bit more time at this point. I do not have discovery in this matter. These are very serious allegations, and I anticipate there may be the need to subpoena medical records at some point. So I'm hoping to give us enough time to get that done before we come back before this court.
Any objection from the people? Rather lengthy objection or adjournment. Probable cause conference will be adjourned to July 17th, 2025, 9 a.m. or as your invite indicates. Bond with its conditions will continue.
I appreciate your time, Your Honor. Thank you.
Thank you. Court calls case, People versus James Chandler.
Good morning, Your Honor. If it pleases honorable court, Brandon Bird on behalf of James Chandler. Mr. Chandler, can you please state your full name for the record? James Chandler.
All right, what are we doing?
We're just asking to adjourn this matter a couple weeks, Your Honor. Sort out some discovery issues.
Any objection from the people? Probable cause conference will be adjourned June 17th, 2025. 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor. You and Your Honorable Court, have a great day.
Court calls case, People versus Cheryl Andrasic.
Alexander on behalf of the people, Your Honor.
Attorney Martin McManus on behalf of Cheryl Andrzejczyk. State your name.
My name is Cheryl May Andrzejczyk.
Thank you. All right, what are we doing today?
Thank you very much, Your Honor. There has been a plea offer. We'd like to accept it, but set it down for a new date for that plea. My client is with her caseworker here with me, and she's not quite on her full medication right now, so I believe I just need a different date for that.
And that's correct, Your Honor. The offer, I believe, was to plead to counts 3 and 4, was sentencing under 4A. So I'm
Got it. All right. Let's do this. If they're trying to get medication out of their stat, let's probable cause conference will be adjourned to June 26, 2025. 9 a.m. as your invite indicates.
Okay.
All
Thank you
right.
very much, Your Honor. Yes.
Thank you. Bond continued.
Thank you very much, Your Honor.
Thank you. Court calls case, People versus Jack Ritchie.
Good afternoon, Your Honor. For the record, Attorney Russ Donaldson, P number 53660, here on behalf of Mr. Ritchie. Your Honor, we had agreed to proceed by Zoom technology and waive a right to an in-person hearing. Mr. Ritchie, will you identify yourself?
Yep, my name is Jack Ritchie.
Very good. All right, what are we doing?
Your Honor, there's still some outstanding discovery issues. I know that I've been in communication, or my office has been in communication with Ms. Willenbring. I'm not sure if she was able to access some of the video discovery or not. That's where I think we had left it at this point. I would be asking for an adjournment. We've already waived the 21 days. I would ask for June 26th, Your Honor.
Your Honor, as far as I.
What happens to attorneys that ask for their dates?
Am I
Typically don't get
violating
them.
some?
Oh,
I'm
yeah.
sorry, Your Honor.
It's an unspoken rule, but one that really irritates me. So you're in good shape, counsel. You've already irritated me. It's been 5 minutes. No, you're good. Don't worry about it. Go ahead, Ms. Willingby.
Your Honor, I don't think there was an issue with the video. I think there was one forensic download of an item that was done and was uploaded to evidence.com. And my understanding was that Mr. Donaldson's office couldn't open that.
Got it.
I did try it this morning, but I haven't tried to actually open the materials. I emailed the detective to see if it could be put in some other kind of format. But for the record, my understanding was that there was nothing relevant on that device, but I will certainly work to see if the detective can get it in a
Format that will. All right. All right. I'll adjourn the probable cause conference. I'll give him the date, June 26, 2025.
Your Honor,
9 a.m. or as your invite indicates.
Your
All
Honor,
right.
I don't want to irritate you anymore. I didn't know if we could perhaps, and I don't want it to be taken out of my client by no stretch. I didn't know if we could address the issue of bond or if the court would want me to file.
No, we can address the issue about it. That's fine, counsel.
Okay, thank you, Your Honor. Currently, my client is on a house arrest with a tether, and the court has been gracious enough to allow him to be able to go to counseling as well, to do in person, as well as to do some counseling group sessions via Zoom with a specific time. The court entered an order last time we were here. I would ask the court to, and I understand the court's concerns relative to access to the internet, and what I would like to ask the court to do is to allow a limited supervised access to emails for his therapist, as well as communication with me as his attorney via emails. He does live with his mother and father. They are present behind my client, right behind my client right now. There are, my understanding, like homework assignments, and there's some communication between the therapists that need to be communicated. And I would ask that for limited purposes that, and the computer that would be using is password protected. He doesn't have access to anything right now. If the court were to allow that, then it would be monitored by either his mother or father, specifically and solely for those purposes. And he's also, Your Honor, trying his job prior to being involved with the criminal judicial system was a freelance writer, which required him to do research and so forth on the internet. We know that the court's not going to allow that. We're not asking for that. He is trying to find viable alternative employment. His mom has been doing some work trying to get some information, but a lot of the job openings are done via internet online applications. So far, Stonebridge Golf Club, Lake Forest Golf Club, there's the Davy Tree Expert, Home Depot, Lowe's. All of these different companies require at least a preliminarily online application process. Again, I would be asking the court with limited supervision to be allowed to fill out those applications and to do that process, so that way he can obtain gainful employment that would not compromise the court's concerns about internet access. But we would need some limited access, and then assuming he were able to get an interview, to be allowed to go to those interviews and perhaps get the job.
So let me just, if I were to categorize this, you're looking for access to employment applications as well as emails from the email communications between attorneys, and also email regarding his therapist. I thought we had therapists covered.
We didn't have emails, Your Honor. We have therapists covered by way of either direct. It was just he was able to do Zoom meetings, but my understanding is that there's homework assignments that have to be, I don't want to say graded, but that there's some communication with different things as part of his therapy that is conducive to obviously to this case as well, but that I believe is essential in order to have the therapeutic process work in the way it was supposed to work. And we understand we understand the limits, Your Honor. We understand that if the court were to allow for those things, that again, they would be supervised by my client's mother and father, who would be in the court or would be in the room, would be able to punch in the code to have access to the computer, and would be there monitoring it to make sure that there was no any kind of outside communication relative to those emails.
Your Honor, I understand the request, and I understand that no internet usage provision is certainly challenging in this day and age, but I am going to object to a change. I already did agree that he could go to in-person therapy or use a computer to go to therapy, which I think is great, but I also had my concerns about. I think that we're just more and more expanding the scope of how he can use the internet, and that's the basis of these charges is use of the internet in pursuit of sexual gratification from a minor. So while I can appreciate that his parents would watch over him, there is no way for us to verify that that is being done, that nothing inappropriate is being accessed. So I just don't feel comfortable agreeing to those terms, and I am going to object to this.
I guess one question I have is regarding like the emails. Certainly those could be pulled off somehow so that those communications can take place, and something has to be sent back, then somebody can type the email and send it back. I mean, I guess there's ways around that part of it, particularly maybe communications from the attorney and even communications from the therapist. The part that I a little bit, I guess confused on or maybe don't understand is you said there's like homework or certain things that need to be done. I'm a little bit worried about how if I send you something and you've got to do homework, are you supposed to send it back to me right away? Is it sort of this almost interactive kind of thing that's going on via email? I just don't, I'm not sure I understand the full.
Your Honor, I can't profess to know the complete parameters of it, but I guess there's two things. One is to have confidential communications, especially with me as his attorney. There's sensitive stuff because of the charges that are involved that I don't want his parents or anyone else for that matter.
Right.
Same thing with the therapy, Your Honor, is that we don't want mom or dad to be part of that process until it's appropriate under a therapeutic setting, if that's what it ends up being. My understanding is that there's some things that my client would have to fill out and then would send to the therapist, and then they would discuss it. I could defer to Mr. Ritchie. We haven't started that process yet because we wanted to make sure that we were following the court's parameters with that. But we could limit it in such a fashion when it wouldn't be back and forth. It would be, it would be something that the communications could actually, I guess I could possibly facilitate some of that. And I don't believe it's going to be a lot, Your Honor. I don't believe there would be a substantial back and forth. I did get some additional discovery. It's about probably 70, 80 pages that I need to get to my client. It's the easiest way to do it. That would be to email it and to be able to communicate with him and talk with him about those things. So I would hope the court would at least allow for that. But I believe for the therapeutic point, just limited emails with the therapist, I think would be appropriate and just, and that would be something that could be monitored however the court would want to fashion that.
So what about email communication from his attorney?
And how I envision this would work, Your Honor, is that I would call my client or call his mother or father and say, I have an email that I've sent. Will you allow him to access it? And that way he can look at it privately from my standpoint. And we can do the same thing with the therapist, that if there's an email sent, we could fashion an order that if an email is sent, that a phone call would happen prior to that to acknowledge it. And then it would be just a matter of being able to get it and print it out and respond.
Under those two circumstances, what I'm going to do is I'm going to allow it. However, not that I'm necessarily going to want to see it, but I'd want a log of those communications. So I'd want a log of, for example, when the phone call came, when the email was sent, and when the defendant accessed the email.
We can definitely do that, Your Honor. I'll make sure that and I could fashion that in an order. Log for times, phone calls, access, and response. So it would be, okay. Thank you, Your Honor, for that. As it relates to the.
And you'll prepare an order and send it forth. I understand that people won't necessarily, but they can approve it as the form. But if you get that over to the court.
As it relates to my request relative to the employment online applications.
I'm going to deny that request. That one is a little bit too broad for me right now. Doesn't mean I won't entertain it on the 26th, but
fair enough. And Your Honor, what I'll make sure that we'll present those logs by the 26th, just so the court can see and get comfortable with what the parameters are after I prepare the order and get the court's approval then.
Wonderful. All right, great. So at this time, I'll have mine continued and then I'll look at the ordering.
Thank you, Your Honor.
All right. Thank you.
Are we free to leave, Your Honor?
Yes, you are.
Thank you.
Thank you. Court does call the case of the people versus Ricky Parvin.
Good afternoon, Your Honor. Jennifer Winstead. I'm appearing on behalf of Ricky Parvin, who is present and standing to my right.
Your name, sir?
Ricky Pardo.
All right. I have a plea form. Is that what we're doing today?
That's right.
The plea form indicates that the defendant would be pleading guilty to the charge of assault and or assault battery. The 93-day offense. Upon a successful plea to that charge, count one would be dismissed. And it's okay to seek the prosecutor's deferred. That is the full understanding, the court's full understanding of the agreement.
Yes.
Correct. Very good. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Ricky Pardo.
All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of assault and or assault battery. Is that correct?
Yes, yes, Your
That's a
Honor.
misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour at the 1483 District Court.
Yes.
All right. And understanding all of that, sir, there was that charge. How do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
I do.
You signed an advice of rights form today. Is that correct?
Yes. Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Attached to the podium. Please look at paragraph 5. Those are the rights that are part of the trial. Oh, need glasses. All right. Okay. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
I do.
You understand you're giving up your right to appeal of right?
I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
I am.
of your own free will
I am.
because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
October 7th, 2024, at the location of US 23 near 6 Mile in Northfield Township, Washtenaw County, state of Michigan. What do you do involving a John Purdue that makes you think that you're guilty?
We had some back and forth road rage. And
Back and forth road rage. All right, you guys are going down the road.
yes.
What happened?
Hard to explain it. It just, two people got out of hand and
Okay, well, what makes you think that you either assaulted him or committed the offense?
basically the tapping of the brakes and flipping him off.
All right, so both of you are in your vehicles.
Yes.
And there's a tapping of the brakes. So what'd you do? Just tell me what you did.
I don't even know
Did
how
you
to
display a weapon?
I did not. There was never no weapon, just a finger.
Did you do something with your car that would make him think that some injury or that he would be assaulted in some way with your vehicle?
Yes, Your Honor.
Okay, what do you do that makes
Tap the brakes.
you say tap the brakes? You were in front?
Yes.
Okay, and so you're both headed at the same time and you're hitting the brakes, attempting to intimidate him that he may rear end you or cause some damage or injury to himself.
Correct.
And you would think, or would you think by you doing that, that he would be in reasonable apprehension of some injury to himself based upon your
I do.
A long tortured way to get there, but also have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes. Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Get my form here. Sentencing in this matter will be
14th at 9 a.m.
July 14th, 2025 to 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue.
Thank you.
And court does call the case, People versus Darian Cut.
On behalf of people, Your Honor.
Good afternoon, Your Honor. Bernie Kizzy here on behalf of Gary Cotton, who is approaching to my left.
Oh, switch phone. Sorry.
And then Darian Cotton, Your Honor.
All right. All right, I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of possession of a firearm in a motor vehicle, the attempt, the 1-year offense. And upon his successful plea to that charge, count 1 would be dismissed. There is an indication of okay to seek HIDA. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Is that correct, Mr.?
Yes, Your Honor.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, nothing but the truth, so help you God?
I do.
State your name.
Darian Carter.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of possession of attempted possession of a firearm in a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration, $1,250 fine plus court cost, and mandatory forfeiture of the weapon or device. You understand that?
Sir.
And understanding that, I should also advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, sir.
And understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form today?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to state?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you're indeed guilty of this offense?
Yes, sir.
March 21st, 2025, at the location of Hay Street and Ecorse Road, Ypsilanti Township, Washington County, State of Michigan. Were you in a motor vehicle?
Yes, sir.
And did you have possession of a weapon?
Yes, sir.
Where was it located?
In a bag,
In a bag?
like behind the seat,
Is that a bag behind the driver's or passenger seat?
behind the passenger seat.
Okay, and were you driver or passenger?
I was passenger.
You were a passenger, so it was behind the seat. You knew it was there?
Yes, sir.
And was it your weapon?
Yes, sir.
And did you have any authority to carry that weapon in that fashion?
No, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Just one question, Mr. Connick, that to your knowledge, was that weapon loaded
I wasn't sure.
later? Did you
Yeah, I watched the video. I seen it.
satisfy your?
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be July 17, 2025, 10 a.m.
I'm sorry, I have a trial that week.
for Judge Washington. What you can do is you can contact the court. They'll
Okay,
work with you to move it. Okay, that's the only date we get. So,
that was 14B, Your Honor.
yes, sir.
Thank you.
All right. Thank you, Your Honor.
Bond will continue. Thank you.
Thank you, Your Honor. I'll be right down. Have a good day, Your Honor.
All right,
See you
you
in a
do
sec.
the same. That's it. 14A. End the chair.
I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases.